So very good morning to all the CA Inter students who are writing the examinations for the Jan 2026 CA Inter exams, and uh, this is a very good moment that ICI Vijayawada, the SICASA, is conducting this session regarding a marathon revision for one of the toughest subjects in Group 1 of CA Intermediate, which is the corporate and other laws. And a big congratulations to all the team of SICASA for ICI Vijayawada branch for taking initiative to do some good thing to the students by bringing a qualitative marathon such that they will be definitely clearing in the coming Jan 26 examinations. And my heartfelt thanks to all the members of ICI Vijayawada branch as well for making this to happen. So let us first begin with our session regarding the corporate and other laws. What are all the topics we are going to discuss, and what you can expect in this 3-day session from this particular session on corporate and other laws as a marathon. So let me first write it down and show you what are all the core contents that are going to be discussed in this particular marathon for 3 days. So you can see here, so this is a marathon revision on corporate and other laws, which will be accounting for a full length 100 marks of your paper. So how we are going to break our 3-day session? Let me first explain. If required, we can take an extra session also, that's not a problem. So number 1, we are going to first take up company law in 3 parts. Okay, because company law or corporate law for the case will come for substantial 70 marks of your paper, and 70 marks of your paper accounts for a good amount of difficulty as well, because in the light of the latest examination that was already completed, September 26, which is a blast from the ICA, wherein question papers came extremely tough, especially when it comes to the paper called as law, because they stopped asking. ICA has brought a new trend. Actually, I call it as a very good trend of asking questions on a comprehensive basis. Means they stopped asking a direct question. Instead of asking what do you mean by a deposit, they are asking a comprehensive question and asking whether it is a deposit or not, which is a nice gesture from the ICA to test the skill and ability of the student, whether he is able to understand the concepts well in tune with the ICA or not. So therefore, as per the ICA expectation, we have to prepare. And there is no question of any expected questions here in this marathon. No top 100 questions, top 50 questions. Because if top 50 questions, one question also do not come, what will be the situation? So here, this marathon is not about expected questions. This is not about top 100, top 50, ABC analysis. No, this will be a full-fledged marathon on our syllabus. What ICA want us to study, on that we are going to have a marathon now. Okay, I'm not going to just discuss about only those expected areas. No, so we are going to discuss all the things in detail in this particular marathon. Okay, so I will try to cover as much as possible in this, such that your 60 to 65 marks or 70 marks will be coming from this marathon directly. That guarantee I can give. Means syllabus coverage, I will be making 70% of your syllabus coverage. Means after these 3 days of marathon, your work is to study and apply your mind only on the balance part. Clear or not? What we cover in 80 days, 70 days, okay, we have to cover that in 3 days. Means it will be little bit faster, and I won't repeat it multiple number of times as well. Clear, everyone? Everyone clear? Shall we begin? Yeah. So we are going to divide the total subject, whatever we are going to discuss, in 3 parts. Part 1. I am going to cover areas which include preliminaries, incorporation, prospectus, preliminaries, incorporation, prospectus. Okay, and I will, if possible, if time permits us to do so, then I will be giving you the introduction to the concept of interpretation of statutes. Okay, we are going to cover interpretation of statutes. See here, preliminary incorporation and prospectus and IOS. If not, preliminaries and incorporation and prospectus. These all areas will cover 12 to 15 marks in examination. So target is, first we need to complete these 3 areas in this particular session today, because it will take time, big chapters there. Okay, but when it comes to deposits, charges, dividends, debentures, along with that there is one small part called as a, okay, small part we will discuss, audit, auditors. These all we can complete in one session. These are small areas. These are big areas. So big areas we need to spend some time. Small areas we can complete it as soon as possible. Okay. Today I will cover these 300%. Fourth one, if possible, I will give the introduction such that IOS will come for 10 marks in examination. How many marks here? 10 marks. So 10 marks IOS we will complete. Next session, our target areas are interpretation of statutes. Okay, interpretation of statutes, FEMA, LLP Act. Why these 3? Take any examination of ICI. Any, when I say any, literally any. Any examination of ICI you take. These 3 areas, interpretation of statutes, FEMA and LLP, each come for 10 marks. FEMA come for 14 marks. LLP come for 12 marks. 12, 14, 26, 36 marks we are going to cover in this area. Okay, which one? Interpretation of statutes, FEMA and LLP Act. All these 3 will come for 36 marks in examination. Okay, so you imagine substantial part of your marks are combined in these 3 areas. Okay, after this, general meetings. Okay, general meetings, share capital, accounts of company. Do you know what is the weightage of these 3 chapters in exam? Average 10 marks. Average 10 marks. General meeting will come for 10. Share capital will come for 10. Accounts will come for 10. This will cover how many marks? 30 marks in your examination. This will cover 36 marks in your examination. Okay. So, and this will be covering around 12 marks in your examination. So, here itself the substantial core areas are covered now. That's what I wanted to tell. Okay. So, I'm again repeating your main core. I will show you one document. Maybe after that you will get convinced whether I said whatever I said is right or not. Past trend of ICI I will show you, such that you will understand. First, you will be convinced on what is this concept all about. Just give me 1 minute time. Wait, it will come. See the screen once. First of all, everyone participating live, please give a reply. Are you all clear up to here? Everyone. Yeah. See the screen. If you observe the trend analysis of ICA on the chapters, you can observe this way. See here. 3 chapters I will point out. Share capital, general meetings, accounts of company. You can observe these 3 areas. Whenever you wanted to understand the trend of ICA, don't go back for n number of attempts. Go back 5 attempts, immediate 5. Then you will understand the realistic trend. Okay, means when I say go back to these 5. Share capital 10, 15, 12, 7, 6, 12. 12, 13, 10, 10, 6, 17. Last attempt, September 25, you can see there. Okay. Accounts of company, you see the trend. 12, 10, 8, 13, 10, 15. Directly. See the 15 marks last attempt. That paper difficult. Why difficult? Because no one's ABC analysis, this is in A category. Student left it. They gave for 15 marks. Attempt by. So, this is the first one. LLP, you see. 10, 16, 12, 14, 12. And on an average, 12 marks they are giving. Next, if you observe the next one, FEMA, 14, 14, 14, 14, 14. Average, they are continuing with 14. Okay, sir, only 12.8 is the average of all. Okay, if you take a realistic average, it will be 14 marks coming from FEMA. So, 14 marks FEMA, 12 marks LLP, 10 marks IOS. And if you prepare those chapters, share capital, general meetings, all these, in a proper sequence, in a proper strategy, if you go, you will get miraculous result. Okay, now doubt will come to the student. Sir, as per your logic, general meeting, share capital, IOS, FEMA, LLP, all these are carrying 10 marks on an average. Right, sir? Then you should start first with that, sir. Why you are starting with Prospectus and Incorporation? That's the next question that you will get. I have answer for every question that you make. Shall I tell you what is the reason for this? The reason is, see, false trend. Which trend here? False trend. Means what? I will show you what is a false trend. See, share capital chapter. Share capital chapter came for 13. Immediately trend will start in the market. Share capital, if you prepare, 15 marks will come. Immediately they made it 7. Only one attempt it happened like that. Again they will give for 15 marks. Prepare share capital only. It gave for 5 marks. Next again 8. Oh, then share capital is not that important. Nah? Again they will increase the trend. Oh, share capital is really important. Next attempt they gave for 3 marks. I think that's the point. Like that, when the trend is on a going increasing trend, suddenly they will give for 7 marks, 6 marks. So, whatever the trend I said now, for example, I will give you an example here. 12, 10, 8, 13, 10, 15. Correct? Last attempt, dividends not given. Before last attempt also, dividends not given. Then what student will think? Dividends chapter, let us leave. Next chapter, dividends will come for 12 marks. Attempt by. Second, I will give you another classic example for this. Registration of charges, you observe. 4 marks, 5 marks, 5 marks. Oh, registration of charges, prepare. There are only 8, 9 important sections. If you prepare that, one question will come. Next attempt, 1 mark. Next attempt, they did not give. Next attempt, 5. Next attempt, they did not give. Waste chapter. They gave for 15 marks. Attempt by. Okay. Oh, 15 marks. Registration of charges, you prepare. If you don't prepare, you will die. Last attempt question is not there. With this trend, if you go, next attempt registration charges will come for another 8 marks. Malli attempt by. Avasarama idantha needed your action. better you prepare everything. Okay. So therefore what happened? See, incorporation chapter, the danger I will tell you. It came for 4, 5, 11, 7, 10, 3, 6, 5. After that 4 attempts, question is not given from this chapter. They left, they gave for 7 marks. They gave for 5. Last attempt it came for 2. If my estimate is not wrong, next attempt 15 marks will come from incorporation area. Same happens also with the prospectus this time. So these two are in hit list for Jan examination. Okay, when I say hit list, what is the hit list? When you go by trend, they are least important. But when it comes to I say, that is most important. Did you all understand the concept? Everyone? Did you all understand what I said? So that's the idea here first. So you need to understand why we are first starting with this. The reason why we are starting with this incorporation and prospectus is they are in hit list this attempt. Okay, red alert, these 2 chapters were there. And red alert, another chapter is preliminaries also this time. Sir, preliminaries means what they will ask, sir. I will show you today what they will ask. Okay, preliminaries what they will ask, I will show you. Okay, so preliminaries, why danger is there na? Suddenly, like a windfall, 12 marks, one attempt 14 marks also came from this. Anyayam, student will go out. So therefore, first target number 1, preliminary, incorporation, prospectus. Then I will go into IOS. Are you understanding, everyone? Clarity? Let's begin. So this attempt, let's not give a chance for ICA to fail us. We should get 60 plus means target for that 60 plus you'll definitely get if you understand the marathon concepts clearly. Okay, let us begin. Okay, first point number 1. What is the first chapter? So marathon chapter 1 that we are going to begin is Preliminaries on Companies Act. What are Preliminaries on Companies Act? We are going to discuss about definitions in Companies Act. What definitions we are going to discuss? What is a company? What is a private company? What is a public company? One person company, holding company, subsidiary company, associate company, small company, okay, small company, foreign company, government company, listed company, unlisted company. That's it. Mainly, these are the important types of companies we are going to discuss. Okay, 14 marks one attempt a question came na. That attempt private company, small company, and listed company, subsidiary company. 4 questions came in question paper. 2 questions came in the form of MCQ. 1 mark MCQ, 2 questions came. 2 marks. Along with that, they tested questions also on the 3 questions of 4 marks each in descriptive part. That's how 14 marks came in that examination. Okay, let us now first complete the chapter called as Preliminaries to the Companies Act. Okay, you can see here. Whatever the book you follow, you can follow. Just I will cover through charts because it will be faster when you complete it. Okay, it will speed up your process of learning. First one. Point number 1. What is the first concept? Short title, extent, commencement and application of the act. Short title. What is the name of this particular act? Companies Act. Application, whole of India. When it commences, 38/2013 it started. All sections did not come to applicability on same date. Different sections applied on different dates. 470 sections are there in Companies Act. All 470 sections did not come to applicability on one single day. They spread across different times. 2018, 2019 also some sections came in Companies Act. Means what? 1956 and 2013 parallelly ran till 2018, 2019 also. Okay, different dates are notified by CG in official gazette. Okay, next important things. Application of this act. To whom Companies Act will apply? Companies Act will apply not just to companies. Companies Act will apply to companies under Companies Act, companies not under Companies Act also. When it is companies under Companies Act, fully applicable. When it is a company but not a company under Companies Act, limited applicability is given. So therefore, what is the application of this act? Company under Companies Act, it is applicable. Company under Companies Act, it is applicable. Second, company under previous company law. 1956 my company is incorporated, not under 2013. For them also Companies Act is only applicable. Companies Act is applicable also to banking company, insurance company, electricity company, except in case of inconsistency. What does it mean? For example, Banking Regulation Act, if you observe clearly, appointment of auditors in a banking company. Appointment of auditors in a banking company. If, for example, if there is a bank, auditors has to be appointed. Appointment of auditors in a banking company, how to appoint them, how to do audit of a bank, how to remove them, everything was given in the Banking Regulation Act itself. Now, Companies Act is applicable to bank means, I will ask a question. Companies Act, there is a chapter called as Chapter 10 Auditors. Their auditors appointment is covered. Now, Banking Regulation Act also, auditors appointment is covered. But both the cases, it's not same. Auditor's appointment in a bank is different. Auditor's appointment in companies other than bank is different. Now, Companies Act and Banking Regulation Act, when they clash together, there is an inconsistency. Here, auditor is appointed normally. Here, RBI will appoint. Okay. Therefore, there is a contradiction between Companies Act and Banking Regulation Act. In this case, Banking Act will prevail over Companies Act in case of banks. So, for bank, who is the most important one? Banking Regulation Act. So, the provisions of Banking Regulation Act will override provisions of Companies Act. So, Companies Act will apply to bank or will not apply? Will apply. Till when it is applicable? As far as there is no inconsistency, Companies Act is applicable for Banking Act, banks also. However, if there is a specific provision written for the bank separately, which is different from that of Companies Act, that Banking Act only should prevail over. Same applicable for insurance as well as for the electricity type of companies. Okay, done. First of all, everyone please answer. Did you understand up to here clearly? Stage by stage I will ask you. Once you are clear to the concept, I will go into the next one. Done. Next segment. So Companies Act is applicable to whom? Companies under Companies Act 2013, companies under previous company law, banking, insurance, electricity, any other company incorporated under special act, any other incorporated under special act. NABARD is there. Like that, so many other companies are also there. They are incorporated under their own act of parliament. For them also Companies Act is applicable, provided there is no inconsistency. Next. Definitions. These are all the concepts you need to learn here. From this, one question can come in exam. What is a company? What is the previous company law? What is a body corporate? Who is a member? Who is a director? Over. Kinds of companies. Private company, public company, holding company, subsidiary company, associate company, government company, foreign company, nidhi company, one person, small, section 8, listed, unlisted. This is all you need to learn. From this, one question can come in examination. This attempt especially. Okay. Let us see. What is a company? Company means a company incorporated under Companies Act or on any previous company law. Either it should be incorporated under this act or under any previous company law. Then only we will call them as a company. Sir, mine is State Bank of India. Mine is a company incorporated under State Bank of India Act. Then who I am? You are not a company under Companies Act. You will be treated as a body corporate. You will be treated as a body corporate. Because body corporate includes a company incorporated outside India. Includes a company incorporated outside India. Includes whenever comes in the definition. Interpretation of statutes we will anyway read. Whenever the term includes come, it should be interpreted as a also. Also includes. Means what? This is also included. Not this is only included. Whenever the term means come, it means only. Only those should come. Includes means also they will come. So there is a difference between means and includes. Means now only, includes now also. There is a difference. So company means company incorporated under Companies Act 2013 or under any previous company law. Body corporate includes means body corporate also includes company incorporated outside India. Okay, company incorporated outside India means what? Body corporate includes company incorporated outside India. How to interpret that? Outside India incorporated companies are also included means India incorporated companies anyway will be included. So therefore, body corporate, there are so many things that you can enter into that. Number one, company incorporated under Companies Act or previous company law. It's a body corporate. LLPs, body corporate. Companies incorporated under Special Act, body corporate. Companies incorporated outside India also body corporate say. Okay, so therefore, body corporate definition you have to mug up literally. Read. Body corporate includes company incorporated outside India. So, company incorporated outside India means it will be incorporated under a foreign law. It will be incorporated under a foreign law, not under Indian Companies Act. Therefore, it is a company incorporated outside India, incorporated not under our Companies Act. Therefore, we call it not as a company, we call it body corporate. From this, what is the moral of the story? Every company is a body corporate, but every body corporate is not a company. Because in body corporate, company incorporated outside India, LLP incorporated outside India also can be there. But company means only company incorporated under Companies Act only will come. Company is a smaller definition. Body corporate is a bigger definition. Beyond this, I can't discuss at this moment. Everyone, please tell me. If you all understand, I will go into the next definition. Done. Next one. Next one. So now, sir, previous company law. Previous company law na enna sir, previous company law. What are the previous company laws? There are 5 previous company laws before our 2013. 1866, 1882, 1913, 1942, 1956. That's it. Next one. Director. What is the definition of a director? Director means, what do you mean by means? Only this is the way of becoming a director. There is no second way. Only one way. What is that one way? What is defined in the law is the only one way. What is defined? Director means director appointed to the board of a company. Means if you enter into the board of directors of a company, then only I will call you as a director. What do you understand from this definition? What do you understand from the definition? Director means a director appointed to the board of a company. That I understood. What exactly does it mean? What exactly does it mean is, name is irrelevant. Sir, what do you mean name is irrelevant? See, I was appointed into the board of directors of a company. I am named as a president, not as a director. Even then you are a director only. Okay, even then you are a director. You did not enter into the board of a company, but they are giving you position of a director. They are calling you director. You will not become a director. So, naming you as a director won't give you directorship. Going into the board and not naming you as a director don't make you a director. Don't make you not from becoming a director. So if you enter into the board, you will automatically be a director. If you don't enter into the board, even though you are named as a director, you are not a director. Everyone understood this statement, what I said? Everyone understood the statement, what I said now? Just because of the reason that you are named as a director, you will not become director if you don't enter into the board. Just because of the reason that you enter into the board, you will be called as a director, though you are not named as a director. Naming is not important. Entering into the board is important. Everyone. Fast. Reply. We'll go into the next one. Yeah. Next issue. See here. Member. Very important definition here. Member definition. Who is a member? Is our next question. Okay. Member in relation to a company means only, there are only 3 methods of becoming a member. I will first tell you what are the 3 methods. Number 1, at the time of incorporation, after getting incorporated, at the time of public offer. Third one, after public offer. Easy way to remember. You can become a member in three ways. Number one, at the time of incorporation. Second, at the time of public offer, or at the time of a new offer, maybe to public, maybe to existing members, new issue. Third one, when it becomes a listed company. When it becomes a listed company. Listen, I will give you example. Company, before getting incorporated, listen, anyway, incorporation chapter, I have to tell this. I will tell you now itself, such that at that time doubts will not come. Please, 5 minutes of discussion we are going to make on this. Beyond that, I don't want to spend time. See here, repetition also I won't do. One time I will tell. If you listen, or else gone. That's it. Okay, as simple as that. Life of a company will be broken into three parts: before incorporation, on incorporation, after incorporation. Okay, after incorporation. What does it mean? Company, before getting incorporated, promoters will be there. These promoters will do all the preliminary works. What is my preliminary works? Preparation of MOA, preparation of AOA, all other documents, everything these people only will take care. Make it and take care. Who? Promoters of a company. Now, these promoters of a company will prepare MOA, will prepare AOA, and will prepare other documents in the name of proposed company. In the name of a proposed company. Means, before incorporation, company is not in existence. Therefore, how can you call it a company? They are not promoters of the company. When they will become promoters of the company, when company gets incorporated. When the company gets incorporated. Company is not incorporated. Means, from where the question of promoter of that company will come. Okay. Second thing, if company is not incorporated, this is not the memorandum approved by the ROC. This is yet to be approved. We just prepared that MOA. We are sending it for approval of ROC. May be approved, may not be approved also. Cancellation also can happen. Rejection also can happen. In principle, we prepared this MOA, OA, and other documents. Listen carefully to the point. These promoters are not called as promoters in Companies Act. They call these people as subscribers to memorandum. They call them as subscribers to memorandum. Memorandum of Association, there are 6 clauses totally. Name, situation, also called as registered office clause, objects clause, liability clause, capital clause, association clause. Last 2 clauses are there, are the heart of the company MOA. People think objects clause is the main thing. No. The most important thing is capital clause and association clause. Capital clause and association clause. Simply, that's why I call it as this is a mother of company, this is a father of the company. Like that it will be. Who is important? Both are equally important. And both are required for our survival initially. Okay. So, that much important these 2 people are. So, let us understand what efforts capital clause and association clause will put. When you see the real capital clause of memorandum, the format will be looking like this. Serial number, name, PAN number of that particular person, okay, price per share, number of shares, total amount, digital signature of the candidate. Now I will write serial number 1, R Koushik Mukhesh, PAN number so and so, 10 rupee per share, 5,000 shares, amount to 50,000, sign. I sign. Like this, 7 names will be required for public company, 2 names will be required for a private company. Okay. So therefore, what will happen? Let us say ours is a private company. Another person 2 is there. Mr. A, PAN number so and so, 10 rupee. He also subscribed for 5,000, 50,000. A also signed. Over. Now this is a capital clause. What do you mean by capital clause? Koushik Mukhesh and second candidate Mr. A are promising on the memorandum, that once a company gets incorporated, I repeat again, once a company gets incorporated, we are having an obligation to put initial capital into the company, because company is a vehicle. For that, fuel is required. Fuel is the money. Who should put the money? Company are not incorporated. Before that, they can't put the money. Company should get incorporated, then they have to put the money. Company will get incorporated. If you don't pay, That's why I am taking a promise from you even before it is getting incorporated. That means you are promising that you will subscribe to the capital after getting incorporated. Where you are making the promise? Memorandum capital clause, you are making a promise. That's why you are called as a subscriber to the memorandum, not subscribing to the shares, because company are not there at the time you are signing on this. That's why we call this not subscriber to shares. I am subscribing to the memorandum of a company. I am subscribing to the memorandum of a company. Okay. Let us now complete our timeline chart that I have already drawn. See here. So, before, at, after. Okay, before, at, and after. Before incorporation of a company. Before incorporation of a company, you are called as subscriber to the memorandum. At the time of incorporation of a company, at the time means you submitted MOA, you submitted AOA. You submitted MOA and you submitted AOA. Both the documents are submitted. MOA is submitted, AOA is also submitted. Those submitted documents will be registered by ROC. Once the documents are registered, company will come into existence. Okay, today certificate of incorporation came. All subscribers to memorandum will be automatically becoming the members of a company. Their names will be entered into register of members of the company. Automatic. You need not do anything. I repeat again. Before incorporation, you are not a member. Why? Member of what company? Company are not there. Before incorporation, you cannot be called as a shareholder because company should come. I should first print the share certificates and then give. It takes time. Shares are not there. You are not a shareholder. Company are not there. You are not a member. Then who I am? What is my relation with the company? You are called as subscriber to the memorandum, not you are a subscriber to the shares. That's why before incorporation, you are called as STM. On incorporation, all subscribers to the memorandum will be deemed to have been agreed. Will be deemed to have been agreed to become the members, and their names will be entered into the register of members. And their names will be entered into the register of members. Okay. So, subscriber to the memorandum shall be deemed to have become the members, and their names will be entered into the register of members maintained by the company. Up to here, everyone understood the point clearly? Next case. Sir, company incorporated, sir. Then what to do? Then they will give you 180 days time. They will give you how many days time here? 180 days time. 180 days time, why they will give? In this 180 days, you should subscribe to the capital which is promised in this capital clause. You say, Koushik Mukhesh said, I will give 50,000 to the capital. Within what time I should give? Within 180 days I should give. Sir, I did not give, sir. What will happen? Company will be wound up. Company will be wound up. Strike off will happen. 248 section is there. Under that section, strike off will happen. So company will literally close. Without fuel, how many days I can also run the vehicle? I can't run. Initial, some basic fuel is required to burn it and then run the company. So therefore, sir, you said about capital clause, sir, but you did not tell anything about association clause. Then what it is? Nothing. Capital clause law, whoever are there, these people will sign on association clause. Sign on which clause here? Association clause. Why they will sign? Association clause will be the last page of the memorandum. If they sign there, they are accepting all the previous pages contents. For example, 100 pages document is there. I signed on 20th page. What does it mean? First 1 to 20 papers I am accepting. 100 pages book. I signed on 80th page. When I sign on 80th page, what does it mean? I am accepting the contents between 1 and 80. If I sign on 100th page, I am accepting contents between 1 and 100. Same. Association clause, if they sign, they will accept all the previous clauses. We are accepting our name, we are accepting our location, we are accepting our objects, we are accepting the liability, we are accepting that I am taking that capital, and we are signing in the association clause. Association clause will contain the names of STM. STM and what? Subscribers to the memorandum. This is what I wanted to convey. Okay. So, subscribers to the memorandum will be deemed to have become the members. Okay. Upon incorporation, they will be deemed to have become the members. Name automatically enters into the register of members. This is one way of becoming a member. Second, company going for public offer. Company going for public offer. Public offer time, application, allotment, first call, second call, final call. Second stage important. Once shares are allotted, Means what? Application money, application form you might have filled. When you are filling application form, what you are signing there? I am paying application money. If application money is accepted, allot me the shares such that I will be paying you the balance calls. Means we are agreeing in writing there. We are agreeing in writing. Application form is a writing, written document. So we are agreeing in writing that I want to become the member of this company and my name please enter into register. We are only asking. Third case, whenever you purchase shares in a stock market, sir, I am not STM, I am not purchasing at the time of IPO. I am purchasing TCS shares today. Today is not incorporation, today is not public offer. Normal day, I am about to buy. I will buy from stock market. Then tell me, if you buy from stock market, okay, three parties are involved. Company, sorry, I'm very sorry. If you are purchasing from stock market, three parties are involved. Seller, buyer, middle, there will be a very important person called as a depository. Who is he? Depository. See, you will sell the shares. One person has to hold it in electronic form. He will sell the shares to you. And for that also he has to hold in electronic form. The person who holds the shares in electronic form is called as a depository. Company records for depository name will be there. I repeat one more time, please have a clarity. I said the 5 to 10 minutes will spend here. When I come to incorporation chapter, fastly I will go into the concept with an assumption that you listen to the preliminaries properly. Okay, see here, I repeat one more time. Whenever there is a company, you take any company, you take TCS company, you take any company for that case. Whenever you take any listed company don't know who are their members. They don't know. For example, if I invested in shares of TCS today morning, I will purchase, I will sell afternoon. Now, the moment if I buy, company will write, R. Koushik Mukhesh is my member. Afternoon I sold. No, R. Koushik Mukhesh is no more my member. Again in the evening, 3 o'clock, I again bought. No, R. Koushik Mukhesh again become member of my family. 3:35 again I sold. No, he is again not becoming a member of. How many times he will change like this? N number of people, N number of times, they will change every single trading day. Company cannot maintain the details of all those people. Therefore, company will ask one dedicated outsider. You do one thing. You are a Chitragupta. You do one issue. All the members coming inside, all the members going outside, you maintain the record. Okay, whenever I wanted to declare any dividend, I will ask you, give my member details. At that time you give. Whenever there is a general meeting, I will ask you. Whenever there is a general meeting, I will ask you, give my member details. Then you give me. Whenever dividends are to be paid, I will ask you. Whenever bonus shares are to be issued, I will ask you. Whenever right shares are to be issued, I will ask you. Whenever notice of general meeting has to be given, I will ask you. At that time you give me. Remind me, you keep the details with you. Like this, one person is there. Middle he will stand. That person is depository. Depository. Depository will hold the shares in the company on behalf of the original shareholders. Koushik Mukhesh purchases. Koushik Mukhesh shares are not held with Koushik Mukhesh. They are held electronic form, held by depository. If you order them to sell, they will sell. If you order them to buy, they will buy and keep it with them. That's all. It is like a post office type. Or technically, it's like a bank. It will hold your bank, hold cash. They will hold shares. If you write a check to the bank, what bank will do? Release the money. Here, if you give a sell order, they will release the money. They will release the shares there. It's like a bank only. So whenever there is a depository, depository is the registered shareholder of a company. The registered shareholder means what? In the company's register, depository name will be there. In the depository register, our name will be there. Okay, but try to understand clearly. I purchased the shares. Then I should be the member of company, na? But because of frequent changes in the members, company is saying that, Koushik Mukhesh, you are a member. I am not denying that. But in my records, I will not maintain you. If your name is entered into the depository register as a member, you will be treated as my member only. That's what they said. So, three parties are involved. Company, depository, members. Once public offer is completed, company will lose contact with the member. Depository will have contact with the member. Okay. So, member name will be entered in depository. Depository name will enter into the company. Depository will tell he is your member. That's all. Those all people are my members. So what is the third way of becoming a member? Making your name to enter into depository register or records of the depository. You are the beneficial owner now. You are which owner? Beneficial. Why? General meeting notice is a benefit to you because you have to attend the meeting. Okay, that I will give you. You are a beneficial holder. Dividends I will pay you. Beneficial holder. Bonus shares I will give you. Beneficial owner. Right shares I will give you. Beneficial owner. Company records, your name will not be there. Depositor name will be there. That's why depository is a registered shareholder. Original person is a beneficial. This beneficial shareholder is treated as a member, not the registered shareholder. Okay, we now completed the definition of member. See, member in relation to a company means mode 1, mode 2, mode 3. I'm making it full screen. Please read it properly. Have you read what is there on the screen, everyone? Everyone give a reply. Okay. So I have given 2 to 3 minutes time for you to read as well, so that if you have any doubts, you will get it clarified. So what definition we completed? Definition of a member. So member definition is completed now. So condition 1, condition 2. I broken all the 3 modes into two parts. Subscriber to memorandum agreed to become a member. Upon registration, name entered into register of members. It's a deemed provision. Mode 2. Condition 1, who agreed in writing to become member and name entered into register of members. Third, holding shares of a company named as a beneficial owner in the records of depository. These are the 3 modes of becoming a member in a company. Okay. Next issue. Let us see the kinds of companies now. See the list first. Private company, public company, one person company, holding company, subsidiary company, associate company, Government foreign nidhi is small. Listed unlisted companies not for profit, which is called as section 8. So let us go into the main part of the section now. 15 minutes time I am giving for kinds of companies, not beyond that. So first 1 hour lo we have to complete this area. Preliminaries. 1 hour, 1 hour, 15 minutes maximum. Okay. Let us complete. Let's put a target and complete. We will do everything in a best way possible. Okay. Start. What is the thing that we have to complete? Private company. What do you mean by a private company? Private company means condition 1. Private company means, just a minute. Okay. Now see, private company means what? Private company means a company. First, private company must be a company. Condition 1, having minimum paid up share capital. Something minimum. What is the minimum? They did not define in the act. Something. 5 lakh, 1 lakh, 10,000, 20,000, your wish. Okay. But there should be a capital. Without fuel, vehicle will not run. And condition 2, articles of that company should do 3 things. Should do, not may. Should do 3 things. Okay, shall contain 3 things. What are the 3 things? Restriction on transfer of shares. Again, I am repeating. Transfer of shares is not prohibited. It is restricted. Next, limits. Total number of members to 200. Means the number of members are restricted to 200 in number. Okay, maximum number of members that you can have is only how much? 200. Next one, prohibits. Next one, what? Prohibits. What it will prohibit? Public subscription of any securities. Public subscription of any securities. So tell me, what are the 3 things? Private company means any company. Okay, private company means any company having a minimum paid up share capital, and by its articles, it will do 3 things. Restrict transfer of shares, limits total number of members to 200, prohibits public subscription of any securities. Okay, when I say limit the total number of members to 200, in this limit of 200, 2 things are there. Exclusions, inclusions. Exclusions, inclusions. Exclusion, who is excluded from that number of members? Present employee who is also a member. Present employee who is also a member should be excluded. Who will be excluded? Second person, past employees who became the members while in the employment. Past employees who became the members while they were in employment. Means what? I was employee 5 years back. Okay, at that time I got the shares. I came out of employment, but I am still a member of that company. Now, even me also should be excluded because I acquired when I was a present employee. I acquired when I was a present employee. Again, I will repeat. Listen carefully. This is very important. See, I am a present employee. I am a present employee. Being an employee of a company, company gave me shares. I am an employee and member now. Now you should not count me into the 200 limit because employees limit is not there. 1,000 employees also you can give a benefit. You can give a benefit also to 1,000 employees. Therefore, employee there is no limit. Employee, any number of shares he can hold from the company while he is an employee, present employee. Understandable. Past employee who became member while in the employment. What do you mean by that? 5 years back, I am an employee. 5 years back, I am an employee. At that time, I purchased shares. At that time, I am a present employee to the company. At that time, I am a present employee. Present employee is excluded or not? Once you are a present employee excluded, you will be excluded always. Even though employment is lost, you became a past employee. You were acquiring the shares and became a member when you are an employee. Yeah? Yes, that's all. You will be taken into the total. So you will be excluded from the total number of members of 200. Next. Who also is excluded? See, father and son, wife and husband jointly purchased shares. Jointly purchased what, sir? Shares. Who? Wife and husband or mother and father, whatever the case may be. So 2 people jointly purchase the shares of a company. Okay, through their joint bank account. Now who is the owner? Both the persons are owner. Both the persons will be members. No. In a joint holding, only it will be treated as a single member. Whose name first appears in the register of members of the company, that person will be treated as a member. Second member will be excluded. Why this provision came? Mainly for HUF. HUF Karta will represent entire family. Karta will take from the bank of HUF. Say HUF ki bank account will be there. Whose bank account? It's a family bank account. If I draw a check from that, property purchased out of it belong to everyone in the family. There are 30 people in the family. Karta purchase, 30 members are treated as one member only. That's why this concept came. Okay, so tell me, who are excluded? Present employees excluded. Past employees are not always excluded. Past employees who became members while they were in employment. See how exam question can be tested. (2022) I am an employee. 2023 I got the shares. Thereby I became a member. Now I am an employee and member. Employee and member. 2024 I resigned as an employee. Shares were not sold. Means still I am only keeping it. Means I am a member. I am now not an employee and member. I am only a member now, not employee and member. Employment lost. So I am only a member now. Okay. 2025. Counting made on number of members. Should I be counted or not? You should not be counted because though you lost employment and became a past employee, you acquired the shares while you are a member or not? Yes, that's it. While you are an employee or not? Yes, sir. That's it. You will be excluded even though you resigned from employment and became a past employee. This is one example they can ask. Second kind of example. See here. 2022 became an employee. Same. 2023 shares are issued, became an employee and member. 2024 listen carefully what happened. 2024 resigned, not sold the shares. So you are not an employee, but you are a member. 2024 December la sold shares. 2024 December la sold shares. Became a non-member of a company. 2025 la again he purchased shares and became a member. Okay. Now counting la this fellow is included or not? You will answer now. And the answer for this question is whether counting this person is included or not is very big yes. Sir, why sir? I am a past employee and share. You are a past employee, no doubt. You acquired shares when you are in employment, no doubt. But those shares you sold already. You became a non-member and non-employee. Again you purchased. Now shares are not acquired while you are a member. These new shares are acquired while you are a non-employee and a non-member of a company. You are included into the total number of 200. Everyone understood how they can create a difficult question in exam? Everyone understood? Yeah. I told now I will not repeat a number of times here. We have to complete entire syllabus means I can't repeat. Okay. Say this. Next one. Next one are three types of companies: holding company, subsidiary company, associate company. Okay. See, let us see this. First one is a holding company. What is a holding company? Holding company, subsidiary company, associate companies are not formed by incorporation. I can't form a holding company. Two companies are already there. Two companies are already there. Relationship start because of holding company, subsidiary company. That means these two are only relative terms. These two are only relative terms. Hey, A is there, B is there, already born. Now both are getting married. Relationship started between both of them. Hey, did you understand? A is there, B is there. Two different people are already born. Okay, now they are getting married by an arrangement made by their parents. Okay, now tell me what is happening here. Two people are united. Now what is starting? A new relation came between them called as a spouse relation started. I think everyone understood the point. So a spouse relation began now. Now spouse is a relationship. It is not a new person created. Holding company, wife, husband, spouse is the third person. Spouse is not a third person. Spouse is a relation. Same like that here also happen. Holding company, subsidiary companies are not companies actually. It's a relationship existed between two companies. That's why definition they clearly promote this. Holding company means holding company in relation to one or more other companies. Okay, holding company. Multiple subsidiaries can be there. Now. Therefore, one or more other companies. See, one holding company can have multiple subsidiaries. Okay, multiple subsidiaries can have one holding, but one subsidiary cannot have multiple holdings. Holding parent, subsidiaries are children. One parent can have multiple children. One child can't have multiple parents. So, therefore, holding company in relation to one or more other companies means a company in which such other companies are its subsidiaries. How beautifully they drafted. When you will become holding company, you will become holding company if all the other companies below are your subsidiaries, then you will become holding. Means you cannot read holding company definition unless and until you read the definition of what is a subsidiary. So tell me, what is the definition of holding company? Holding company in relation to one or more other companies means a company in which such one or more other companies are its subsidiaries. Okay. Then what is a subsidiary? What is a subsidiary? Subsidiary in relation to any other company. Plural is not used here. Singular, because subsidiary can't have multiple parents. So, subsidiary company in relation to any other company means a company in which holding company does two things. Control it has to do. Two things can be controlled. Two eyes are there for a company. Eye number one, shareholder. Eye number two, board of directors. Control either this eye or that eye such that you can control the main person. Therefore, first let us see the left eye, board of directors. So, holding company controls the board of directors. Composition of board of directors. Sir, what do you mean composition, sir? Ability to appoint or remove all or majority of directors. Means what? Holding company can't control board of directors, but it can control who should be there in the board of directors. A, B, C, D, E, F, G, H, I, J are there. I will tell, hey, Mr. C, leave. Mr. D, leave. Mr. F, leave. Mr. I, you leave. That power I have. I have a right to appoint and remove majority and all of the directors also. That power you have means you are having a control over board, control over the composition of board. Composition means what? Who should be there, who should not be there. That power I have. But I don't have power to control board directly. So control composition of board of directors. That is one control. Second, subsidiary company in relation to any other company means a company in which that other company, which is a holding company, exercise or control more than 1/2 of the total voting power, either at its own or together with its subsidiaries. Means X limited, Y limited, Z limited. X limited, Y limited, Z limited. X is holding 70% in Y. Y is holding 70% in Z. Okay. Now X is a holding company to Y. Y is a subsidiary company to X. Now Z is a holding subsidiary company to Y. Y is a holding company to Z. Okay. So a company can at the same time become both holding as well as a subsidiary. No problem. So because I am not a holding subsidiary to the same company, I am a holding to one company, I am a subsidiary to another company. To whom Y is a holding Z, to whom it is a subsidiary X, To exit can't become both holding and subsidiary at the same time. It can become holding company and subsidiary company at the same time, but not to the same company. But not to the same company. So what? When you will become a subsidiary company, let us take situation of Z. When Z will become subsidiary, if holding company controls, exercises or controls more than 1/2 of the total voting power. Total voting is 100%. More than 1/2 means more than 50. I am holding 70. Therefore, Z is a subsidiary, Y is a holding. Now see the X. X is holding 70% in Y. More than 1/2. Y is a subsidiary, X is a holding now. Clear? So, X, Y, Z, Y is a subsidiary to X. Z is a subsidiary to Y. Therefore, Z is deemed subsidiary of X also. It is said in the definition note also I have given here. The control as specified above may be exercised through its subsidiaries also. In that case, we call it a deemed subsidiary. So, I am not directly controlling Z. Through subsidiaries I am controlling. This is called as a deemed subsidiary. X and Z are deemed subsidiary. Okay. A company can have one direct subsidiary, one direct holding and one deemed holding. Understood? Direct holdings can't be two. Okay. Multiple direct holdings cannot be there. So therefore, other definition of subsidiary. So either you should control more than 1/2 of the board of directors, like that agreement should be there, or more than 1/2 of the total voting power you should have, either by yourself or through your subsidiaries. Anyone should hold. Another example also I will give you. X Limited, Y Limited, Z Limited, A Limited. X Limited holds 70% in Y. X Limited holds 70% in Z. Y Limited hold, say for example, 30% in A. Z Limited hold 30% in A. Now observe clearly. X is holding 70 in Y. Y is a subsidiary to X. X is holding 70% in Z. Z is a subsidiary to X. Pakka. But deemed subsidiary will not apply here. Why? When deemed subsidiary will apply? If it is a subsidiary to any of my subsidiary. Here in my example, Y ki Z is a subsidiary. Therefore, Z became a subsidiary to X. Here, Y is holding only 30% in A. So it's not a subsidiary to Y. Therefore, it is not a deemed subsidiary to X. On the other hand, Z is not holding more than 50% in A. Therefore, A is not a subsidiary to Z. Therefore, A is not a deemed subsidiary to X. Therefore, deemed subsidiary of X and A will not apply here. But it will be treated as a subsidiary because of this condition. Either at its own or together with your subsidiary. Therefore, tell me, my subsidiaries are Y and Z. Y is holding 30. Z is holding 30. Both together 60. You may not hold, but through your subsidiaries you are holding 60%. That's it. A will be treated as subsidiary to X. Funniest part is A is not subsidiary of Y and Z. A is only subsidiary to X now. Okay. No repetition. Everybody in the class understood the concept clearly. Yeah. Repeat. Everyone. Are you all clear? Done. Associate company. Associate in relation to any other company means other company should exercise significant influence, not substantial influence. Substantial influence will become subsidiary. Significant influence. Sir, what is significant influence? Shareholding minimum 20% or board of directors participation. You are not controlling composition here. If you control composition, you will become holding company, subsidiary company. Associate company, not big like subsidiary holding, not even so smaller. 20% I am holding, but less than 50% only. But not more than 50%. If you hold more than 50%, you will become subsidiary. If you have a power to control the composition of board of directors, you will become holding subsidiary. I don't have 50 or more than 50, 30, 25, decent amount. I'm not controlling composition, but I can control decisions in a board meeting along with other directors. Then you are called as associate, not called as a holding subsidiary holding. Next. Government company. You can become a government company in two ways. Directly through government holding, and second one by becoming a subsidiary to an existing government company. Okay, you can become a superstar in two ways. Hard working and you can become, or become the son of some superstar or megastar, automatically you will be treated as a superstar. Same logic. One mode, tough mode. You can become a government company in two ways. Mode 1. First, government company means a company in which not less than 51% of the paid up share capital. When I say paid up share capital, it includes equity share capital and preference share capital also. Okay. Differential rights are there. Now, how to treat we will see when we come to differential voting shares. So, repeat again. Mode 1 of becoming a government company. Company in which not less than 51% of the paid up share capital is held by CG, SGR, SGs or partly. Okay. This is one way. So, governments should hold more than, not less than 51. That is one way. Sir, that is not possible for me. Is there any shortcut route? Yes. Become a subsidiary to a government company. Means one company has become government company this way. Become a subsidiary to that, automatically we will call it as a government company. Clear or not? In this connection, there can be a question that can be given like this in exam. There is a company called as X Limited. In this X Limited, Andhra Pradesh state government will hold 40%. Okay, Andhra Pradesh state government will hold 40%. Y Limited, which is a government company, will hold, Y Limited, which is a government company, will hold 20%. Will hold 20%. Is this X Limited a government company? Like this they will ask. No, this is not a government company. Reason I will tell you. You can become a government company in two ways. Not both the ways. Any of the two ways. Either government should hold more than 50, not less than 51. Or become a subsidiary to a government company. Y Limited is a government company holding 20% in X Limited. Just now we read, with the 20% X Limited will not become a subsidiary to Y Limited. So route number 2 closed. What is the mode number 1? Through government you should hold not less than 51. Here only 40%. So therefore, don't combine 40 and 20 and see 60. You will get lost in exam. Sir, can I add 40, 20? Yeah, yes. When you can add? If both are governments. AP government and Tamil Nadu state government are holding 40, 40. Then you can total and tell 80%. Tamil Nadu is holding 20, AP holding 40, 60. AP holding 20, Tamil Nadu holding 40, 60. You can total. Here this is government, this is government company. Both totals you cannot add because it should become subsidiary to government company, not less than 51%. Understood? Next one. Foreign company. Basic condition. Company, body, corporate, incorporated outside India. Okay. Next. Supporting conditions. Place of business should be in India. So just the incorporation outside India don't make you foreign company. You should incorporate outside India. Business should be there in India. That business can be carried on either by itself. You can come and start your branch or give franchisee through agents physically or electronically and conducts the business. Next. Nidhi company, don't read, not required. Next. Small company, important. What is a small company? Basic eligibility to become a small company is that company should not be a, not should be a, should not be a. So to become a small company, you should not be public company, holding company, subsidiary company, section company or body corporate. Incorporate under special act. So what are not small company? Public company, holding company, subsidiary company, section company, or body corporate, incorporate under special act. They are not small companies. This is basic eligibility. Yes sir, I am not falling under any of these. I am a private company. Now again additional conditions are there. Your paid up share capital should not exceed, this you have to change, a small change is there, 4 crore, 40 crore. So paid up share capital not exceeding 4 crore, turnover not exceeding 40 crore. Next, let me go this side first. Company is not for profit. What is a company not for profit? Section 8 will cover this. Any company which is incorporated with an object, means a purpose of promoting, not to make profit. I wanted to promote that area. That area should grow, not me, I should grow. Promoting education, science, religion, arts, etc. Next, profit will come. I am telling I don't want profit. But if profit comes, I don't say no. So if profit comes, I should not eat them. I should apply the profit again for the objective only. And dividend distribution is prohibited. That's it. Next, unlisted company. Any company other than listed company. Okay. Listed company. What is a listed company? Listed company means a company of whose securities have been listed on any RSC. They use the word security. They did not use the word shares. They use the word security. They did not use the word shares. Therefore, amendment has come to this. Listen, very, very important amendment. I don't know how many students know this amendment. First, listen carefully. Amendment did not come this attempt. 2 attempts back it came, but very important, significant amendment. Tough question has to come now. They can ask this question in exam. Let me first explain what is this logic all about. Okay, participate. Point number 1. Listed company na. See, I will ask you a question. My company has issued debentures. My company has issued debentures. Debentures for 5 years. Listed them on a stock exchange. Debenture is a share of security or security. These debentures will be convertible or non-convertible, or non-convertible debentures I issued. 5 years. I listed the shares. Now I become which company? Listed company, because any of those securities whose securities have been listed, not shares. Debenture is a security, not a share. Debenture is listed. Debenture listed. I issued to debenture holders. Listed on a stock exchange. I call your company as a listed company. 5 years completed. I paid back the debentures. Now again I will become unlisted. Ante kada general logic. When it is listed, I will be listed company. Debentures are not there. My shares are anyway unlisted. Now you are getting that listing status permanently or temporary? Temporary. Those kind of situations are exceptional cases. Any kind of temporary listing should not be considered to be listed company. Preference shares also same. Private placed preference shares. See, private company. If issue of listed, if the issue listed is non-convertible debt security. Just now I told you non-convertible. Sir, why non-convertible? Convertible anyway, convert into shares. Shares will be there for forever till the company is there. Longevity is there. They will agree listed status. So if the issue is listed is, okay, if the issue listed is non-convertible debt securities or non-convertible redeemable preference shares issued on a private placement basis, not to public, privately placed. Next, means existing members. Public company which has not listed its equity shares in India. So their equity shares are not listed in India, but has listed equity shares outside India. No listing even outside India. Two situations. Okay, let us see. But has listed equity shares outside India. Exempted from status of listing if the issue is relating to non-convertible debentures or non-convertible redeemable preference share issued on a private placement basis as per SEBI regulations. Next one. Which has listed equity shares within India, no exemption. It will be always called as a listed company. In simple language, if I have to tell, there is a company issued its shares, equity shares listed. Now always you are a listed company. Other securities like non-convertible debentures and non-convertible redeemable preference shares, if you are listing on an exchange, that is only for temporary period. You are not treated as a listed company, provided issue is not made to the public, issue is made to the private placement. More about this we will see when we come to the share capital chapter. Then you will get full clarity. Okay. With this, we completed preliminaries chapter, one of the most important chapter for the Jan exams we completed. Everyone please tell me 1 hour 15 minutes. 1 hour 15 minutes. In that 15 minutes, I introduce you to the main topic. What we are going to do. 1 hour exactly. We completed preliminaries. Are you all comfortable with this, everyone? Okay, done. 5 minutes gap we will take. Have some water and come back. We will again start with the next area called as incorporation of a company. Okay, this time 10 marks you can expect from this area. Okay, so take a 5 minutes to 8 minutes gap and come back soon. We will start with incorporation. 2 hours I will be spending on incorporation. 2 hours I will spend also on prospectus chapter. Okay, everyone? Clear to the schedule, everyone? Yeah. Take a break and come soon. 5 minutes gap. So next area we are going to start is incorporation of company and matters incidental thereto. Name of the chapter, Incorporation of Company and Matters Incidental thereto. Okay. See here first. In this chapter, there are so many issues that we have to cover. Literally so many. But in the last trend I shown you na, incorporation is coming for 2 marks, 4 marks, sometimes for 3 marks, like that they ask. But previously, once upon a time, 6-7 attempts back, there is a past history of this chapter coming for 11 marks and 12 marks also in exam. Recent trends, they decrease the marks for this weightage for this chapter. Now student will be in a wrong opinion that okay, this chapter is the least important. On the basis of trend, let us go by other. They will give this chapter next attempt for 12 or 15 marks gone. Therefore, let us not take that risk. Same risk is also there with prospectus chapter this time. So let's not leave this. Okay. So now around 12 o'clock now. Okay, around 12 o'clock now. 1.5 to 2 hours time we have to put for this chapter and let us complete it. Okay. What extent we have to complete, let us complete in this particular chapter. All the concepts I will discuss in this particular area called as incorporation. This chapter flows from section 3 to section 22. Section 3 to section 22. Okay. Concepts overview. Basic definitions. Who is a promoter? Who is a registrar? Memorandum, articles. That's why promoter, register, memorandum, articles. 4 definitions. First. Next one. Clauses of memorandum. There are 6 clauses. That clauses we are going to read. Next. Formation of company. Formation of company. Analysis on memorandum. Analysis on articles. Analysis on name clause. Name clause again there are 5 parts. Contents of name clause, reservation of name, rectification of name, restrictions on name, alteration of name. Next, situation clause. There are again 4 concepts, 3 concepts totally. Contents of situation clause, establishment of registered office, shifting of RO. In the shifting of RO again there are 4 kinds of shifting. Shifting from within the place where the company is situated, city to city, ROC to ROC within the state, state to state, various. Next, analysis on other clauses, objects clause. Objects clause are 2 things again. Contents of objects clause and alteration of objects clause. Next, alteration of article. Next one is the conversion cases. Public to private, private to public. Okay. Next, doctrine and related sections. There are 3 doctrines and 4 concepts. Doctrine of constructive notice, doctrine of indoor management, doctrine of ultra vires, effect of memorandum and articles. There is another concept in doctrine of indoor management, exceptions to doctrine of indoor management, which is very important. Next, incorporation related sections. How to incorporate a normal company, how to incorporate a OPC, Section 8 company incorporation, declaration of commencement of business, effect of registration. Miscellaneous, section number 19 to section number 22 are miscellaneous sections. These are all we are going to read in this particular chapter. Okay. Overview you can see first before we go into the main contents of the sections. Okay, next. First one, basic definitions. Who is a promoter? Who is a promoter? See, generally promoter means they will start the company, like that we will tell. No. Companies Act definition of promoter covers the duties of a promoter, liabilities of a promoter. Definition do not contain what are the characteristics of promoter. No. They will cover who will take the responsibility of a promoter. See. Let us see. Promoter. A person who is named as such in the prospectus or in the annual return. Who is named as such in the prospectus or in the annual return. What does it mean? See, if you name a person as a promoter in the prospectus, if you name a person as a promoter in the prospectus, for example, you named a person as a promoter, prospectus you opened, prospectus of promoter, Mr. A is there, automatically Mr. A will become promoter whether or not really he promoted the company. Second, annual return. What is it? Annual return. Once you name a person in the annual return as a promoter, annual return will be filed by the company every year. In that annual return, you said that Mr. A is a promoter. That's all. He will become a promoter by default, whether or not really he is a promoter. Okay. So that's one of the route of becoming a promoter. So what is the first route? Naming in the prospectus, naming in the annual return. Second one. Sir, my name is not there, but I can control the company affairs. Okay, company anything has to happen. I have a control over it, either as a shareholder or as a director. Then also you are called as a promoter. So promoter is a person who is having a control over the affairs of the company, either as a shareholder or as a director. Sir, my name is not written in the prospectus or annual return. I have no control over the affairs. Directly, I am not controlling. But I will give instructions to the board of directors. Board of directors will do whatever I say. Second situation, I am controlling directly. Third situation, I will give advices. I will give directions. I will give instructions to the directors. These directors are dummies. They will do whatever I say. Now I am not doing the point to directly. I am getting it done through the directors. You are also called as a promoter. So you will be called as a promoter in how many ways? 3 ways. So you will be called as a promoter. Way number 1, naming you in the prospectus annual return. Second route, directly controlling the affairs. Number 3, anyone who is having whose advice, directions or instructions board of directors of the company are accustomed to act. Okay. So in this advice, directions or instructions, professional positions are not covered, except when such advice, direction or instruction is given in a professional capacity. Example, there is a company, they can ask a question like this in exam. There is a company X Limited. In that X Limited, Mr. A is a legal advisor. Okay. On a particular problem, he gave an advice to the board of directors. Board of directors said yes. Now legal advisor will become a promoter. Now my advice is given in a professional capacity. You should not cover that. Okay. So therefore, how to become a promoter? You can become a promoter in 3 ways. Way number 1, you should be named as such in the prospectus. Second, you should be named as such in the annual return. Third, you should control the affairs of the company either as a shareholder or director. Fourth, you are not controlling, you are giving ADI, advice, directions or instructions to board. That board is accustomed to act according to your directions or instructions. This is an indirect route of becoming a promoter. But very, very important thing is, any advices given in professional capacity will not be considered. Okay, next. What is the second one? Registrar. Okay, who is a registrar? Definition of registrar is not given. Hierarchy given. Means level. Assistant registrar, deputy registrar, joint registrar, additional registrar, under registrar. Tell the hierarchy. Assistant, deputy, joint, additional, main registrar. This is hierarchy. What registrar will do? Registration. Registration of what? Company registration and other registrations. Registration of company and others. Next, what is articles? Articles means, articles also not defined. Articles means 2 types of articles. Original articles at the time of incorporation, altered articles whenever you alter them. So articles of association means articles of a company as originally framed. or as altered from time to time. Memorandum ki just replace the words. Memorandum means memorandum of association of a company as originally framed or as altered from time to time. With this, we completed the 4 definitions in this particular chapter. First of all, everyone, please give me a reply. Have you all understood the definitions clearly or not? Okay. 1 minute time I will give you by putting it on full screen. Just read and complete it fast. Okay, done. Next one. Formation of a company and related concept. Formation of a company and related concept. So let us try to understand how to form a company and the related aspects inside that. Okay, see here. First, basic rules for formation of a company. Purpose of incorporation. Section 3 we are reading. Please keep mind here. Section 3 we are going to cover. Basic rules for formation of a company. Purpose of incorporation. Only for a lawful purpose. Means a company cannot be incorporated for illegal or unlawful purposes. Association. If it is a public company, 7 or more people should form. Private company, 2 or more. OPC, 1 person. All this association will be called as what? Subscribers to the memorandum. Now I will save time. I need not explain you what do you mean by subscriber to memorandum now. Everybody in the class understood the point clearly. What is a subscriber to the memorandum, which I discussed in the initial part itself. Okay, next. So, members are severally liable in certain cases. Section 3A. Members are severally liable. Means separately they will become liable. What do you mean by this? See, what are the consequences on the members who follow below the statutory minimum? Public company 7, private company 2, 1 person ki 1. Forget about 1 person company. Private company 2 became 1. 7 became falling below statutory minimum. What will happen? See. What will happen? Let us observe first. Okay. Let us try to understand. What are the consequences on number of members falling below the statutory minimum? I will draw a timeline chart and explain you. There is a private company. There is a private company. Private company. 2020 they started with 2 members. They continued with 2 members till 2024. Okay. 2024 December la one of the member went out by selling the shares to the existing member, and he went out. Because of that, it became only one member. But private company means how many members are required? 2 members are required. But the number of members became how many? 1. Immediately company has to close? No. Okay, immediately I should stop doing the business? No. 6 months time I will give you. Let us say December 31st this happened. Jan, February, March, April, May, June. Means June 30th, 2025 is a final date, before which number of members should be 2. But company failed to do so. They made it 2 members again on, say for example, August 10th, 2025. They added one more member, making it 2 members totally. So repeat everything once. Start 2020 there are 2 members. 2024 December 31st 2 members, 1 member went out, became 1 member. 6 months no problem, without any problem, like as if there are 2 members, company can do the business. For how many months? 6 months period. June 30th 2025 came. Number of members became 2? No, still they are 1 only. Now after that, June, July, August, means for around 40 days, even with that 1 member only, they continued even beyond that. Means 6 months plus another 1 month plus another 10 days. In this company there is only 1 member instead of having 2 members. So 1 member is required. How many members are required? 1 member is required. How many are there? Sorry, very sorry. 2 members are required. How many are there? 1 member is only there. Up to 6 months I will say okay. But for this 1 month and 10 days is there na, that is a contravention. Therefore, during this time, 2 members are there. Any liability of the company will be liable. Members are not personally liable. Next, after that what happened? After that December 31st 2024 number of members became 1. Up to 6 months, for any liability, company only liable, not the members personally liable. Next, 6 months time I have given to fill that number of members from 2 to 1 to 2. You did not fill. 40 days you continued with only 1 member after 6 months period. This liability, company will not be liable, member become personally liable. 10th August again they appointed na. Any liability incurred after that, company will become liable, member will not be personally liable. Means what? Member personally liable always are in certain cases. In certain cases, what is the certain case? Number of members should fall below statutory minimum number, and company should have completed 6 months time. Even after 6 months, number of members are not increased to 2 in case of private and 7 in case of public, and business is conducted. Any debts incurred by the company, member become personally liable. Same concept you will also see in LLP chapter. See, what are the consequences of number of members falling below statutory minimum? In the first 6 months time, company can continue to carry on the business. Company can contract with debts also. Company shall be held liable for all the debts and obligations. When in the first 6 months. After 6 months of fall, general case, company cannot carry on the business in its own name. But you violated and you carried on business. If company carry on the business and contract debts after 6 months, even when the number is below the limit, then two situations. Company will not be liable. Member who is aware of that fact shall be jointly and severally liable for the debts contracted after 6 months till the number is increased to 2 again. In case of private, 7 to public company. Everybody in the class understood the concept clearly? Everyone understood the concept clearly? Yeah. Next issue. Clauses and its summary. There are 6 clauses. Name, situation, objects, liability, capital, and one person company nomination, other company association clause. Subscribers' names will be there. Okay. Let us first see this. What is the first one? Name clause. See, whenever in my book, name clause means name clause, after that register office, like that I did not put. Once I touch name clause, now all concepts in this chapter which are linked to name clause, we put in the single chart. such that if you read this and complete now, after that about name clause, you need not study anything. Okay, that is for the name clause, general cases. This is for the name clause, rectification of name clause and alteration of name clause. Situation clause, all about registered office. Section 4.1 we read with section 12. After the shifting of registered office, 4 different cases. Place to place within the city, the city within the same state, ROC to ROC within the state and state to state. Objects, other clauses, then articles of association, then conversion cases, doctrines under Companies Act, like that it will go on and so forth, will continue. Okay, let us first continue and complete this. See here, name clause, general situation of a name clause. Let us see. See here, contents of a name clause. Name clause contains the name with which the company is proposed to be incorporated. Public company should use the words limited at the end of the name, private limited at the end of the name, one person company at the end of the name. Next, Section 8 company need not use the word limited or private limited at the end of its name. What we understood at the beginning, name clause will contain the name with which the company is proposed to get incorporated. Okay, so in that, public, private, one person company, 3 companies are there. Public company should use the word limited at the end of its name. Private company should use the word private limited at the end of its name. One person company should use the word OPC at the end of its name. Section 8 company need not use the word limited or private limited, but at the end of its name they need not use. But they will use a different name like federation, foundation, confederation, chambers, like that they will use a different language. Okay, next. Prohibitions and restrictions. Prohibition. Name should not be identical or too nearly resemble to the name of an existing company. What does it mean? You started a company with a name. This name of a company should not be too nearly resemble, too identical to the name of an existing company. There is already an existing company. Existing company is there. To the name of that existing company, this name should not be identical or too nearly resemble. Okay, XYZ Limited, you should also not start XYZ. Not even that. I started like this. YEX, YE, ZED, Z Limited. Now, name may not be identical completely, but too nearly resembling. Sounding is same na. XYZ only we will speak also this. These are also not allowed. So, if the name of the company is too nearly resemble or identical to the name of an existing company, such kind of names are prohibited. Second, name shall not give false impression of a government patronage. Patronage means support. For example, I started a company. Okay, I started a company and kept it as KMR classes AP Limited. Bracket la Andhra Pradesh close limited. KMR classes AP Limited means what you understand? Maybe these classes are run by AP government. No, I am from Andhra Pradesh state now, that's why I kept that name. This is a false impression now. How much fraud you are doing? When a person see that, they will think it's a government operated company. Like that, you should never use a name. So name shall not give a false impression of a government patronage. Sir, government means central or state. That's why they gave the details of that. It should not be central government, state government, local authority, or any body owned by central or state government. You should never use their names unless really they gave you some support. Okay, next. Name is offensive. So name should not contain any offensive words. Means prohibited words should not be there. Okay, next. Restriction. Sir, what is the difference between prohibition and prohibition? Means you should not. Restriction means you can, but with the permission you can do that. What are those? A company can use the word national, board, commission, Bharat, central, state, etc. with the previous approval of CG. Means you can use the word national. For example, there is an insurance company called as a National Assurance Company Limited. Sir, then they use the word national. They took permission, they have used. Understood the point or not? They took the permission, they used. So commission, Bharat Heavy Electricals Limited, BHEL is there. Sir, their Bharat is used, they took the permission of CG. And it's a government company as well. Next, you will get a doubt also. Sir, Andhra Sugars is there na, sir? Andhra Sugars. It is there near Rajahmundry only na. Sir, Andhra Sugars is there. Word Andhra came in that listed company, one of the biggest listed company. So you are using that name. That is also taken the permission of CG. So if you want to use the word national, board, commission, okay, next Bharat, central, state, etc., you must take the permission. Okay, only those are, sir. No, no. If you want to use the word insurance, IRDA permission. If you want to use the bank, RBI permission. Venture capital mutual funds, SEBI permission. Nidhi, MCA permission. These are all called as separate regulatory authority permissions. Regulatory authority permission. Okay. This is all about prohibitions and restrictions. Everybody in the class, please answer. Up to here, do you all understand all the concepts relating to the name clause up to here? Okay, done. Let us move on into the next discussion. Okay, next. Reservation of a name. What is this? Reservation of a name. You cannot directly incorporate a company with the name you want. First, you have to reserve the name and then you have to go for registration of the name. Okay, first you have to reserve it, then incorporation. Gap will be given means the date that will be, okay, the date that will be taken will be how many days? 15. So let us try to understand what this is. Okay. Reservation of name. Sir, first listen to the concept of reservation. Once you understand everything, then you can go on with the reading part. I will first explain you. There is a new association of persons wanted to form a company. They wanted to form a company. Whom? Some group of people wanted to form a company. You can form a company, no problem. But you cannot incorporate company directly. First, you have to reserve the name. Let the name get reserved. In that reserved name, you have to incorporate your company. Okay. I don't want to go into the details of forms, how to fill like in a regular class now. I don't want to waste your time and my time also. But without this basic intro, you can't understand the concept. That's why I'm just repeating some basics. You cannot register a company without reserving the name. Step 1, reserve the name. Step 2, registration of a company or incorporation of a company. First, reserve the name. How to reserve? Reservation again 2 types. Sir, my company is already incorporated, sir. Now I wanted to change the name from ABC Limited to XYZ. Now also first I should reserve XYZ and then only I should go for a change in the name. Yes, that's what I am going to tell you now. Reservation can happen in 2 stages. At the time of incorporation, proposed company. After getting incorporated, existing company. If it is a proposed company, if it is what company? Proposed, and a company not yet started, we wanted to. So apply in a web form. Okay, apply in a web form. Web form means online filing. Spice 32 form, INC 32 you need to take. Fees 1000 rupees you pay and you send it for its approval. Next, validity of the name reserve. Validity of the name reserve. The name that you sent, you have sent the name, na? Okay, that name will be reserved for a period of 20 days. How many days here? 20 days. Some printing lag has come. So name will be available for a period of 20 days. This 15 days is to rectify the defect. So this name will be valid for a period of 20 days. What does it mean? In 20 days, so you have to reserve your company, you have to register your company. Next. So at the time of incorporation, apply in web form, Spice 32 form, Spice plus form, INC 32, pay 1000 rupees, reserve the name. Validity will be for 20 days. Next, apply in a web form. Form name is run. RUN means what? Reserve unique name. This is not for Spice. Spice is used for reservation at the time of incorporation. But already incorporated, you can't use Spice 32. Therefore, you have to use a run facility along with 1000 rupee fee. Validity, same validity will be given to you. But listen carefully to the point. Okay. See, application in Spice Plus may be accepted or rejected. In case of rejection, a one-time resubmission option shall be given to rectify the defects in application form within a period of 15 days. You submitted. Okay. You submitted. Immediately rejected. Accepted or rejected? Rejected. Then you will be given a chance to rectify the defect and resubmit it within a period of next 15 days. Once that is submitted, now 20 days the reservation will be given. In this 20 days time, you have to incorporate your company. Understood the point clearly or not? Everyone? Okay, so that's the point. So not great point to understand for exam, but still there is a small issue like this in study material, so I covered it. Next, name clause law, most important to two aspects we are going to discuss now. Rectification of name, alteration of name. See, alteration of name is governed through section 13 subsection 1, section 13 subsection 2, proviso to section 13(3), section 13 subsection 9, section 13 subsection 10. Okay, there are so many provisions on alteration as well. First, rectification. Let us see. Name clause law, first one is concept relating to rectification. Let us see. Type 1 of rectification, type 2 of rectification. Type 1. First, I will explain like any other concept. Then we can read it in 1 minute. Okay. Listen carefully first. You applied for a name. ROC registered that name, believing that that is a unique name. Computer always have systems, computer systems or software, to be very clear and precise, will always have intelligence, not wisdom. Means what? Intelligence means you will have a dustbin. Dustbin can store so much of data. Just because dustbin has stored data, you will not call dustbin has a wisdom. It has intelligence of storing things. That's all. Computers are always intelligence only. That's why they call very nicely artificial intelligence, not artificial wisdom. Means what? It don't know what is right, what is wrong. You give me data, I will process and give you output. That's all. Good if you give, good only I will give. Bad if you give, bad only I will give you. We are seeing a deep fake how it is working in the world today. You give some good content, I will give you good content. You give me bad content, worst content also they are giving out. Means what? They don't know anything. They are just dustbins. You throw something, I will store it. When you ask, I will give back because I will store with me. This is the concept of computer system, software. From there only problem started. Normally, you will incorporate a company. Already there is a company called as XYZ Limited. XYZ Limited. Okay. I incorporated a company X, Y, Z Limited. Human being, you have wisdom. God has given a power to understand what is good and what is wrong and what is bad. So you will tell, hey, XYZ, this XYZ. Why you are writing like that? Both are too nearly resemble. Adi, you know that. Computer system will see these characters differently because they convert everything into binary language and see. In a binary code, all these things are different numbers will be given. Understood? For this binary code, for the second one, binary code is not same. Computer, what it will know, if binary code matches, then I will tell, hey, this name is not allowed. But here, not allowed means mine is different. By spelling, it is completely different. Computer don't know. ROC also did not see. Generally, ROCs will see very keenly. Is there any name with the same sounding? At least they will check that way. Clear? ROC, inadvertence, means oversight, by mistake. ROC incorporated this company. Which company? XYZ Limited company. They came to know there is a company already incorporated with the name called as XYZ Limited. Now another company also got incorporated with the name XYZ Limited. Change in spelling but sounding is nearly resembling. Okay. Now fraud happened. Fraud is committed by this company. Now newspaper next day they have written XYZ Limited has committed fraud. People talk like this. XYZ Limited fraud happened. Then who is more popular XYZ? First one. Then everyone will think first XYZ Limited has done the fraud. Understood the point or not? First XYZ has done the fraud. Hey, simply you can understand this way now. There is one chartered accountant with the name Koushik. There is a chartered accountant also with the name Koushik. Example, this take it as an example only. Don't take it extremely seriously. There are two chartered accountants with the same name. Koushik, that fellow is also Koushik. That fellow has done the fraud. Reasonably, I am more popular now in this community. Koushik, CA Koushik has done the fraud. Next day newspaper headlines came. Then immediately people will first put a message to me only. Sir, did you involve in any kind of fraud? Why? Because I'm more popular now. So that's the problem. I think everyone understood the logic clearly now. What is the problem of having a same name? Answer, yeah. So that problem they wanted to avoid. They don't want to put that problem. See, I'm an individual, but companies, the shares are listed on stock exchange. If something happens now, company prospects are gone. Therefore, they take this very seriously. Therefore, ROC by inadvertence means by mistake has registered my company with the name XYZ Limited. Later, ROC found that this name is too nearly resembled to the name of an existing company or a body corporate or any trademark. My name is similar. ROC will request us. Okay, will request us. Okay, Babu, Chitti, Kanna, my mistake. Please change the name of your company from YEX, YEY and ZED Limited to some other name which is not identical. My mistake. That's why I'm not punishing you. Pass ordinary resolution. Normally, name alteration requires special resolution. My mistake. Conduct ordinary resolution. My mistake. Conduct general meeting. 3 months time I will give. In 3 months, Nana Bujji, Kanna Chitti, please change the name of the company. Like this, they will request. Who? ROC. Through central government, they will direct. ROC through notice will not come. MCNA will directly request you. It will order you, please change the name of your company from the old YEX and YEY and ZED. Okay, please change it. Ordinary resolution, general meeting within 3 months. Sometimes. Trademark ki your name can be similar. I will give you an example also. There is a company with the name DMart. Correct? No. There is no company with the name DMart. DMart name is Avenue Supermarts Limited. Avenue Supermarts Limited is the name of the company. Okay. Brand name, trademark name is DMart. D means their family name. Damani Group. A Damani Group representative, they kept DMart. So Damani Group is the group name. Their family name is Damani. Okay. Damani Mart. They kept like this. But actually name of the company is Avenue Supermarts Limited. People don't know this. Paper light came. Avenue Supermarts Limited has committed fraud. People don't know. DMart committed fraud. That's it. Fire. India on fire. DMart committed fraud. So now listen. 2000 example I am telling, not fact. Hey, this is fact. Now I am writing example. 2020 la Avenue Supermarts Limited is formed. Example, they formed in 1988. I know full history. I invested in the company also. I am one of the person who always track their shares. So I know entire history, the ratios, everything I know about DMart. Okay, don't try to teach me about DMart now. But example I am telling. Avenue Supermarts Limited is there. 2020 la company incorporated example. They became super popular in India. Okay. They started one trademark called as DMart. This is registered in the minds of public like anything. Villages, towns, cities, metro cities, metropolitans, cosmopolitan, everywhere they are there. Where DMart is not there, wherever post office is there, wherever DMart is there. Like that they established their business. Super successful. Now what happened? 2023 year. Okay, 2023 year. Let us say on Jan 1st, 2023. I started a company with the name DMart Limited. Now name search I will do. DMart Limited. Is there a name? No company with the name DMart. Avenue Supermarkets is there, but DMart is not there. ROC gave me this name. 2023 Jan 1st, DMart Limited is incorporated. Okay. This thing came to the notice of DMart company, Avenue Supermarts Limited, on March 31st, 2023. This group, Avenue Supermarket Limited managing director, came to know that in Hyderabad there is one company, or in Vijayawada there is one company, or in Chennai one company is there with the name DMart Limited. With the name DMart Limited, there is a company. If they do fraud or some nonsense, people don't know that we are different. People will think both are same. Therefore, First we will ask him to change his name. It is resembling our trademark name. Now, how ROC will know? Company names, na MCA register, it will be their mistake of MCA. But here this is not my mistake. Na. Trademark similarity, how can I check? Therefore, law said like this. When this company was formed, 2023. Okay, now when Jan 1st. 3 years within this date. Okay, not from the date when you came to know about it. No, from the date on which the company is incorporated with the name of your trademark. From there, within 3 years, proprietor of registered trademark should make an application to CG saying that Babu Kanna Chitti CG, you accepted one company name with the name DMart. That's a trademark name. If he does something, people will think I have done that. Please ask him to change the name. When I should complain? Within 3 years from the date of incorporation of that company with the name similar to my trademark. From there, 3 years time I will give you. Limitation period. You should make an application to CG. Clear? Okay. CG ki 2 opinions may form. Yes opinion, no opinion. Means what? CG may tell, array, they are starting some Kmart Limited. You are a DMart. Now, why people will think Kmart and DMart are same? No need. You can go. Understood? I started with the name DEMART. Now this is not DMart, but spelling is like DMart. Na? Trademark is similar again. They will tell, okay. This is dangerous. I will ask him to change. So, if central government also felt that yes, there is a need, then they will order the company to change its name to a different name within a period of 3 months by passing ordinary resolution in a general meeting. Again, same concept. If central government felt that no, then they will not order to change the name of the company. Did you all understand the whole scenario of the section? Everyone? Like this only they are asking questions. They are not asking direct questions in exam. They are creating case studies. Comprehensive questions are coming in exam. Okay. Next. Alteration also I will complete. Then I will give 1 minute time for you to read rectification and alteration. Alteration of name. Approvals required. First, board of directors have to approve the alteration of name. Next, shareholders by passing special resolution general meeting. Central government approval is also required. Why central government approval? If the altered name is offensive, if the altered name is too nearly resemble, if the altered name contains any government patronage, that's right. CG approval is mandatory for altering the name. Okay. But when you go for rectification time alteration, mistake is with the government, special resolution not required, ordinary resolution. CGA permission not required. Anyway, CGA ordering, no problem. Exemption from CG approval. Listen, very important. My company is a public company first. ABC Limited. I wanted to convert it into ABC Private Limited. Now ABC is same na. Public became private. And the limited ki I added private. That's all. I did not do any change. Or my company is ABC Private Limited. Now I wanted to change it to Public Limited. I wanted to make ABC Private Limited into Public. I will remove the name Private. And name, two things will be there. Okay, name has 2 parts. Suffix, prefix, suffix. Suffix, limited, private, limited, all these things will be there. Already we read. Private limited, public company limited, 1% company, OPC Section not required as a suffix. Body of the name is called as a prefix. A prefix already we read. Name should not be similar, identical, etc. A prefix discussion we are going to do now. Whenever I say alteration, prefix alteration, not suffix alteration. Sir, prefix is not getting altered, only suffix alteration. Then central government permission is not required because what is offensive, what is unreasonable in that? So, when only the change is addition or deletion of private at the time of conversion, central government approval not required. Shareholders permission, board permission is required. CG permission not required. Other compliances. Comply with section 4.2. Name should not be identical, all those. Next, section 13. Section 13, we will read section 13. And file a copy of special resolution and altered memorandum with ROC. Duty of ROC, make the changes in the register and issue fresh certificate of incorporation with the new name. Okay. Now, first of all, 2 things I am expecting from you. 1, in the live chat, please give me 1 yes, did you understand or not? Once you understood, then I will give 1 minute time for you to read this entire document. Okay, bye everyone. Yeah. Please read this. Everyone completed? Okay, next. See here. So all the concepts relating to the name clause were completed. Let us now move on into situation clause, precisely also called as a domicile clause. Okay, all about the registered office. Section 41B, read with section number 12. Let's see. Contents. What will be there in the situation clause? state where the company is to be situated. It will not contain the complete details of the place. It contains only the name of the state. Next one, registered office and the rules. Let us say, whenever you incorporate a company, just now means, when we started with preliminaries, I told you, company will get incorporated. Company will get incorporated. After company getting incorporated, we will start one registered office, because registered office to have, first you need to enter into agreement with the landlord. Okay, in whose name? Company name, because company members are different. It's a separate legal entity. So company has to enter into a rental agreement or a lease agreement or some agreement with a landlord. That can happen only after company gets incorporated. Therefore, I can't tell where my location of registered office is there in the memorandum when I prepared before incorporation. Therefore, I will tell only the state. I will tell Andhra Pradesh, Tamil Nadu. I can tell the state name. Exact location I can't tell. That's why we don't provide any kind of details like that. But within 30 days of your incorporation, you have to establish a RO. Not just 30 days like establishing RO. You should file a declaration with the ROC saying that yes, we formed registered office. You can now come for verification also. That also should be filed within 30 days. So within 30 days, two things: establish and file the verification form. And other contents, other issues. Listen, what are all the other issues? Whenever you have a registered office building, on that building, four things will be there. Details: name and address of registered office. Name and address of registered office. Place: outside every place of business. Name and address of the registered office outside every place of business in a conspicuous position with legible characters. With a conspicuous position in a legible, conspicuous means everyone, when for example building is there, building has the four walls. Outside to the main entry gate, you should put the board. Backside I kept. Who will come and see that? Conspicuous means it should be in a seeable position. Means when a person is moving on the road, when he see, that should be visible to him. Second thing, board is on the front gate only, but letters I can't even understand what he is writing. Legible English characters you have to write. So only English, local language and English. English is mandatory. Okay, local language and English. Sometimes you can also use other languages, but generally they will write one in local language, second one in English. Okay, now if in that locality English is not in prevalence, now you can use a different language, but local language is mandatory. So start. What should be there? Wait a minute. See here. Paint or affix. Paint or affix. Outside every place of business. What you have to paint or affix? Name and address of registered office. Mode: conspicuous position with the legible characters in two languages. Local language, any other language. Next. Second thing. Company will have a seal. On that seal, name of the company should be engraved. Because seal is this much. On that registered office address, how will you paste? Only name of the company, XYZ Limited, seal. Next. Print. Where to print? Print on business letters. Means communication letters. With one XYZ wanted to communicate with another business. That letters. Invoices. You know what is an invoice. Bill heads. Okay. Notices. Official publication. On this, letterheads you will print. There you should write full details. Name, address, SIN, corporate identity number. I will tell you what it is at the end of the chapter. Phone number, fax, email ID, website address. Everything you need to print on these. Okay. Next. Also print name of the company on negotiable instruments. Check is there. Every time I need not write the name of company. In the name of the company, you can take the check. On check, you should print the name of the company. Name. Check, register office address, all these things are not required. Actually, this part is there in section 12, register office. But most of the concepts are not linked to register office here. Okay. Because the first point the register office is involved, they kept like that. Anyway, that is not required in our revision session. Regular class we can discuss about all those things, but try to understand the concept. What will be there in the name clause? What will be there in the register office clause? State where the company is situated. State where the company is situated. Now, register office and rules with respect to RO. Establishment of RO. Within 30 days of incorporation, we have to establish an RO. Within 30 days of incorporation, we have to establish a RO. Not just that, you have to file a verification with ROC. Other issues, disclose others. What are those? Paint or affix, name and address, outside every office, every place of business. For example, my company is having 10 branches. 10 branches outside, you need to paint or affix name and address in conspicuous position in a legible characters, local language and any other language. Name should be engraved on seal. Print on all business letters, billheads, invoices, letter papers, and any official publications, every detail about the company. And on negotiable instruments, name of the company. Everybody, please answer section 12. Everyone understood clearly? Okay, done. Next one. Some are asking for the break. I will give you. Let me complete all the clauses of memorandum first. Okay, I'm seriously telling you, it will not take more than 10-15 minutes to complete all the clauses, because once the situation clause and objects clause is completed, other clauses will take 2 minutes to complete, because there is no great thing in that. There is no alteration concept in that. So 1-2 minutes we will complete. Are you okay? I can take for another 15-20 minutes and complete first. Yeah, so let us start. I will give break once all these concepts are done. I will only voluntarily give you the break, you can take. Okay, let us see. Shifting of registered office. It is a super chart here that I prepared. Shifting of registered office. There are 4 shiftings. Place to place within the city, city to city within the state, ROC to ROC within the state, state to state. Approval number 1. Let us read. Okay, let us read vertically. I wanted to change from one place to another place within the same city. Then board of directors at a board meeting has to first approve that. Approval to shareholders, not required. Alteration of MOA required, not required. Any special confirmations required, not required. Any CG approval required, not required. What is the duty of ROC? Register the change. That's it. Register the change. Next. No, sir, I am changing from one city to another city. From Hyderabad to, say for example, I am shifting from one place to another place. I am shifting from Vijayawada to Visakhapatnam. Okay, from Vijayawada to Visakhapatnam, or from Visakhapatnam to Vijayawada. Same Andhra Pradesh state. 2 cities are changing now. Now, in this case, what to do? Let us try to understand. First, board of directors, board meeting, they have to approve. Shareholders shall pass a special resolution in general meeting. Next, alteration of MOA not required. Why not required? State is not changing. Why? MOA, what will be there? State name will be there. So, MOA has to change, means state has to change first. Since the state is not changing, MOA alteration is not required. Special confirmation. No special confirmation required. Next. Sir, any central government approval required? Not required. What is the duty of ROC? Register the change. Next. Sir, no, sir. I am not changing just like that. I am changing from one ROC to another ROC. Give example. Sir, I am changing my ROC. I am changing my company from Chennai jurisdiction to Coimbatore jurisdiction. Chennai one ROC is there. Coimbatore another ROC is there. State is Tamil Nadu. ROCs are different. Now, in this case, I am shifting my company from Chennai city to Coimbatore city. Now, tell me. Shifting is made within the state or beyond the state, or beyond the state shifting happened. Sorry, I'm very sorry. Within the state, beyond ROC shifting happened. In this case, board of directors have to approve at a board meeting. Shareholder special resolution at general meeting is also mandatory. SH shareholder, SR special resolution, GM general meeting. Example, you have to write it as a sentence. Approval number 1. Obtain the approval of board of directors by passing a resolution at a board meeting. Obtain the approval of shareholders by passing a special resolution at a general meeting. Alteration of MOA is not required because there is no change in the state. Special confirmation is important. RD has to confirm the shifting. Who? RD. Why RD? Because he is the head of ROCs. You are shifting ROC to ROC, that RD has to confirm. So, confirmation of RD. Number 1. Company should go for RD for confirmation. I repeat. Company should go to RD for what? Confirmation. Now, what RD will do? RD will issue confirmation to the company within 30 days. Repeat again. Repeat again. Company, confirmation of RD. Company should apply to RD for what? For confirmation. RD shall issue confirmation within 30 days to the company. Company applied to RD for confirmation. RD will issue confirmation within 30 days. Either yes or no. RD said yes. That confirmation should be filed by company with ROC in 60 days. ROC will register the change within next 30 days. So 30, 60 and 30. Company to furnish to RD time limit is not there. You apply for confirmation. Once you apply, RD will reply within 30 days. If it is a positive, send it to ROC within 60 days. ROC will register the change. New ROC is there, he will register the change. Old ROC ki cut, new ROC ki open. That will happen. Understood? So see the chart once. 2 minutes time. Everyone, are you comfortable with the chart up to here? Okay, done. Next one. See here. So we completed place to place, city to city, ROC to ROC. ROC to ROC, central government approval required? Not required. Required or not required? Not required. Again, ROC shall register the change. Okay, done. Now the last and final one. I want to change from state to state. Now memorandum alteration also happen. See, that's why in this section 13 doesn't come. In this section 13 also will come. 13 is the memorandum alteration. Okay, so what will happen? First, board of directors board meeting, shareholder special resolution. Alteration of MOA required? Yes, required. And next, any other confirmation? Not required. But CG approval is required. See, company will apply to CG. CG will give its approval within 60 days to company. But to give this approval, any of these three conditions you should satisfy, or any of these three. What are the three? You are jumping from one state to another state. Okay. Happily you are in Andhra. Now you are going to Assam. Yanta Assam. So if something happens, now people have to come and reach an accessible place like a registry office. Vijayawada, Visakhapatnam, like the good cities when they are, you are shifting directly to Assam, Anta Assam. So you are shifting the registry office from one place to another state directly. Okay. Maybe your intention is to escape from the creditors. You might have taken loan from a bank in Vijayawada, jumping to Assam, such that they can't easily come to your registry office. Might be that is your intention in shifting the RO to one state to another. Therefore, three conditions, like any one condition you satisfy, then central government will issue its approval. You can change the register office from one state to another. What are the three? Either take the consent of creditors or a debenture holders and person concerned. Take their consent. Sir, they don't give consent, sir. Okay. You are confident that they don't give consent, na? At least do one thing. Balance sheet, show me that, sir, this is the creditor balance. For that, already this much of provision is created to pay them, like DRR in case of debenture redemptions. Debenture redemption reserve has to be created. Na? Debenture holder is a creditor. You show debenture redemption reserve. Sir, debenture holders are 100 crore. DRR, already 60 crore is there, sir. Sufficient provision is created. At least show that. Sir, ours is a normal loan, sir, not not debenture to create a DRR. Okay, then at least do one thing. Loan taken from SBI, 100 crores. Okay, secured and secured. Asset, yes, sir, asset. Where is our asset? Asset is in Andhra Pradesh only. Vijayawada only asset. Very big land, sir. Amaravati, we are having hundreds of acres of land, sir, for capital. We gave that as a security to them. Understood? Huh? We gave that as a security directly to the loan. SBI, we gave loan as a security as a loan. Okay, 150 crore land is available, sir. That we have given already as a security to them. Oh, okay. Though you don't take consent, though sufficient provision is not created, at least adequate security is created enough for the debt, sir. I will give you permission. If any of these three conditions are satisfied, CG will approve and give notice to both the ROCs of the state. Old, new, or old, you leave him, new, you catch him. They will give, central government will give order to both of them. Then ROC of the state to which RO is shifted and a new ROC shall register the change and issue fresh certificate of incorporation. Everybody answer, understood the point clearly or not? Everyone understood? Yeah, done. Next, give me 10 minutes time. We will complete objects and other clauses of memorandum as well, and we will close. See, objects clause. Again, there are two parts here. First, contents of objects clause, alteration of objects clause. Contents. What it will contain? Objects clause will contain the object purpose for which the company is proposed to be incorporated. Approval 1. Okay, that is the main objects clause. Alteration of objects. Hey, listen. Alteration of objects, two sections will get attracted. Section 13 and section 27 also. I merged both here and I kept. 27 is in prospectus chapter. Again in prospectus I won't cover. Today only we are going to cover. Na? After incorporation, what is the next chapter? Prospectus. At that time I won't repeat again. Okay. So I will discuss here. That's all. Once for all. Completed. So see here. Whenever you wanted to change the objects. Okay. Two simple concepts you remember. General objects you wanted to change and a main object. So whatever the objects in the memorandum you wanted to change them. For that one procedure is there. What is the procedure? Just board of directors, board meeting, shareholder special resolution. That's all. Over. Okay. File the altered memorandum copy with the ROC and ROC will register the change. Game over. When the problem will come, when your company is a listed company, you issued prospectus, took money from public by saying that you are using this money for this object, and those objects you wanted to change and money is still unutilized. Tell all the conditions. There is a listed company which has raised money from public by issue of prospectus, by showing some objects, and money is still unutilized. Now you wanted to change the object. Means the purpose for which you issued the prospectus and said that purpose and the purpose for which you are now doing, both are same or different? Are different. I will not agree for that. For that, big compliance is required. What is the compliance? Let's understand. General case. Sir, normal objects, sir, mine is a normal private company. For that, in that case, approval of board of directors at board meeting, shareholders by passing special resolution, alter memorandum, compliances. Company shall file with ROC copy of special resolution and alter memorandum within 30 days. File it with ROC. Next, ROC shall register the change and certify within next 30 days. Okay. Objects clause change do not require CG approval. Very, very important note. Next. Alteration of objects clause, second part. General case. Special case. Applicable to whom? listed companies, that too public. Okay. What this public company have done when applicable? This public company accepted money from public by issue of prospectus. Amount is still unutilized. Repeat again. What are the three things? This listed company has accepted money from public by issue of a prospectus. Amount is still unutilized. Repeat again. Accepted money from public by issue of prospectus. Amount is still unutilized. So there is a listed company which has accepted money from the public by issue of prospectus and amount is still unutilized. At that time, you wanted to change your objects. Then approval 1, approval 2, same. Board approval, shareholders approval, same. Next, compliances are there. Give advertisement in 2 newspapers, English and local vernacular language, and give exit offer to the dissenting shareholders. Some shareholders say special resolution is to be passed to do that. Correct? Approval 1 and approval 2. Approval 2 is shareholder special resolution. Special resolution, 3/4 approval is required. Okay, votes cast in favor should be 3 times again more than votes cast against. Means if 1 vote is against, 3 votes should be in favor. And 4 votes, 3 should be in favor, 1 can be against. 3/4 approval is required. A balance 1/4, those people are called as a dissenting shareholders. Meeting case, some people did not attend. Those people can never become dissenting shareholders. Like this question can be framed in exam. Who is dissenting? Meeting conducted, we passed the special resolution, participated, voted against, but 75 voted in favor. They qualified that. Therefore, alteration of objects clause is happening. A balance 1/4 are there. Na? They should be given dissenting. They are called dissenting shareholders and will be given with an exit offer to them. Some people sat at home and happily slept. For those people who do not even continued in voting, they are not given the chance of getting exit offer. Did you understand how they can ask a question in exam on this? So next, other compliances, same in general case, remaining. File it with ROC, ROC will issue certificate of incorporation. That's it. Next, other clauses. Liability clause. Company limited by shares. Means what? Liability of the members will be limited to the extent of unpaid amount on shares. Guarantee given which they contribute at the time of liquidation. See, I will fastly complete one word. Foundation, you might have already read this. I don't want to waste time on this now. See, company limited by shares, shares are subscribed. If there is any unpaid amount, to that extent I will be liable. Public offer started. 10 rupees the price. 7 rupees I paid. 3 rupees unpaid. I subscribed for 1000 shares. My liability is only 3000 now. 1000 shares into balance 3 rupees. Winding up happened. I am not responsible for more than 3000. Guarantee. Okay, guarantee company. Guarantee company ke liability of the members will come only on liquidation. But company limited by shares, liability of the members can come even before winding up. IPO time I am getting liability to pay the call money. Na? Company when liquidation I will get. So, in case of company limited by shares, liability of the member can arise either at the time of liquidation or even before. But in case of company limited by guarantee, liability of the members will come only at the time of liquidation. Next, capital clause. It will contain the capital which STM undertake to subscribe. Okay, it will be divided into number of shares and amount. Next one, association clause. It contains names of STM. 1% company, it contains the nomination clause. Okay, everybody in the class, did you all understand up to here clearly? Yeah, everyone. Done. Now we are done with half incorporation chapter also is completed. Balance half we will complete and then we will be going into the next chapter called as prospectus as per our schedule. Everyone clear? Everyone? Yeah. 2 o'clock we will reassemble again and start. Okay, we will reassemble back at 2 o'clock exactly. Okay, 2 o'clock we will start and we will try to first complete incorporation and then we will be going into the next segment called as prospectus of a company. Okay, thank you. See here, articles of association. We completed memorandum of association and all its clauses. Now we are coming into articles. Articles do not have any kind of clauses. Articles do not contain any clauses. Article contain regulations. Memorandum of association will contain External regulations means what? When anyone is contracting with the company, they should know what is the company name, where it is located, what it can do, liability, capital, and STM, subscribers to memorandum. Articles will be more important than memorandum once the company starts its work. Okay. See, I will give you an example this way. Wait a minute. Okay. See here. Memorandum of Association is the external skeleton of the company. Articles of Association is the internal organs of the company. Day-to-day working will be dependent on that. So now we are going to discuss about the concept of Articles of Association. Okay. Definition. Already we read, repetition, that's all. Articles of Association means Articles of Association as originally framed or as altered from time to time. What are the characteristics of articles? Section 5. Basics. It contains regulations for management. This is internal regulation. Okay. Next. What is this model articles? Companies need not prepare their articles on their own. If they want, they can prepare. Okay. Or Companies Act in Schedule 1. Companies Act has 7 schedules. Na? 7th schedule CSR. First schedule is a pro forma of Articles of Association. There are tables called as table A, B, C, D, E, F, G, H, I, J. A, B, C, D, E, basic pro forma of memorandum. You have to write everything. But F, I, G, H, I, F, A, B, C, D, E, na? F, G, H, I, J. These 5 are articles pro forma. So the format of articles of different kinds of company. Company with share capital, table F. Company without share capital, okay, G. Like that the tables are given. Exam ki F table is important. So see here now. Model articles and its impact. What is model article? If your company could not prepare its own articles, nothing will happen. Automatically, whatever is said in the model articles will automatically apply. Okay, whatever is said in model articles will automatically apply. If your article failed to say something, so if your article says something, I will follow that. If you do not write anything, what is given in Schedule 1 model articles, I will follow that. What you understand from this? Companies can afford to write their own articles, option 1. Then table F do not apply. Some companies will tell, we don't write our own articles, we take full table F. That also possible. And mix also possible. I will write some provisions on my own. Remaining you can adopt from table F. Anything you can do. So table F is called as a model articles. Means what? Generally articles can be like this. If you want to deviate from this, yes, you can deviate. Write your own articles. Understood the point up to here? So model articles and its impact. It provides for matters for management. Same. And they are provided in table E, F, G, H, I, J in Schedule 1. Additional regulations in addition to model articles can be provided. Means model articles are there. 91 points are there. Along with that 91, you can add also, no problem. Company may choose to adopt all regulations of table F. All or any. There is a or here. All or any. Means what? You can provide for all table F. You can provide any of the table F provisions. Or you can take table F and add others also. No possible. No problem. So 91 are given. You can add some others also to that. Next. Entrenchment concept. First point. I will repeat. Articles of Association means Articles of Association as originally framed or as altered from time to time. Basics. Articles will contain regulations for internal management of a company. Model articles. It also will provide for management of a company. Table F to J. And you can also provide for additional articles in addition to table F. And you can choose any or all the provisions of table F also. Next. Next one is entrenchment of AOA. What is this? Entrenchment of AOA. Chance is there. This can come in the next exams. Chance is there. From this chapter, entrenchment provisions can be asked in examination. Okay. So listen carefully. See here. I will first explain. Articles of Association is for internal management of company. Who will take care of management? Board of directors. Sometimes board of directors can misuse the powers given in the AOA. Misuse the powers given in the AOA. First, let me explain one concept. Okay, first see this. Alteration of AOA. First, you read this. Alteration of AOA. First, read this. Whenever you wanted to alter AOA, board of directors should take a decision first. Shareholders by passing special resolution. Okay, comply with the act, comply with memorandum. What do you mean by that? Anything you write in the articles by alteration, it should not override memorandum. Example, memorandum of association, clearly I have written that borrowing cannot be made by company, only own financing. Borrowing is not allowed. Means borrowing from outsiders is allowed or not allowed? As per memorandum, not allowed. Articles I have written that borrowing can be made by board of directors up to 1 crore. There I said you cannot do. Now you are saying up to 1 crore board of directors can do, means what you are trying to tell? Therefore, it should comply with act. Alteration should, as per the provisions of Companies Act, it should also comply with memorandum. And you pass the special resolution, file the copy of special resolution with ROC within 30 days. Okay, ROC will register the change. Simple. So what you understand from this? Articles of association can be altered by special resolution in a company. Okay, therefore problem started. What is a special resolution is a question. General meeting will be conducted. In my company 10,000 members are there. 100 attended general meeting. This 100 are having, okay, 10,000 shares. 10,000 members are having 1 crore shares. In this 10,000, only 100 attended. Those 100 are having 10,000 shares. Okay. In this 100, 76 said yes for alteration. Okay. Balance 24 said no. Now resolution is passed. Sir, 10,000 lo only 100 attended, sir. Those 100 will take a decision and alteration will happen. Yes, it will happen. Law will say a simple thing. Who stopped these 10,000 from coming to meeting? Did I stop them? It's their irresponsibility of not attending the meeting. Later you can't cry on me. That's the whole logic behind this particular concept. Means what? Meaning is very simple. Meaning is, whenever there is a company conducted a general meeting, attended persons lone we will take resolutions approval. 10,000 la 75% no. Meeting ke attended 100. 100 la we will see special resolution. That's the problem with a special resolution always. A special or ordinary, anything. So what is the problem here? Articles of association, alteration require special resolution which considers only minor shareholders approval. Minor means not age-wise minor. Small group of shareholders approval we will take. You are altering articles of a company from where the board derive the powers. Board will get the power from articles. That articles will be shifted now, changed now. This is a serious issue in a company. Therefore, law said like this. Articles of association will be there. Okay, I repeat. Articles of association will be there. This is like a house. Articles of association is like a house. In this house, veranda is there. There we will leave slippers. Inside you go. There we will put television and flower vases, sofa sets, etc. Normal, moderate cost. Inside there is a bedroom. In that we have a locker. In that locker we kept gold and other ornaments. Okay. House A. House la 3 parts are there. Veranda, living room and a bedroom. Veranda, least importance. Okay. Veranda. Access can be taken by anyone. Anyone who come to our house can have access to veranda. Whom we allow will have access to living room. Whom we allow, give the keys and surveillance, that person only can touch this gold locker. Correct or not? We will put lot of restrictions. Everyone, if our friends come to our home, directly they will go inside. 90% of the cases they stay only in the living room. Unless and until we take them, they don't come to any kind of other rooms that we provide. And that too, if they come, they will just sit, they will see the house and they will go. They won't open the lockers. We are putting lot of surveillance on that gold storage. Same concept. Company is house is like an articles. Articles there are three kinds of provisions: slipper type of provisions, living room type of provisions, golden shelf type of provisions. Some provisions or regulations in the article should not be given easy access to alter them. Easy access to alter them. For example, borrowing powers. What powers? Yeah, borrowing powers. Company will be affected by excessive borrowings. Why? If borrowings are increasing, debt will increase. Debt increases, fixed interest commitment will increase. It will affect the equity shareholders of the company or not. Board of directors, just like that, calling for meeting, altering the articles. Okay. Memorandum of association, I said, loan can be taken. Now can be taken. AOL, we clearly said, board of directors can borrow up to 1 crore only. Anything beyond 1 crore, shareholder special resolution is required. Like this we have written in the articles. You have to follow that or not. Now what board of directors are doing? They are calling some group of shareholders silently and said that I will call for a meeting, increase this limit from 1 crore to 10 crore, they said. Now both will borrow whatever they want. 10 crore rupees is damaging to my company. Therefore, 91 regulations are there in table of articles. In that all 91 are not of equal importance. Some are slipper provisions, some are living room provisions, some are golden shelf provisions. A golden shelf provision we will put surveillance. A surveillance entrenchment. Entrenchment means we will create a fence to that. Easily you should not be given a chance to alter those points inside the articles. 91 and 91 I will not put. Or 7 to 8 provisions in articles should not be altered. I am not telling. Should not be altered easily. Should not be altered. I am not telling. Should not be altered easily. Means what? Normally alteration of article require which resolution? Special resolution. Entrenchment once done, we will increase the restrictions to alter AOA, which will be more restricted than special resolution. For example, in my company, how many are there? 10,000 members. Meeting, how many came? 100. Special resolution means what? 75 should say yes. Correct? No, I will not agree with this. I will tell entrenchment required 75% of the members' approval. Means what? 10,000, 7,500 should say yes in order to alter that part of the articles. Now tell me, this is restricted lesser than special resolution, more than special resolution. If I tell 75% of the total number of members should agree, means it is less restricted than special resolution, as restricted as special resolution, more restricted than special resolution. I'm waiting for your answer. That's the logic. So, the articles of association divided into 3 parts: less important, important, most important. 91 are there. Let us say we adopted table of directly. 70 comes under this. 10 comes under this. 11 are coming under most important. Entrenchment I will create for these 11. Entrenchment is what? You can alter, but alteration of this will require provisions or regulations more restricted than special resolution. Sir, what is this more? That depends. In our example, 70% of total number of members, I said. Like that you provide whatever you want, but it should not be lesser than SR. It should be more than SR. Next. Sir, understood, sir. Over, not it over. Shall I tell you why? Listen. What I said, once I create entrenchment, those entrenchment provisions are there. Na? Those if you wanted to alter, it requires more provisions than special resolution, more restricted than special resolution. But to provide this red color box, what should be done? We discussed about how to alter the entrenchment provision now. So I want to create entrenchment. How to create? It depends on when you are doing, which company you are doing. Okay, two situations. When you are doing, which company you are doing. Sir, I am doing at the time of incorporation itself, sir. And when you prepare spice form and submit AOA MOA to ROC, at that time I said in this 91 these 11 are entrenchment. If you tell like that at the time of incorporation, no approval required, directly ROC will approve that, and he will tell, okay, these 11 provisions are entrenched. Alteration requires 70% approval of members or something like that, whatever you provide. So entrenchment provided at the time of incorporation is not a problem. Okay, but entrenchment provided after incorporation depends on type of company. My company is private company, my company is public company. Private company require unanimous approval, means all shareholders has to agree to create entrenchment. Okay, public company requires special resolution. Sir, you said more than special. More than special is to alter, to create that entrenchment after incorporation. Private company unanimous approval, public company special resolution is required. Everybody in the class understood the entrenchment clearly, yeah? Everyone. Now read this. Entrenchment of AOA. Read the parts carefully. Imposing conditions on alteration of AOA which are more restrictive than special resolution. If you are putting the entrenchment provisions at the time of incorporation, no approvals. After incorporation, private company ki unanimous, public company ki shareholders by passing a special resolution in a general meeting. If you are thorough up to here, let me know. We will go into the next segment. Everyone reply. If you say yes, we will continue further. Okay, done. Next one, conversion cases. Company gets converted into one case to another case, and a private to public, public to private, one person company to public, any kind of conversion. Okay, basic conditions. Conversion cases. Any class of company into any other class. Okay, first, whenever you wanted to change the class of your company, point number one, alter your MOA, alter your AOA, pass a special resolution in a general meeting, take the approval of board of directors. Okay, board of directors and special. So, first board approval, shareholders approval, alter MOA, alter AOA, because you are changing the entire company, na, everything you have to change. Okay, compliances, section 14 and section 18 subsection 2. Okay, what they said, let us see. Section 14, additional conditions. Conversion, private company into public, public company into private. Okay, next, conditions as prescribed in section 18, all these four, plus type of conversion, private to public. If you are converting private company to public company, then what will happen? Already we read at the definition stage. Private company will contain restriction on transfer of shares, limit the total number of members to 200, prohibit the public subscription of securities. Correct? So when you are converting your public company to private, we will add restrictions. When you are converting your private to public, we will remove the restrictions. Other restrictions, limitations, and prohibition. See, private to public, if you are converting, they no longer impose restriction, limitation, prohibition. Now, public to private, they shall include restriction, limitations, and prohibitions in the articles. Central government approval is required only when the conversion is made from public to private. Private company to public company, if you are getting converted, central government approval is not required. But what is required? Public to private required. Reason is very simple here. Public company, you can have 1,000 members, 5,000 members also. Private company, you should have only 200. How you are going to settle for the balance people? For example, my public company has 5,000 members. Now I am converting it into private. Private ki 200 allowed. How you are going to settle that 4,800? Big problem will come. That's why central government will involve when the conversion is from public to private, not private to public. Okay. So section 14 la normal conversion, public to private, private to public is there. Any conversion first require board approval. Next shareholder special resolution. Next alter MOA. Next alter AOA. Next condition. Company shall file copy of special resolution, copy of altered articles, and CG confirmation, whatever we said, with the ROC within 15 days. Now your company is converted. Okay, public to private, private to public, or some other case to another case converted. So now listen carefully. What people can do? XYZ Limited borrowed money from bank. XYZ Limited borrowed money from bank. It got converted into XYZ Private Limited. Okay, Private Limited. Loan is taken by XYZ Limited. Now I am converting into XYZ Private Limited. Bank came for loan recovery. I said, go and ask XYZ Limited. It said, sir, it's not there. Then we will not pay. Like this, we should not do our action. That's what he wanted to tell. Once a conversion happens, debts and obligations shall continue in the name of converted company. Okay. Very, very important one is conversion of OPC into Section 8 is not permitted. Conversion of OPC into Section 8 is permitted or not permitted? Not permitted. Everybody please answer. Understood this chart clearly? Simple chart. Let us not spend time and waste our time. If you are okay, we'll go into the next one. Okay, done. Next, see here. Doctrines under Companies Act. Listen, before itself, I am giving a disclaimer. Doctrines is a foundation syllabus. I am not going to discuss now and waste our time. Doctrines, foundation syllabus, construct notice, indoor management. What I will do is, at the end of our sessions, revision sessions, 10-15 minutes I will spend time on all the doctrines together. Are you all okay with it? Let us complete entire Companies Act first. Okay, when you are completing Companies Act, entire revision classes are over. Last 15-20 minutes I will spend on doctrines. Are you clear? So let us not unnecessarily spend time on something which is already dealt in CA foundation and waste our time. Okay. Next. Yes. From now, whatever discussions I am going to make, okay, section number 15, 17, 10, okay, next section number 10 continuation, section number 10 continuation, and section number 6, 19, 20, 21, 22. Okay, from these definitely exam la one question will come this time. Simple topics, quickly completed, but very important for exams. See here. From now, spend good time to understand all these concepts and complete. Okay, first one, alteration of MOA and AOA to be noted in every copy. Concept is simple na, 1 minute. Complicated na, I will spend 3-4 minutes. That's all. There are around 10 sections are there. 45 minutes is the time. You have to complete it by that time. Okay, let's begin. Miscellaneous concepts on MOA. Alteration of MOA or AOA to be noted in every copy. Section number 15. General provision. Any alteration made to MOA or AOA shall be noted in every copy. Sir, what does this mean? You altered memorandum, you altered articles. Okay, company already have 50-60 books of AOA and MOA printed already. Okay, now alteration happened. Those should never be given again. Whenever you are giving any MOA to any person who asked for it, it should contain all the alterations. It should be noted in every copy you give, or else punishment will get attracted. See here, company and officer in default shall be liable to a penalty of how much? Rupees 1000 per every issue. Next one, copies of MOA or AOA to be given to every member. Section number 17. Sir, what is this? See, if any member requested for a copy of MOA and AOA or any agreement copy under 117, when we come to 117 section, I will tell you. Then within 7 days of the request, you should send them. So if any member asks for MOA or AOA or agreements under section 117, company should provide them within 7 days of the request. In default, 1000 rupee for each day, maximum 1 lakh rupee penalty will be levied on the company and officer in default. Everybody understood section number 15 and 17 clearly? Yeah. So whenever alteration happen, every copy printed after that should contain that alteration or its punishment. Second, whenever any member requested for any kind of MOA, AOA or agreements under 117, company must submit them within 7 days or else again punishment. Everybody understood the concept clearly? Can you go to the next one? Okay, now see here, impact of memorandum and articles. Okay, MOA and AOA shall be important examination expected question. One of the expected question is section 10. Section 10, this we have to read. Okay, this also we have to read. This page also we have to read. Let us see. Effect of MOA and AOA. Sir, what is effect of MOA and AOA? Sir, what is the meaning? Listen. Whenever company prepares a memorandum and articles, okay? Whenever company prepare memorandum and articles, when company will prepare memorandum and article, at the time of incorporation, they will prepare. Listen carefully or else you can't understand. Okay? Listen. For example, there are so many people sitting in live now. Okay? We all entered into agreement, some agreement, written agreement. When you will say that I entered into agreement, when you sign on some document, whatever is there in the document, you are agreeing for that. Correct? For example, I signed on MOA. That means I am agreeing for all the contents of MOA. There is something in AOA. That means I am agreeing to whatever is there in AOA. From this, what is the moral of the story that you have to understand? My liability will be there only if I sign. If I don't sign, my liability will not be there. That means, for example, if there is a terms and conditions sheet, on that I did not sign, you signed, then you will become liable. I will not become liable. Why I will not become liable? Because I did not sign on that. Now let us understand one point. MOA and AOA are prepared at the time of incorporation. Capital clause, association clause is there. I told you most important. Association clause, who will sign? Subscribers will sign. Once the subscribers sign, association clause will close, company will come into existence. Okay. After that, company will grow leaps and bounds. It will go for public offer. It will become listed company. All this drama will happen at a later stage. But it starts with a simple 7 group of people in case of a public company. They will sign on association clause. Use common sense now. Morning I told you one logic. What is that logic? Whenever you are becoming shareholder by purchasing shares in stock market, company don't even know that you are a member. Okay. That means company is not giving you memorandum articles. Koushik Mukhesh, sign on that and then become a member. I will become member not by signing on memorandum. I will become member by purchasing the shares in the market. Purchasing the shares in the market, I will become a member. Correct or not? And my name will be entered into the records of depository. My name will be entered into the records of what? Depository. Okay. That is the idea behind the concept. From this, one concept started. What is the concept? Let me explain. So, the simple logic behind this is, every member of a company, for example, 2020, my company started. I am one member, you are another member. Private company. I am one member, you are another member. Or I am one member, you are all 6 members, other members. We 7 started one public company. Very good. We 7 signed on association clause. Fantastic. Later, 2020-25, now, today, on November 28th, on November 27th or 28th, whatever the case may be, we made public offer. Another 5,000 members joined us. These 5,000 members did not sign on MOA, AOA. They became members by subscribing to the shares, not by subscribing to memorandum. Okay. So totally 5,007 members. 7 signed on memorandum. Remaining 5,000 did not sign on memorandum. Now, liability to follow what is there in MOA is with the 7R, is with 5,007R. Liability to follow what is there in MOA, AOA is with the 7R, 5,007R. Everyone. Okay. See here. So, liability to follow is only with 7. Okay. Is with 7 only. Because those 7 are really signed. Remaining members, they did not sign physically. However, section 10 makes it a deeming fiction is created, saying that even though other members of the company did not physically come and sign on the memorandum and articles, even then they are liable for all the contents of MOA and AOA. That section 10. Repetition one more time. Originally, memorandum and articles has been originally actually signed by subscribers to the memorandum. There are 7 members. After the company went for public offer, new members came. Those all subscribed to shares. They didn't sign on MOA. Actually, signing is done only by 7 members. 7 members should become liable. But lawmaker will not tell that way. Even though sign is actually made by 7 members, I will treat as if MOA and AOA respectively had been signed by company and each member, though you did not actually sign, I deem that you also signed. All 5,007 members of the company will be liable for what is there in MOA, AOA. What does it mean? This is constructive notice for members. Doctrine of constructive notice for members. Mean one of the member who subscribed shares on public offer should not tell, "Ayyo sir, I don't know what is there in memorandum and articles. I did not sign them. I did not read them. That's your mistake." There is a section under Companies Act called as section number 10. which will create a binding effect of memorandum and articles with the members of the company, whether you are STM or a non-STM member. Did you understand the point or not? Everyone. Everyone understood? So, whether you really signed or not, who asked? I did not ask reality. I asked, are you a member? Yes, sir, I am a member. That's all. You have a liability as if you are the subscriber. As if. Deemed. You are a subscriber. So, what is the obligation of a member? Member obligation is to observe all the provisions of MOA and AOA. Okay? All the provisions of MOA and AOA. Company made a call. You have a liability to pay or not. That's why. Amount due to the company as per MOA and AOA shall become debts due and shall be paid. So it become a debt due by the member towards company. That's it. This is the effect of MOA and AOA. Listen, here write down somewhere, and if the chart material is not with you or the copy is not there, nothing will happen. I can share at the last. But what you have to do is, effect of memorandum and article section 10 is there na. ISM they have given case examples. What they have given? Case examples. Means case studies type they have given. How many? 4 case studies they have given. Must read. Concept you understood na? They gave 4 case studies. Where? ISM. They can come directly in exam. Chance is there. So now I am not going to take all those things and spend our time on that. That's your duty. Again, I am telling you, if you don't read those 4 now, section 10 key, section 10 below, study material, there are 4 case examples given in ISM. If you don't read them, they will come in exam. At that time, don't blame me. Sir, you taught this concept, but you did not tell those 4. Those 4 are case examples. Adi, you have to take care. Examples also you don't read. You should only tell an example also. I will tell concept. You read examples. So this section is incomplete if you don't read those. Concept I told na. Examples you read and understand. Okay. But I will tell you what is the summary of those examples. That's why I gave this. Other issues on binding effect. Okay. See. Memorandum articles something is written. Memorandum article something. 91 points are there in articles. Memorandum, so many things are there. Memorandum articles, something is written. Okay. Member of a company will be bound by what is contained in MOA. What is contained in MOA? Sir, what does it mean? For example, Memorandum of Association, it was Articles of Association, it was written like this. If Board of Director make a call, first call, second call, final call will be there. If Board of Directors make a call and if a member do not pay the call within 14 days, within next 14 days, we will forfeit his shares under 28 days time. Call money made, call made by Board of Directors. Pay within 2 weeks, 14 days. If you don't pay within 14 days, within next 14 days, Board of Directors by giving you a chance to pay, if you don't pay even after that, next 14 days, they have a right to forfeit the shares. They have a right to forfeit, means or cancel and give to some other person. They have a power. Who have power? Board of Directors have a power. Where it was written? Articles. I am a member. Who became a member by purchasing through stock market. Board make a call. I did not pay the calls. Now board forfeited my share. I said, "Arey board, how dare you? Enta dhairya neeku? How can you forfeit my shares?" Like this, I shouted on them. They said that first get lost, read the MOA and come. MOA. What is that MOA? MOA also you don't know, they asked. I said, why I will know that? Why you will know? You are bounded by memorandum articles. They said, no. I am not a STM. I need not read. STM will sign. I am not an STM. I need not sign. Then law says that even though you are not a member through STM route, you are a member. Section 10 treats you as if you are a STM member, though you are not an STM member. So you have to observe all the provisions in memorandum and articles. We assumed that you read it. We assumed that you know about that clause. We assumed that intentionally you did not pay. Therefore, leave the company. One point. This is called as there is a binding effect between company and members. There is a binding effect between company and members. Okay. There is a binding effect between member and company. Member bound to company. Now my example is on member bounded to company. Next. Company bound to member. Sir, what is this? How member have to comply with MOA AOA? Company also should comply with MOA AOA. Why? Put correct. No correct. Always I should be right. Eh? You will not be right. So, the memorandum articles of points are there. Okay. Member is bound by that. Company also bound like that to the members. Example I will give you. Example I will give you. Company articles of association are clearly given. Company articles of association are clearly given. Board of directors of the company, shall borrow only to the extent of 1 crore. Beyond 1 crore, they cannot borrow. They borrowed 1.5 crores directly. Now, company has to pay penalty to the members because company is not bound to members here. How I am reading MOA and following what is there, you should also read and follow like that. Third, there is no binding effect between member with another member directly. Not always. Okay. There is no binding effect between member with another member directly. Means what? Through memorandum you can create a liability again. Sir, I did not understand this. I will explain. See here. See here. In the articles of association, we have clearly written like this. If any member wanted to leave the company, he can sell the shares. When he sells the shares, existing members must buy his shares. Existing members must buy his shares. Okay, we have written like that in the articles. Now, member is bound to another member. Okay, next. There is no binding effect between company with an outsider. Sir, what do you mean by that? Company with outsider means there is no member involvement. In that case, this concept does not apply. This concept of binding effect will apply only when there is a member involved, not company with an outsider. For the case law is also given. Whenever you find time, you can read later, not now. First of all, everyone, please tell me, did you understand this concept of binding effect of section 10? Everyone. I'm giving you 1 minute time. Take 2 minutes time, no problem. But read it properly. Complete it. Everyone clear? Can you move to the next one? Everyone, are you clear? Can you move to the next one? Next, see here, incorporation sections, all the three I will keep in one set and I will complete. First, let me complete the miscellaneous areas. Okay, miscellaneous areas, the section 6, section 19, 20, 21, 22 are there. Section 6, 19, 20, 21, 22. Okay, these all sections are in miscellaneous. Let's complete. Then we will be left out with only some areas like section number 7, 8, 9. That's it. We'll complete the chapter. The biggest chapter, so one of the chapter, study material 89, 90 pages is as big like general meetings that we will complete now. Okay, are you clear? So though it is so voluminous, recent times since a question is not tested, students are under a wrong impression that this is not important. One attempt will be there, that attempt gone. Okay, let us see. Miscellaneous. Act to override MOA and AOA. Act to override MOA and AOA. Sir, what do you mean by Act to override MOA and AOA? Listen. Always remember, Act is beyond anything. Nothing can override the provisions of Act. Act is the biggest one. If in the Act itself they clearly said, articles will override this, then articles will override. Or else, always, the equation is very simple. Act greater than MOA greater than AOA. Means what? First bigger one is the Act. Within the Act, MOA. Within the MOA, AOA should be there. Okay? See, that's why. Exceptional case. The aforesaid provision shall not apply if it is otherwise expressly provided in the Act. In the Act itself, they clearly said that articles will give power to the section means, then okay. If nothing is said, Act overrides articles. Sir, give one example for where articles is overriding Act. So many, not 100 examples I can give. But I will give you one super example which you know. Buyback. In order to go for buyback, articles should authorize the company first. What do you mean by that? If articles is silent, company cannot go for buyback. Again, how to understand this? If articles is not saying that you can go for buyback, section 68 can't apply to the company. And applicability or non-applicability of section 68 being Act is dependent on articles. Now, who is overriding whom? Articles is overriding Act. Since it is expressly provided allowed, or else generally Act will override AOA, MOA. Basic concept. Act override MOA, AOA, agreements, general meeting and board meeting resolutions. Are you understanding? Any provision in any documents that is repugnant means against to it will become void. So tell me, in general, what is the point? In general, what is the point? Articles will always be within the Act only. Articles cannot override the Act. Articles cannot override the Act. So the basic concept is Act to override MOA, AOA, agreement, resolutions in general meeting and resolution by board of directors. Consequence of contravention. Any aforesaid contravention, the particular provision in the articles will become void. Exceptional case. If it is expressly provided in the Act that articles will override the Act, follow that. Nothing is said, Act only will override the articles. Next one. Subsidiary not to hold shares in holding company. Expected question, you can mark it important here. Subsidiary not to hold shares in holding company. See here, morning I discussed about this. X Limited is there. Y Limited is there. X Limited invested 70% in Y. X Limited is holding company. Y Limited is subsidiary company. This happened on 1/1/25. Okay. Next. Y Limited invested in X Limited 60% on 1/11/2025. On 1/11/2025. So X Limited invested in Y Limited on 1/1/25. Y Limited invested on X Limited on 1/11/2025. 60% capital is invested. Okay. Now tell me, who is holding, who is subsidiary? Now Y Limited will become holding, X Limited will become its subsidiary. Correct? Therefore, they said that this is not possible. Means what? Once you become subsidiary to a company where there is a holding subsidiary relationship existed, in such case, subsidiary cannot invest in the shares of holding company. Number one. Sir, I will not purchase, sir. They will only allot me shares. Adi possible? Second question. Okay. Can they allot? They also cannot allot. So, subsidiary company cannot purchase. Holding company cannot issue or transfer the securities to Y Limited. Understood the point or not? So, this is the point that you have to understand. Okay. So, again I am repeating the point. See here. Once you become a subsidiary to a holding company, subsidiary company again cannot invest in the shares of holding company. Okay, not possible. Neither I can invest nor they can issue or allot me the shares. Transfer also not allowed. Up to here understood. Kada? Now there are some exceptions. What are the exceptions to this? See, there is a company called as X Limited. There is a company called as Y Limited. X Limited invested in 70% in the shares of Y Limited. X Limited, there is a shareholder, Mr. A. Shareholder, Mr. A. Which company? X Limited. Mr. A is a shareholder. Okay. Now, Mr. A kept Y as a, Mr. A kept Y as a nominee. Y as a nominee. What do you mean by Y as a nominee? Y Limited is a nominee. If A die, A's shares will go to Y. Okay, A's shares will go to Y. I repeat again. X Limited invested at 70% in Y Limited. X is holding company. Y is subsidiary company. Okay, Y is subsidiary company. X Limited, Y Limited are holding subsidiary. What is the rule? Subsidiary should not hold the shares of holding company. X Limited has Mr. A, shareholder. For him, nominee is Y Limited. Means what? Legal representative is Y Limited. If Mr. A die, all the shares of A will go to Y Limited. So after becoming a subsidiary, A died. A's shares are now going to Y Limited. That means Y Limited is holding the shares of the holding company or not. Actually, it should not be allowed. But this is an exception because Y Limited is not holding in its name. Y Limited is holding in capacity as a legal representative. Allowed. Voting rights also will be given. Now, Y Limited will not vote in capacity as Y Limited. Y Limited will vote in capacity as a nominee of Mr. A. Not in its own capacity. Nominee capacity they will vote. So allowed. Second thing. There is a company called as X Limited. There is a company called as Y Limited. X Limited invested 70% in Y Limited. X Limited became a holding company. Y Limited became a subsidiary company. Okay. X Limited became a holding company and Y Limited became a subsidiary company. Now what happens? Let us see. Shall we? Listen. What happened is, holding company, subsidiary company is there now. Now what happened is, Y Limited is a trustee. Y Limited is a trustee. Okay, Y Limited is a trustee. This trustee is holding the shares of holding company. How it will be possible, we will see in a different chapter. As of now, remember, Y Limited is holding not in its own capacity, it is holding in capacity as a trustee. That is also allowed because I am holding as a trustee capacity, not in capacity of Y. What is this trust? I will discuss when we come to debentures, because there is a separate area called as a debenture trustee. So exception number 1, legal representative. Exception number 2 is a trustee capacity. Exception number 3, pre-acquisition by the subsidiary. See, X Limited, Y Limited. X Limited invested 70% of the shares of Y Limited. Invested in 70% of the shares of Y Limited. Okay. Now what happens is X Limited invested 70% of the shares of Y Limited. Na? Holding subsidiary relationship started between both of them. After getting started all these relation, okay, when this all happened, 1/1/25, Y Limited held 25% shares in X Limited on 31st August 2024 only. Means I held the shares in X Limited even before I became its a subsidiary, this date. Now what happens? Now what happens is, this is called as a pre-acquisition holding by subsidiary in holding company. Suddenly you need not cancel the shares. You can hold the shares, but voting right will not be given to you on this capacity because you yourself is holding now. So you can hold it. Pre-acquisition holding you hold with you. If dividend comes, you take, but voting will not be given. Everybody please answer. Understood the entire concept or not? 10 minutes I explain this concept. Everybody understood this concept or not? Everyone should answer. Did you understand this concept clearly? Yeah. I'll make it full screen. Read it properly and complete. Here. One percent also prohibited. One person is asking doubt, na? 1% also prohibited. One share also prohibited. Trustee and legal representative, there is a responsibility to tell why you voted. Therefore, to that extent, they are saying okay. Clear, everyone? Can you move to the next one? Okay. Next one. Service of documents, section 20, authentication 21, execution of bills of exchange 22. One among these three you can expect in the coming exam. Okay, 20, 21, 22. What others will leave is what that comes in exam. Simple logic. Okay, so listen. Service of documents. Service of documents. Okay, let us see this. Service of document. Section number 20. What is this service of document? If anyone wanted to communicate with the company, if any person, you, me, anyone, we wanted to communicate with the company, where to send our communications, where we need to address. Okay, so where to send, where to communicate, how to communicate, where to send the notice. Listen, whenever communication is given to the company by a third party, for example, I am a third party. I wanted to communicate with the company, or I wanted to communicate with any officer of that company in his officer capacity. For example, Koushik Mukhesh is a director in a company. Director is an officer. So I am a director in a company. Understood? They wanted to communicate with me in my capacity as a director. In my capacity as a director. Or not in capacity as director, I got a general notice from someone in my own capacity. That will be sent to my address only. When it will be sent to the company's address, if I wanted to communicate with an officer in his capacity as an officer. Okay. So therefore, communication with whom? An outsider wanted to communicate with, okay, outsider want to communicate with the company or any officer. Next, where to send? RO of the company, registered office. Mode, either they can send by registered post, speed post, courier, hand delivery, electronic mail. Means what? Registered post, speed post, normal general private courier. Directly go and give it to the company, hand delivery, or electronic mode. Okay, next. This is communication by third party. Okay, repeat again. If anyone wanted to communicate with company or with the officer of a company, okay, where to communicate? Registered office. Mode, registered post, speed post, courier, hand delivery, electronic means. Okay. Next, communication by the company. Previously, communication to the company and officer. Now, communication wanted to be made by company. Okay. So, if the company wanted to communicate with ROC or member, place ROC key his office, member key at his address. How? Post, register post, speed post, hand delivery, courier, and electronic mail. Okay. However, member ki one small exception was given. Member may choose any particular mode upon payment of fee decided by AGM. Sir, I did not understand this. See here. A member can tell like this. I wanted to receive all the notices of your company to me. Not by any of these. I want only by hand delivery, they said. Okay. Some people will be there who are at the age of 60, 65 years or 70 years and above. They don't use that email, mobile phone, everything. They will tell, I don't want all this. Send either by post or mail. Send either by post or hand delivery. But for that, cost will be incurred. That cost member only has to bear. If you bear now, we will send through whatever mode you asked for. So, simple answer. Company, some person wanted to communicate with the company or officer. Place, RO, mode, registered post, speed post, courier, hand delivery, electronic means. Second, communication to be made by company to members or ROC. ROC na at his office, company member na at his address. So 6 modes are given now. What are the 6 modes? Registered post, registered post, speed post, courier, hand delivery, electronic means. Member can choose any one mode only to send. For that, he has to incur the cost. That cost will be decided by the AGM members. Next. Up to here, section 20. Everyone understood? Reply. All the students, did you understand? Yeah. Next one. Authentication of documents, proceedings, and contracts. Authentication means signing. Signing of documents, proceedings, and contracts. Any document, proceeding, legal proceeding, or a contract which require authentication of company. Company has to authenticate because company is a separate person which require authentication of company shall be made on behalf of company by KMP or officer or any employee authorized by board or authorized by board. So any document or any legal proceeding or any contract that should be signed by the company will be signed on behalf of the company either by KMP or any officer or by any employee authorized by the board. That's it. Next. Sir, document signing I can understand. But bills of exchange, negotiable instruments, who will sign? See there. Execution of bills of exchange, promissory note, negotiable instruments, or execution of any deed. Deed is not a document. Okay, proceeding is not a document. Contract is not a deed. So therefore, what is a deed? Deed is an agreement between two persons to do something. So who should execute on bills of exchange, promissory note, negotiable instrument? Who should sign on the deeds? Whenever it is a bills of exchange or promissory note or any negotiable instrument signed on behalf of the company by any person having express or implied authority. What do you mean express or implied? Generally, who will sign on checks? Person who is having an authority to take cash in the company will sign. That person can sign. If clearly they said MD should sign, MD will sign. That's called as express authority. If nothing is said, generally in the company who has a right, that person only will write. That will be called as implied authority. But the deeds cannot like that. The deed of the company shall be executed only by, if company has a seal, any person acting as an attorney under the seal, they have to say. If company do not have a seal, any person authorized by, if company has a CS, director and CS, if company do not have CS, two directors have to sign on that particular deed. So who will sign on the deed? It depends on the type of company. If company has a seal, person who is having authority to stamp that fellow. If company has no seal, then any person authorized by, if company is having CS, director and CS will sign. If company has no CS, two directors will sign on the deeds. Okay. Deed. We completed 20, 21, and 22. Completed? Okay, next one. Now we are into the final concept of this incorporation chapter, wherein we are going to cover three important segments. Number one person company incorporation. Number two, Section 8 company incorporation. Number three, incorporation of a normal company. Means what? General rules of incorporation, and then we are going into other things. With that, this chapter will get completed. One of the biggest chapters by content will be completed with this. Okay, in the time we spent on incorporation, we will complete four chapters. Number one, dividends. Number two, debentures. Number three, deposits. Number four, charges. In the time we spent on this chapter, we can complete those four also. But this chapter, why we are spending time and understanding all the sections, you know the reason. Already at the beginning, I said you what is the reason behind doing this. Sir, anyway, let's see. Special provisions applicable to one person company. Okay. Section 3, subsection 1, first, second, third, fourth, fifth provisos, and rule number 4. Let us see. First, nomination clause and related issues. First, content. Before going into that, first tell me, First tell the answer. Point number one. One person company means what? One person company means a company in which there is only one person as a member. Okay, correct. But along with that, there will be another person called as a nominee. About that, we are going to start. Okay, contents. Nomination clause. This clause contains the name of such other person who become the member. Okay, in the event of death or incapacity of the subscriber. Means what? One person company, one subscriber is there. Na? If he die, immediately who will become the member? That person who becomes a member upon death or incapacity of original member, na? We call that person as a nominee. Okay, next. Before appointing a nominee, it's a contract between you and that person. Na? Take a written consent, attach that consent to MOA, file it with ROC. Next one. Sir, I wanted to change the nominee. Two changes can happen. Okay, nominee himself can withdraw, or you can also make a change. If a nominee withdraw the consent, then duty of the nominee. Withdraw before death or incapacity. Okay, after occurrence of event, you cannot. Before only you have to do. Second thing, notice in writing, notice to sole member and OPC. Okay, so sole member only in a OPC. OPC here represents Board of Directors of OPC. Okay, Board of Directors of OPC. Repeat one more time. Point number one. What is the clause? Nomination clause. What do you mean by nomination clause? It contains the name of the nominee who will become the member upon death or incapacity of the subscriber. He is called as a nominee. Before writing his name in the nomination clause, take his consent, attach the consent to MOA and then send to the ROC for registration. Done. I wanted to change the nominee. Two kinds of changes can happen. Number one, he can voluntarily ask to change. Second, we wanted to change. If we voluntarily change, duty of nominee starts. Withdraw it before the death or incapacity. Notice must be given in writing and notice must be given to sole member, that one member, and the board of directors of OPC. Duty of the company, appoint a nominee within 15 days, new nominee, and file the notice of change within 30 days. Next, if company wanted to change made at the initiative of the subscriber. Means what? It's not a nominee who said that he want to change. We wanted to change. Change may be made for any reason including death or incapacity of a nominee. Appoint a nominee within 15 days. File it with ROC within 30 days. You can change. Next. Alteration of MOA for the change in nominee. Whenever nominee changes, the nomination clause will change. File with ROC. Then what will happen? Alteration of nomination clause shall not be deemed as alteration of MOA. Shall not be a shall be a shall not be. Means what? Without following the big procedure of altering MOA, you can directly make the changes. So alteration of MOA section do not get attracted. Understood? So you can directly alter it. ROC can alter. Special resolution, all these. Only one person. What special resolution you will pass for alteration? That's why they said deemed alteration will happen. Read up to here. Completed? Have you completed? See here. Next concept, incorporation and other related issues. 2 minutes we will cover. Who can become a nominee or a member? First, he should be a natural person, means human being in simple language. It should not be a company. So, company cannot become a member of OPC or even nominee to an OPC. Indian citizen and a resident of India. Okay, either under Companies Act or any other law. Means resident means a person who stayed in India for not less than 120 days in the immediately preceding financial year. In which financial year? Immediately preceding financial year, not less than how many days? 120 days he should stay in India. Next, ineligibility. Which one? Ineligibility. And who cannot become a member or who cannot become a member or nominee of an OPC? First one is a minor. Minor cannot become a member of OPC. Minor cannot become a nominee in OPC. Even he cannot hold the shares in beneficial interest. Other cases, one person company cannot get converted into Section 8. Already we read. Cannot carry on NBFC activities or invest in the securities of a body corporate. It cannot do. Next, dual membership and nominee possible. Means what? A person cannot become a member or nominee in more than one person company at the same time. Means what? I will become a member in A Limited, B Limited, A Private Limited, B Private Limited, both are OPC. Say I want to become member at the same time. Not possible. I cannot become nominee at the same time in more than one company. Not possible. You can become member in one OPC and nominee in another OPC. No problem. Now you will get a doubt. Sir, you said A Limited, B Limited. Member not possible. Nominee not possible. But what you said is a member nominee is possible. But sir, okay, but sir, if this company the main member died, then automatically I will become member to a nominee to member. Na? At that time, two memberships I will have. This is allowed for a period of 180 days. It's not there in your syllabus. Therefore, I am not stressing on this. But actually, in real life scenario, what happens is, see here again, I am repeating. You cannot become member in two OPCs. Pakka. You cannot become nominee in also two OPCs. Adi also pakka. But what is the point here? I will become member in one OPC. I will become a nominee to a member in another OPC. Allowed. Now doubt will come. What could be the possible doubt that can come? If this member die, automatically this nominee will become a member. At that time, if you see the scenario, I will be member in two OPCs. Na? Is this allowed? Yes, this is allowed for a temporary period of 180 days. In this 180 days, that member should choose only one company in which he wanted to continue as a member. Did you all understand the discussion or not? Everybody. Okay, done. That's what you wanted to cover. So if a person who is already a member of OPC become member of another OPC by reason of capacity of nominee, he shall comply with the provisions within period of how many days? 180 days. Next, Incorporation and Section 8. These two sections are already covered in CA Foundation. Okay, Incorporation Provision and Section 8 Company. That's why I will give summary in 2 minutes. Just to listen, you can read later stage. Okay, listen first. Incorporation section, what it says is, whenever you wanted to incorporate a company, there should be minimum 2 members in case of private company and 7 members in case of a public company that are required. To form what? To form a company. So to form a company, we require how many members? We require 2 in case of a private company, 7 in case of a public company. Okay, now listen carefully. What these people have to submit? A question will arise now. So what are the basic details that we need to furnish to ROC? See here. There are 4 parts, 4 concepts actually in this area. General Incorporation, Section 8, OPC and effects. Effects of registration we already read in Section 10 and 9. Special procedures for OPC we read now. So we are now going to cover Part A and Part B. Part A and Part B. What Part A? What documents we are required to file? Okay, filing of documents. Basic. MOA and AOA duly signed by subscribers. MOA and AOA duly signed by subscribers. Okay, so MOA and AOA signed by subscribers are one of the documents that we need to send to ROC. Second, I told register office of a company will not be there before incorporation. We have to establish it within 30 days. So in that 30 days, if I wanted to communicate, where to communicate? Address of correspondence till RO is established. Next one, personal particulars with respect to STM and first directors. Subscriber to memorandum and first directors give their personal details. What details? Their name, surname, residence address, nationality, proof of identity. This with respect to STM. If you are a first director, okay, same as STM, name, surname, all these things should be given. DIN also should be given. Not just that, you are becoming director, give the consent. And in any other company, if you are a director, in any other company, if you are a shareholder, in any partner, if you are a partner, give those interests also. Okay, cover. What we covered, the basic details, MOA and AOA duly signed by subscriber to memorandum. And the second one will be address for correspondent till the RO is established. Next one, personal particulars with respect to the STM and FD. File it, everything. Over. Next, filing of documents, the first one. This is the first thing. Second one, you should also file professional declaration. What also should be filed here? Professional declaration we have to file. Professional declaration will be given by whom? CA, CS, CMA advocate engaged in formation. Engaged in formation. They should give. Okay. Declaration should be given. See here. Filing by whom? Filing of what? Filing of declaration. Declaration is of 2 types. Number 1, compliance declaration, self-declaration. Compliance declaration will be given by CA, CMA, CSR and advocate involved in the formation. Okay. Next one. Next one. Of what? They will give a certificate saying the declaration that complete Companies Act and rules with respect to incorporation have been complied with. Means this company has been incorporated by following the provisions of Companies Act. We did not go away from that and incorporate. Like that, compliance declaration will be given by CA or CMA or CS or advocate who is involved in formation. Next, self-declaration should be given by STM and FD. What self-declaration? They should tell that they are not convicted of any offense. Okay, they are not guilty of fraud in the last 5 years. And whatever the information they are saying is true and correct to the best of their knowledge. Like that, these people will give self-declaration. I am going into this very fastly because nothing is there in this. It's just a procedure. To sum up everything, what is the logic of Section 7? Section 7 says that whenever you wanted to incorporate a company, take a Spice Plus form. To the Spice Plus form, you have to make the attachments or not. First attachment will be MOA, second attachment AOA, signed by the subscribers to the memorandum. Over. 3 documents over. Next, attach address for correspondence till the register office is situated. Fourth document, attach. I want full particulars of directors and first directors and STM. Name, surname, residential address, nationality, proof of identity, along with that dinner required for first director. Along with that, you should also give consent and interest in other entities. Okay. Next, filing of what? Filing of 2 declaration. One is a professional declaration, also called as a compliance declaration. Second one will be self-declaration. Compliance declaration will be given by CA or CMA or CSR advocate in the formation that all the act and rules have been complied with. Self-declaration will be given by subscribers and first directors, saying that it is an assurance given to the department that they are not convicted of any offense in formation of a company. No fraud has been committed in the last 5 years, and all the information, whatever they stated, is right. They have to sign on self-declaration. Understood? That's it. With this, we completed procedure for incorporation of a normal company. Just take 2 minutes time. Complete it very fast, please. So, Section 8 company. Like this, I will discuss about Section 8 company also very fastly. Listen. Section 8 company, everyone feel that incorporation of Section 8 company is covered by this chapter. No. Section 8 company, there is no separate incorporation. License to Section 8 company will be given under Section 8. Means, whenever you wanted to start a Section 8 company, you are not going to do any business activity. You are going to promote an area. To promote that area, concerned central government ministry has to give permission. Okay, for example, I wanted to start a startup in science and technology. You have to apply to Niti Aayog, a department in central government. Okay, Niti Aayog you have to apply. Through Niti Aayog you will get the license. Okay, to do that activity. That activity, if you want to do in the shelter of a company, for that Section 7. Section 8 is not incorporation of company, a non-profit company. It is to get license. It is to get license. So, when central government will give license, if central government is satisfied that you are going to comply with the 3 important conditions. Number 1 condition. Okay, you are going to promote education, sciences, social, arts, sports, etc. Second thing, you will apply the profits only for achievement of objects. Number 3, you are not going to declare the dividend. And number 4, any other additional conditions that the central government department keep on you. If it satisfies that you will comply, they will give you license to operate as Section 8 company. The moment they give you license, you need not use the word limited or private limited at the end of its name. Then you will apply for registration of company. This license will be attached and sent to ROC. ROC will incorporate the company. This is number 1. Number 2, in future, this Section 8 company is not promoting education, arts, science, social, sports, etc. They are doing some commercial activity. Okay, and condition 1 is not followed. Second one, or profits are not applied on the objects, or number 3, they declared dividend, or number 4, they did not comply with some additional conditions imposed. In that case, central government will revoke the license. When I revoke the license, what will happen? I am a company with a Section 8 license, became a Section 8 company. Correct? Now what is taken? License is taken. Therefore, still company is remaining. Therefore, you will convert this company either into public or private limited company. Option 1. Option 2. License is taken. Now you will merge it with another company having similar object. If there is any other Section 8 company doing a similar objective, we will merge it with it. Sir, I can't continue as a private public company after this. I can't even merge with another company. No one is taking it. Then they will go for winding up of this Section 8 company. Understood? In a Section 8 company, a firm also can become a member. A firm also can become a member. Where? In a Section 8 company. Read this. Whatever is required for the exams, I made summary and I kept here. Read properly. Read the full chart. Okay. With this, we have successfully completed the second biggest chapter in your syllabus. First chapter will be general meetings. Second chapter will be incorporation. In terms of length of the chapter, the biggest chapter in the syllabus we have completed now. Okay. So see, 25 page charts, 25 pages is there. Remaining all the chapter, 2 pages to 3 pages the charts. This is the only chapter which carried 25 pages also in the chart form. Okay. So these are the two things that we have covered. Let me now, just wait a minute. Okay. See here once. We are going to start with the next chapter with the name Prospectus. What is the concept? Prospectus. See, with regard to the Prospectus chapter, you can generally expect a 5 marks question to come in exam. Okay? 5 marks question you can expect to come in examination from the area called as Prospectus. Just a minute. Okay, see here. So, this chapter Prospectus also will account for 5 marks, can go up to 7 marks in exam. Okay. This general trend, if you see, they are coming for 4-5 marks in exam. But in history, in the past, this chapter also have a capability to come for somewhere around 10 marks to 12 marks also. But in the latest trends of exam, they did not ask properly in this chapter. Okay. Therefore, there is every chance that this chapter can be tested for 7 marks to 10 marks in the coming examination. So, this is another more important chapter for the coming Jan 26 examination. Okay. For the coming Jan 26 exam, another danger spot for us will be the chapter called as Prospectus. Okay, chapter called as a Prospectus. Let me first explain you certain points inside this chapter. Okay, first let me explain certain points in this chapter. We are going to start with the next area called as Prospectus and Allotment of Securities. This Prospectus and Allotment of Securities chapter runs from section 23 to section number 42. 23 section to section number 42. There are 7 sections which are bigger Remaining all are extremely small sections, easy to understand and easy to comprehend and write in exam as well. But there are 7 sections which are extremely complicated. What are those? First one, red herring prospectus, shelf prospectus and information memorandum, application form to be annexed to the prospectus to be annexed to the application form, section 33. Next one, section 28, offer for sale, section 25, offer for sale, and along with that private placement concept, and next one will be shares to be in a dematerialized form, allotment of securities. 8 sections are there. These are quite interesting and important concepts. Once we complete these, remaining sections become cakewalk and very easy to comprehend and complete it. Are you clear? So next, whenever we are starting tomorrow morning, when we start with the session, first we are going to start. The moment we have a session, we are going to first start with this public offer and private placement concept. Okay, within the chapter called as prospectus. So tomorrow's target will be max 2 hours we will be spending on prospectus. After that, another 3 hours we will be spending on 3 different chapters. We are going to complete the chapters like charges, deposits, debentures. Okay, 3 chapters or debentures, deposits and charges. How many concepts are there? How many chapters are there? 3 chapters. These 3 chapters plus the prospectus is the next target, such that we are having totally 10 chapters in Companies Act. 10 chapters, but tomorrow we will complete 5. Clear or not? Next, after that, we will take another 3-4 chapters in the next session. 3 chapters we will take. Let's not put heavy scheduling. So 3 chapters we are going to cover. Mainly, what are the 3? First, general meetings, share capital, accounts of company. General meeting, share capital, accounts of company. Such that a complete fulfillment of all the chapters of Companies Act will happen. Okay. So I have no problem in taking extra sessions also. 1 or 2 extra days we will take and complete everything smoothly. Okay. So this is what the plan is. Everyone had a clarity, yeah? Yeah. Okay. So tomorrow's session, once we begin, we will be having the first topic will be prospectus. We will start 10 o'clock. We will begin the session like today. So 10 o'clock when we start, 10 to 12. But before we take the first part of a break, we have to complete this particular area called as prospectus. If you complete like that, remaining 3 small chapters are there, debentures, deposits and charges. We will complete in the second part of our class. Okay. Thank you very much. We'll meet in the tomorrow's session again. Okay. Thank you. So very good morning. Today in this session, we are going to start with another very important chapter in your syllabus, prospectus. And after prospectus, we will start with some small areas that are applicable for exam, but which will come for somewhere around 12 marks in examination again. So there are 4 important chapters. At least we try to complete as many as possible after completing this area called as prospectus. The areas include, number 1, the first concept that we need to keep in mind is prospectus. After prospectus, the next concept will be debentures. Next concept will be deposits. Next concept will be charges. And then the concept of dividends. So all these chapters will come for 4 marks or 5 marks, etc. But again, as I said, from the trend, if you go, unnecessarily you will land in a trouble. Last 2 attempts, the dividends chapter hasn't been tested in the exam. So there is every chance that can come from good amount of around 8 to 10 marks in the coming examination. So therefore, what care we have to take? Whatever the areas which are untested, tested areas anyway, they are proved important. Untested areas which people are thinking that they are not important, let us also cover them first. Such that anyway, general meeting, share capital, every student will prepare. Because definite question will be there every attempt. But the problem is the same level of confidence they don't have on other chapters. So let's cover them. Okay. So the strategy is very simple. Let's cover all uncovered and unexpected areas, then you are ultimately safe at the time of examination. Okay, shall we begin, everyone? Yeah. So now let us continue. Let me first explain what is this particular chapter called as prospectus. Okay. Prospectus, there are two segments in this chapter. One is prospectus related sections. Next one, allotment of securities related sections. Okay, prospectus related sections, allotment of securities related sections. Sorry, first, when I say allotment of securities related sections, okay, allotment of securities related section, it starts at 39, 40, 41 and 42. These are all the sections which will discuss about allotment of securities. Total chapter will be 23 to 42. So 23 to 38 will be discussing completely about prospectus related sections. So 23 to 38 is a prospectus related. 39, 40, 41, 42 are talking about allotment. These three are public offer allotment. This is a private placement allotment. Okay. So we are going to now read the entire chapter without leaving even a single section, but I will cover extremely faster from the exams point of view. Regular class like will be taking somewhere around 14 classes, okay, for prospectus alone. But that 14 classes content, how we can discuss now? So therefore, what is core for the exam? So if I learn this, yes, definitely in exam I will score. Whether I know remaining attached concepts or not, whether I know the bare act or not, leave it. Okay, this is not the time to do that circus. So let us cover the concept from the exam point of view. If question comes in exam, am I able to write it? If that be the question, yes, this is enough. So let us understand. First one, companies are of two types: private company, public company. Okay, private company, public company. Public companies are again divided into two categories: unlisted public, listed public. Okay, unlisted public, listed public. First one, private company. Private company can make issue of shares. Yes, without issue of shares, how paid up capital is created? So issue of shares can be made by whom? Private company. In what way they can make? In three ways they can make. Number one, bonus issue, rights issue, private placement. Bonus issue, rights issue, private placement. Understood? They cannot go for any kind of public offer. Whom? Private company. Close. Second, I am a unlisted public company. I am a unlisted public company. In this case, I can also make three kinds of issue: bonus issue, rights issue, private placement. The moment you go for public offer, you will turn into a listed company. Okay, so the unlisted company once go for public offer, it has to list its shares on the stock market and then it has to go for listing. So therefore, immediately an unlisted company will turn into listed company. Okay, now listed company. Listed company can make four kinds of issues. Number one, bonus issue, rights issue, private placement and public offer. And which offer? Public offer. Now listen carefully why we are discussing this. If you are a listed company, listen carefully. If you are a listed company, I will mark it. If you are a listed company going for bonus, rights, private placement, you are an unlisted company going for bonus, rights and private placement. You are a private company going for bonus, rights and private placement. So bonus issue, rights issue, private placement, if you wanted to make, these all will happen under Companies Act 2013. However, whenever you wanted to make a public offer, Companies Act has only 1% of total public offer coverage. Okay, before going to public offer, under Companies Act, what you need to do is there in Companies Act. But whenever I call a listed company, for all these, SEBI guidelines will apply. Which apply? SEBI guideline. Companies Act do not apply. To whom? Listed public companies. So the summary of the concept is, a private company, unlisted public company, listed public company can go for 3 issues in common. What are those? Bonus issue, rights issue, private placement. Additionally, a listed company can also go for public offer. But listed company ki MCA will not apply. SEBI guidelines will apply. For unlisted and private limited company, MCA guidelines are simply to tell Companies Act 2013 only will apply. Why I am discussing this? Section 23 completed. Yes, even if you don't believe me, this is what there in section 23. Read now. What is there in section 23? Let us see. Public offer and private placement. See, public company may issue securities either by public offer, private placement, or rights issue, bonus issue. If it is a listed company, then what will apply? SEBI guideline. Rights issue and bonus issue as per this act. And SEBI in case of listed company are intended to get listed. Unlisted going to listing is that one. So whenever you are going for public offer, in this case, prospectus is mandatory. Prospectus is mandatory. So public company may issue securities either through public offer or private placement or rights issue or bonus issue. If it is listed company, follow SEBI. If it is unlisted, follow Companies Act. So then what about private company? Private company can go for private placement, rights issue, bonus issue. Rights issue and bonus issue. If you are intended to get, if private company want to go for conversion into public company and then it wanted to go for listing, then again SEBI guidelines will apply. Public offer includes 3 things: IPO, FPO and OFS. IPO, initial public offer. FPO, further public offer, also called a follow-on public offer. OFS, offer for sale. The offer for sale covered by 2 sections, section 25 and section 28. 2 most complicated sections of this chapter. Both the sections combination, if one question comes in exam for 7-8 marks, how it look like? That's what happened in the last exam in law. 25 with 28, they combined and they asked a 7 marks question in exam from prospectus chapter. That's it, wickets out. Okay, you go by expected questions now. Expected questions, maybe 25 will be there, maybe 28 will be there. Combination, if you have to read, you should have full clarity on what is 25 and 28. I'm very happy for one reason. Whether success failure is secondary, but the most happiest moment is ICA is now driving towards conceptual understanding, not memory techniques and not by expected questions. I can tell expected questions for 25 is there, 28 is there, but how the 25 and 28 will come in exam? Horribly they tested in exam last attempt. They did not ask anything directly. Those who understand the core contents of 25 and 28 will only get that 7 marks in exam, or else 0 ne. Next question, next. So that's the point I wanted to tell. So concentrate properly on certain aspects of this chapter. I will only tell you where danger points are. Danger points when I am discussing, you please be in the class properly. Okay, next. Notified class of public companies can issue securities for the purpose of listing on stock exchanges in permissible foreign jurisdiction. This we will discuss much later, not that important. Now we are going into some important definitions. See here, there are 2 definitions. Name of the chapter is what? Prospectus and allotment of securities. So what do you mean by security? The term security is bigger than a share. Okay, there is one act called as a SCRA, SCRA, Securities Contract Regulation Act. Under that act, The term security is defined to include shares. Means what? Share is one of the security. There are so many things. Shares, scrips, bonds, debentures, debenture stock and other marketable securities, commodity derivatives, normal derivatives, and next one is units of collective investment scheme, units of mutual fund, options and share warrants, and government securities. All these will come under one definition called as security. So the term security is so much wider. It covers so many things inside it. Okay, it's not just one single instrument called as a share. Share is the smallest component of security. Where it is defined? Scrap. See here. Securities under section 2 clause 81 of Companies Act. 2 clause 81 of Companies Act did not define what is a security. Referred to scrap. Okay. Security is a wider term and includes shares, bonds, debentures, derivatives, collective investment scheme, security residues, units of mutual fund, government securities, etc. As is what I said. Okay. Security shall not include units of ULIP. ULIP instruments are not securities. Okay. They are normal insurance policy receipts. So ULIP units are not treated as a security. This is one important note you need to mark. Next one. Definition of what is a prospectus. First one. Prospectus is not a oral thing. That means two people discussing will not make a prospectus. It's a document. It's a document. Sir, what is a document? For that we need to read General Clauses Act. General Clauses Act, what is a document is given there. Okay, when we come there we will. Don't do now. So any document described or issued as a prospectus means what? If you write some nonsense in a book, issued as a prospectus, it becomes a prospectus. So then easy na? Not easy kanna. If you write some nonsense and write down as a prospectus and give na, government will treat it as a prospectus. It will not contain whatever is required in the prospectus. 7 years imprisonment and money will be charged at 5 times penalties are there. So therefore they are saying that don't do overaction with prospectus. Be careful. So any document which is described and issued as a prospectus will become a prospectus. If you tell, sir, this book is prospectus, I believe that it is a prospectus. But if contents required to be there in the prospectus are not there, you have to face a severe consequences on that. Okay. Next, it includes 3 things. Red herring prospectus under 32. Shelf prospectus under 31. Okay. Next, any kind of notice, circular, advertisement, or any other document inviting offers from public for subscription or purchase of any securities of body corporate. Okay. So see here. What is a prospectus? Prospectus means a document which is described or issued as a prospectus and includes red herring prospectus, shelf prospectus, any notice, circular or advertisement or any other document inviting the offer from whom? Public. For what? Subscribing. Subscribing for what? Securities. Of whom? Of a body corporate. So in this chapter, wherever the term company comes, also include body corporate. Okay. This is the first thing. First of all, everyone have to tell, did you all understand section number 23 and some important definitions in our syllabus with regard to prospectus chapter? Everyone. Say yes. Done. So 1 minute time. Every topic after I will give you 1 minute time. Fastly revise them. We'll go into the next one. 2 hours time for prospectus chapter. Some students are complaining that some of the participants are unmuting and talking something. Please avoid that. Mute yourself. There will be a symbol, red color striking of symbol will be there for a mic. Please strike it on such that you won't disturb others in the class. Everyone, have you completed? Can we go to the next one? Next one. See here. What is this section? This section is talking about power of SEBI to regulate issue and transfer of securities. Small section here. You need not even study this section, just only one line answer. Okay, you can see this is the only one line. This is section 25. Okay, topic is different. Simply to tell, whenever I call listed company or about to get listed, Companies Act do not apply to them for issue of security, for transfer of dividend, anything by a listed company. Companies Act nothing to do, SEBI guidelines only will do. So SEBI is empowered to regulate issue of security, transfer of security, non-payment of dividend by listed companies or companies intended to get listed on any recognized stock exchange in India. Simply to tell, whenever it is a listed company or whenever it is about to get listed, now unlisted, I applied for listing. For these two types of companies, three things are there: issue of security, transfer of security, payment of dividend. Is governed by not by Companies Act but by SEBI. Simple one line answer equation. Okay, if it is issue of security, transfer of security, non-payment of dividend, Companies Act do not apply, SEBI will apply, provided company is a listed company or about to get listed. In these cases, SEBI guidelines only will apply. Companies Act do not apply to them. Everybody understood the concept? Can I go to the next one? Fast. Only 2 hours. So please, if you answer fastly, we will complete it and move on to the next one. Yeah. Next one. So we completed section number 24. Now listen. I am shifting the entire concept. I am going to 39, 40, 41, 42. Okay. Yeah. 39, 40, 41, 42. See, I will give you one guarantee. 4 sections I said now. 39, 40, 41, 42. One question will come in Jan exam. Pakka. We will again meet on exam day. Okay? That's the guarantee. There will be one pakka question from 39, 40, 41, 42. One question will be there. Today, what I am going to discuss in the next 45 minutes. From that, one question will be there in exam. Okay. What way they will ask, I don't know. But whatever we cover only will come in exam. What we are discussing will come in exam. In that, which one will come, I can't give a guarantee. Okay, I can tell what way they can ask questions also, but I can't tell which concept will come exactly. 39, 40, 41, 42, one question will be there in your paper. Okay, are you all ready? 45 minutes it will take to complete those. Reason, there is one very big section called as a private placement, section 42. So we need to obey that section and read. Clear? Let's begin the show now. So now we are going into the most important segment of prospectus chapter, allotment of securities by companies. Allotment of securities by companies. Okay. See, first one. What do you mean by this allotment? Let me first explain. Okay. Company will go for public offer. Company will go for IPO. When it go for IPO, they will not collect entire money in one go. They will collect in installments. A installments ki name a subscription model. What model? Subscription. Netflix subscription I have. Means what? You are not buying entire Netflix. You are buying a 1 year subscription. That's all. After 1 year, again you have to pay, or else connection cut. Same concept, company la. I will not issue shares by taking money in one go. I will ask in installments from you. That's why people call subscribe to securities. The word subscribe, whenever used, one thing should come in mind. You are not paying entire money once. You are paying in bits and pieces in the form of installments. That's called as a subscription. No, sir. I will buy directly from stock market. From my some buyer, some seller will be there. I will buy then we don't call it I subscribed, then we call I purchased. There is a difference between subscription and purchase. There is a difference between subscription and purchase. Listen. See the screen once. Prospectus, bare act how it was drafted. See there. Prospectus means any document described or issued as a prospectus and includes a red herring prospectus referred to in section 32, shelf under 31, any notice, circular or document, etc. from public for subscription or purchase. Means subscription and purchase both are not same. Okay, subscription means installment basis if you take. Purchase means one-time payment if you make. Both are not same. Both are different. Everybody first answer. Did you understand a new thing now before starting this? Okay. Done. So now what is the point that you need to understand here? Section number 39, allotment of securities by a company. Now listen. Why we are discussing about that is, first one, you need to know difference between subscription and purchase. Here we are not going to purchase. Here we are going to subscribe. So we are talking about subscription model of securities issue. Okay. Now listen. Company go for public offer. Collected application money. What it should do? Within a time frame, allotment should be completed. Means what? You cannot take my application money, put it in your pockets and happily sit at home. Once the application money is collected, within 60 days of collection of application money, you have to allot the securities. You have only two options. Either adjust the application money towards allotment money, or if a minimum subscription is not received, you have to refund back entire money within next 15 days, or else you have to pay interest at the rate of 15%. Understood? Sir, let us begin like this. Whenever company go for subscription of a security, application money will be collected. You can do only two things with application money. Number one, you have to adjust the application money towards allotment. Adjust the application money towards allotment. Means what? For example, application money 4 rupees I said. Okay, application money 4 rupees I said. Let us think like this. Application money 2 rupees, allotment money 4 rupees. Do you know what they will do? Application you already paid 2 rupees. Allotment how much you need to pay? 4. You will not pay 4 again. You need to pay only extra 2 because this 2 rupees whatever you paid on application will be adjusted to allotment. So you can do only two things when it comes to application allotment form. Collect application money. Within 60 days, allotment has to be completed. Means, whenever you collect application money, you can do only two things with it. Number one, adjust to allotment money. Second, adjust to allotment money. Second one, or refund back the entire money within next 15 days if a minimum subscription is not received. Sir, can you please explain what do you mean by minimum subscription not received? See, as per SEBI guideline, minimum subscription should be 90% of the total subscription. So what is this total subscription, sir? Total subscription means total number of shares made available to public to subscribe. For example, a company said, I am going to issue 1 lakh shares. 1 lakh shares money I will not collect at once. 1 lakh shares 10 rupees each, 10 lakh. Example, okay, 1 lakh shares 10 rupees each, 10 lakh. 10 rupees I don't collect at once. 2 rupee, 2 rupee, 2 rupee, 2 rupee, 2 rupee, 5 installments I will collect it. Okay. So what happens? 1 lakh shares are there. Okay. 1 lakh shares are there given for subscription. 1 lakh shares at least 90,000 shares we should receive demands from the public. Means what? Public should have subscribed at least 90,000 shares. Condition 1. Condition 2, they should pay that 2 rupee application money. Means out of 10 lakh, I don't want entire 20 lakh now. I want 1 lakh 80,000 minimum to be received. Why 1 lakh 80? 1 lakh is the total shares. 90% means 90,000. 90,000 into 2 rupee application, 1 lakh 80,000. Out of 20 lakh, if 1 lakh 80,000 is received on application money, that's it. You can proceed towards the allotment. If that is also not received, then you have to refund back entire money within next 15 days to the same applicants. Therefore, applicants will give you money. You have to give them back. Therefore, there is a mandatory requirement that money should be taken only through banking channel. Cash flow, you should not accept application, because if you take in cash, how will you give refund? You will call all of them, stand in a queue, you will distribute money. So therefore, you should collect application money only through a bank account, separate bank account in a scheduled bank you should open. Keep the money there. If collected, adjust to allotment, or else refund back to the same bank account from which you received money. Did you all understand the whole story of first allotment? Okay? Everyone? See here. Company can allot shares to public only when amount stated in the prospectus as a minimum amount has been subscribed. What is the minimum subscription? Always 90% of the total subscription will be treated as a minimum subscription. So 90% of the total amount if received, we call that minimum subscription has been received by the company towards the shares. And some payable on application have been paid and received by the company either by check or any other instrument. And in simple language, we are not receiving in the form of cash. Okay. Next, I will give time once everything is completed. Okay. Application money shall not be less than 5% of nominal amount. What do you mean nominal value? Nominal value represents par value. 10 rupee par value, 2 rupees is the question I said now. So minimum 50 paisa should be application money. In our example, 2 rupee. 2 rupees more than 0.5. Okay. So next, if the stated minimum amount has not been subscribed and not received within 30 days, 30 days is as per Companies Act. Any other period given by SEBI, 60 days is given. Okay. Return the amount within prescribed time. What is the prescribed time? If the minimum amount is not subscribed and application money is not received within the prescribed time, application money shall be refunded within next 15 days from the close of issue. Okay. If not repaid, directors who are officers in default, OID, not old, OID, officers in default, jointly and severally responsible to pay interest at the rate of 15% per annum. Refund shall be credited only to the bank account from which subscription was remitted. Just now we read now. That's it. Next, not yet completed here. See here. Conditions are there. Whenever, sorry, let us hypothetically understand this way. We made application money, received, oversubscribed, we allotted, allotment also completed. Once allotment is done, see, when company having share capital makes any allotment, this exam question they will ask, makes any allotment of security, file with ROC form PAS3. Form PAS3, it's called as return of allotment. Default punishment will get attracted. Next, return of allotment to be filed in PAS3 within 30 days of allotment of security. Along with return of allotment attached, list of allottees to whom you allotted, their name, address, occupation, etc. Next, in case of issue of securities not being bonus shares, allotted as a fully or partly paid for consideration other than cash. For consideration other than cash. Sir, why we will allot the shares for consideration other than cash, sir? Because if it is sweat equity shares. Because if it is sweat equity shares. Okay. So other than bonus shares, anything is issued other than for cash. Employee stock options can be there sometimes. Employee stock purchase plans can be there sometimes. Sweat equity shares can be there sometimes. Sometimes creditors may be converted into equity shareholders under section number 62, subsection number 3 or subsection number 4. Creditors will get converted into equity share. In all these cases, we are issuing the securities for a consideration other than cash. In that case, a copy of contract duly stamped together with contract of sale if relating to any property or asset or a contract of services or other consideration. So for what you are issuing, for example, company purchased a building. Okay, it did not pay money, it issued security. Then it will be called as contract relating to property or an asset. Some person rendered service. Company, instead of paying money, it issued shares. Then contract of service. Next, creditors gave loan to the company. Creditors gave loan to the company. Company is not repaying the loan to them. They said convert us into equity shares. Any other consideration. There should be some contract between you, copy of that contract, duly stamped together with any contract of sale or if relating to property, etc. should be there. If such above contract is not reduced to writing, means if you did not write anything, complete particulars of contract stamped with the same stamp duty as would have been payable if the contract is reduced in writing. Originally, we don't have any contract that I will issue shares in other than for consideration for cash. Orally, we agreed. Now put it on paper and get it stamped. A report of registered valuer with respect to valuation of consideration to be attached. Problem is, company is allotting 1 crore worth shares. What is the guarantee really that company enjoyed services worth 1 crore or goods worth 1 crore or asset worth 1 crore? Registered valuer has to value and tell that yes, company allotted 1 crore shares, company acquired an asset, this asset is really worth 1 crore. Registered valuer has to value. So no sir, it is a bonus shares. Then all these are not required. Copy of resolution passed in a general meeting is required. Copy of resolution passed in general meeting. Whenever company go for bonus issue, general meeting ordinary resolution has to be passed. That is enough. That is enough. You need not attach anything. So attach only the resolution copy. If you are filing PAS 3, if it is any consideration other than cash, other than bonus shares, means copy of contract if in writing. Copy of contract if not in writing, now write and stamp it and attach. Okay, and valuation copy of registered value also should be attached. If it is consideration other than cash but being a bonus shares, then general meeting resolution is enough. Okay, shares under 62, this is ESOP. If it is employee stock option, valuation report has to be prepared. When we come to ESOPs in share capital chapter, I will tell you. Okay, to sum up everything, what is the subject matter? First one, point number 1. Company can allot shares to the public only when minimum subscription is received, which is 90% of the total subscription as per SEBI guideline. And it should be received only in the form of check or any other instrument. Next one, application money should be not less than 5% of the total value. Next one, if stated amount is not received within 30 days as per Companies Act and SEBI guidelines as per 60 days, you have to refund entire money within next 15 days or else officers and default shall be liable to pay 15% interest. Next one, refund back entire money only to the same bank account from which the money is remitted. Next, whenever allotment is successful, file PAS 3 within 30 days of such particular allotment. Okay, within 30 days of allotment, you have to file form PAS 3. What should be attached to PAS 3? Nothing should be attached. But if the issue is made for a consideration other than cash, contract to issue shares for other than cash, you have to attach. If it is in oral form, now write it on a stamp paper and attach. Registered valuer report. Bonus shares, the ordinary resolution copy. ESOPs, the valuation report has to be attached to PAS 3. Everybody in the class understood one of the most complicated section, section number 39. Everyone. Okay. Yeah. So making it full screen for you. Read once and complete. Okay, bye everyone. So next one, section number 40. Securities to be dealt in stock exchanges. First listen, after that you can read. Securities to be dealt in a stock exchange. What is this topic all about? Okay. Yeah. See here first. First see, not this. Okay, I will put it on full screen later for you. At that time you can see. First listen to the concept. See, this section says the following things. Point number one. Whenever company is going for listing, whenever company is going for public offer. Okay, public offer, when you issue shares, what will happen? You will issue shares to public. So listing is mandatory. You have to list the stocks on the stock market. So now question is, publicly you will take money. After taking money, if you don't list the shares, what is the position of the persons who gave money to you? Therefore, there are two stages in listing. Number one, in principle listing, actual listing. What is in principle listing? First, Koushik Mukhesh wanted to go for public offer. I will first approach any one of the stock exchange, NSE or BSE. Let us say, for example, I go to NSE. I will ask NSE. NSE. My name is R. Koushik Mukhesh. I have a company called as XYZ Limited. That is an unlisted public company. Now I am going for listing. I want my shares to be listed on your exchange. Are you okay for that? Then it will ask, give your P&L account balance sheet for the last 4 years or 5 years. So many due diligence reports they will ask. Once you confirm everything, they will tell, yes, you are perfect. I will allow you to enter into my stock exchange provided your public offer is successful. So in principle, I am okay with it. But I can't list your stocks unless it is listed. Unless the public offer is successful and completed. So this is in principle listing. So every company going for public offer, before issuing the prospectus, I repeat, before issuing the prospectus, should get themselves agreed with any of the recognized stock exchange to list their stocks and write the name of the stock exchange with whom he entered into agreement in the prospectus. Therefore, prospectus should be issued not before entering into agreement. You should do after entering into agreement. Understood the point or not? So, I repeat one more time. You have to enter into agreement with, I repeat, you have to enter into agreement with, enter into agreement with whom? You have to enter into agreement with stock exchanges, not before, also not after, but before itself you should enter into agreement. In principle, take their consent, write the name of stock exchange which agreed for listing, and then you have to go for a public offer. Everyone in the class understood the concept? That's the first point. Second very important thing. After that, whenever you receive application money, you can utilize it only for two purposes, as I said already. Either adjust to allotment or refund back the money. And moreover, money should be kept in a separate bank account in a scheduled bank, and application money is received from general public. They are not members at that time. Allotment, they will become members. So they are outsiders' money. Don't treat it as company's money. Therefore, keep it in a separate bank account in a scheduled bank and should not be utilized for any purpose other than the said two purposes. Okay, next one. In the prospectus, I have written like this. Okay, even if the company failed to comply with any conditions given in section 3940, our company directors are not liable. We are waiving them. We are excusing them. Any provision like this, excusing the directors from their default is there now. Such provision in the prospectus will become void. Provision in the prospectus will become void. Next one, underwriting commission. Underwriting commission. Underwriting commission means minimum subscription is received. Minimum subscription is received, but the full subscription is not received. 90% is subscribed. Balance 10% not subscribed. These people will subscribe to the balance and make the issue complete. Okay. Or sometimes if there is a doubt that minimum subscription also will not be received, they will go for full underwriting. Means what? Complete issue will be underwritten. 75% they will subscribe, balance 25. Those people who will make public offer successful by taking an element of risk, we call them underwriters. When they are taking that much risk, they will charge a commission or not. Therefore, we pay them a commission called as an underwriting commission. What commission here? Underwriting commission. So, what are the conditions to pay underwriting commission? Articles should allow you to pay underwriting commission. Second one, very important exam question, it can come in Jan attempt only. Underwriting commission, you cannot pay out of whatever amount you want. It should be paid only out of, proceeds of issue. What do you mean proceeds of issue? You are issuing 100 crore stocks. From that, you deduct underwriting commission and pay. Flotation cost light will go. You will issue shares, 100 lakhs, 100 crores received. 2 crores underwriting commission you paid. Like that you can pay. Or profits law you can pay. Or combination you can pay. Other than these three, DRR lines amount taken, capital redemption reserve line amount taken, you cannot do. Pay out of profits, pay out of proceeds of issue, or combination. That's all. No other reserve you can touch to pay the underwriting commission. So next question, sir, how much commission I can pay? Shares na 5% of issue price or amount fixed by articles whichever is lower. Debentures na 2.5% of the issue value or amount fixed by articles whichever is lower. Okay, if articles say 3% only in shares, 5 or 3 whichever is lower, how much? 3%. Okay, if article says 6%, 5 or 6 whichever is lower, 5 allowed. So if public offer is there, then only underwriting commission. Private placement underwriting commission should not be paid. Understood the pointer? So whatever is discussed now is there in the form of this chart. Read it properly. Confirm whether you understood all the points. See, whatever I said now will be there in the right hand side of the chart. Preference shares, there is no concept of underwriting commission. Only equity shares and debentures. Completed fast. We'll go into the next one. Everyone, please reply. If you are completed, we'll move on to the next one. The next one. Say here. Next one. Global depository receipts. What is the next one? Global depository receipts. GDRs. DR means a depository receipt. Depository receipts is of two types. Indian depository receipt, global depository receipt. Foreigner coming to India and issuing is a Indian depository receipt. Indian going outside and issuing shares is global depository receipt. Okay. Global depository receipt, name only clear. We are not giving shares, we are giving receipts. Okay. We are giving receipts not in India, we are giving receipts globally, outside India. Okay. You are not giving it directly, through a depository you will give. That's why they call it global depository receipts. Okay. See, simple language I will first explain. Indian company will not issue shares directly. It will issue receipts. Receipts to a custodian depository. Caretaker, custodian means. Okay, issue caretaker. Caretaker of whom don't ask. This entire offer will be caretaken by one person outside India. Depository. Like India, like NSDL, CDSL, two depositories are there. USA also have a depository na. UK also have a depository na. So Indian company will issue receipts to the depository. Where it is located? Outside India. They will take care of entire issue. That's why we call them custodian depository. So to them we will issue the receipts. These people will issue the receipts to the public in their country. Okay, they will take receipts. Now there is a procedure to convert those receipts into shares. Then foreign public will become the shareholders in our company. That's the whole idea. Understood the point clearly? Yeah. Means if they do not subscribe to the securities properly, then receipts will get cancelled. See, logic is very simple. Yeah. FEMA guidelines, what they said, if you are issuing any kind of shares or securities outside India, shares or securities outside India, FEMA guidelines have to be complied with. Now I am not issuing shares and securities, I am issuing receipts. For receipts, there is no great FEMA guidelines applicable. When that foreigner will convert the receipts into shares, at that time FEMA guidelines will come in place. My receipts are utter flop outside India. No one is interested to buy. Then I will take back my receipts and cancel them. So balance sheet is not getting affected. Unnecessary nonsense also will not happen. Understood the point or not? So that's why world started encouraging depository receipts. So see here. Fastly I will cover this concept. Please listen. A company may, after passing a special resolution in its general meeting, issue depository receipts in any foreign country. Issue depository receipts in any foreign country. First one, A company may, after passing which resolution? Special resolution. In its general meeting, issue depository receipts in a foreign country. So, company required to pass a special resolution in a general meeting, issue depository receipts in a foreign country. Next. Steps to issue the depository receipts. Okay. Steps to issue. Exam question. Chance is there. I will not tell as important as the previous ones, but important. Let us see. Don't neglect anything. So, steps to issue deposit receipt. First, board of directors intended to issue deposit receipt shall pass resolutions authorizing the company. So, first one, board resolution. Next one, special resolution. Next one, depository receipt shall be issued by an overseas depository bank. Just now I told na, appointed by the company, underlying the shares. So, receipt will be there, underlying shares will be there. Shall be kept in the custody of a domestic custodian bank. Okay, so receipts will be issued, shares will be still in India. Once the receipts are subscribed, we will release the shares. Next, comply with the RBI guidelines. Company shall appoint a merchant banker. Okay, merchant banker, a person who will take care of all these issue things, or a practicing CA, CSR, CMA to oversee compliances with respect to deposit receipt. Such compliance report shall be placed in the board of directors meeting held immediately after closure of all formalities. Additional points. DR can be issued by public offering or private placement in line with the jurisdiction. Means in USA you wanted to issue, you can issue only to a select group of people, or to general public also you can give. Next, DRs can be based on new or existing shares. You can issue existing shares in company, or you can create a new par value shares and you can issue. Okay. Underlying shares are allocated to the overseas depository against a share. DRs issued by overseas depository bank. Okay. Main point we have to understand is steps in issue of DR are the main concept for the exam. So, board of directors resolution, shareholder special resolution. After that, depository receipt shall be issued by an overseas depository bank. Shares are kept with the domestic custodian bank. Follow the RBI guidelines. And finally, appoint one merchant banker to take care of all legal compliances. If merchant banker is not available for you, a CA, CMA or CS in practice, such kind of person will be overseeing the compliances of depository receipts. Up to here, everyone. The overall idea of a depository receipt understood, everyone? Later you can read this. Small section only. Next one. Now listen carefully. 99.99% Jan 26 question will be there. From what? Private placement program. Okay, private placement program. You can expect one question in examination. 99.9999%. By chance it may miss, but in all ordinary circumstances, you will find a pakka question from this in examination. Okay, 2 pages content is there. I will simplify and I will explain the concept and I will show you the chart as well. Read the chart, that is more than enough for the exam. Okay, let us first begin. What is the name of the concept we are going to start here? Private placement. What is the concept? Private placement. Okay, now listen carefully. What is a private placement? Let me explain. Private placement means company will not issue shares to general public. Company will issue shares to select group of identified persons. The rights issue also to existing. Bonus issue will be made to existing equity shareholders. Rights issue will be made to existing equity shareholders. Private placement is not made to existing equity shareholders. Maybe to existing equity shareholders also. But it is identified group of people, not exceeding 50, sometimes not exceeding 200. So I repeat one more time. Private placement is a specialized issue where amount required is very less. And I don't want to go for a debt. Then company will raise money from the selected group of people by issuing a circular. We are not going to issue prospectus. Prospectus is issued only when there is a public offer, where it was said. Definition: prospectus, offers from public. Private ki prospectus will not apply. What will apply? Invitations, circulars will apply. So private placement offer letter will be given. That's why no prospectus, private placement, offer letter. Sorry, let us understand. Definition. One by one, let me explain. See, what I will do is, I will first explain what are all the contents in this page. Once everything in this page is completed, I will give 2 minutes time. You will fastly revise everything. Then I will go to contents in page number 2. Then again I will give 2 to 3 minutes time on this. We are completing this area. Okay. But mark this, extremely important for the Jan 26 exam. Pakka question will be there. Okay. Start. Let us see. Offer or invitation for subscription of securities on private placement basis. Definition. What is a private placement? What is the definition? Let us see. See here. Private placement means any offer or invitation to subscribe. Any offer or invitation to subscribe. To whom? To a select group of persons. To a select group of persons. By whom? By a company. Other than by way of a public offer. Other than by way of a public offer. So, first one, it's an offer or invitation. To do what? To subscribe. To subscribe. To subscribe by whom? Select group of persons. By a company. Other than by way of a public offer. Through private placement offer come application. Okay. Private placement offer come application. Which satisfies the conditions specified in this section. Means what you have to understand. Private placement means any offer or invitation to subscribe. Private placement is any offer or invitation to subscribe to a select group of persons by a company other than by way of public offer through a private placement. I kept it as private placement offer come application. Many books they will use this abbreviation. Okay. For shortcut, many books they will use. Even Dr. K.R. Chandra's Companies Act, when he used to write private placement offer come application letter, why to write? Therefore, they will use PPOCA. PPOCA means what? Private placement offer come application form. That's it. Okay. Let us see. Private placement is an offer or invitation to subscribe. To whom? To a select group of persons. By whom? Who will select? Company will select. Public offer or private? No, other than by public offer. Through a document, prospectus? No. Offer come application letter. We call it PPOCA. Private placement offer come application form. Okay. What do you mean by offer come application form? That itself is the offer letter. At the end, application form will be there. Read this offer letter if you like. Fill this application form. You will be issued with the shares. And satisfies other conditions. Other conditions we will read. Second, provision. Subject to this section, company may make private placement of securities. Okay. How private placement will be made and to whom? Let us see. Private placement to be made only to select group of persons identified by board. Identified persons also we call them IPs. Next. Who will identify? Company. Company means whom? Board of directors. Number of IPs shall not exceed 50 or higher number as may be prescribed. Sir, what is the higher number prescribed now? 200 members in an aggregate in one financial year. Above limit of 200, very important point here. This they will ask. In that 200, private company 200, we won't include present employee like that we read now. Here this 200 love, who will not be included? Qualified institutional buyers. Okay. Employee stock options like employees, all these people, for them it is not applicable. Okay. Next. So for NBFCs and housing financing companies also, this 200 limit will not apply if they are complying with RBI or National Housing Bank. If they follow their rules, and in that basis, if they issue in the 200, they will not come into picture. Okay. Sum up everything. What is a private placement provision? First one, private placement of securities can be issued. Okay. In a private placement, 3 conditions will be there. Number 1, it will be made to select group of persons identified by the board. We call them identified persons, IPs. Next, number of persons shall not exceed 50. As per rules, maximum provided is 200. Now, as of now, 200 will apply. In the 200, who shall not be included? Qualified institutional buyers, employees under ESOP, and NBFCs and HFCs if they comply with RBI and National Housing Bank conditions. Okay. Next, clarification by department. See here. It is hereby clarified that restriction of 200 members would be reckoned, means calculated individually for each kind of security, that is equity share, preference share or debenture. Private placement, you are issuing equity shares. For that 200, preference shares you are issuing another 150. It is within 200. Like that you should take. Debentures plus the preference share plus equity all together 200. Each kind of security ki 200. Next. Company making private placement shall not release any public advertisement or utilize any media or marketing or distributing channels. Simple. We are going for private, means only to a select group. Public offer type you should not do any advertisement. Next. This concept I will discuss later. Yeah, not that great. Femala, it will come anyway. I will tell you. Next. Rule 14 started. Okay, Rule 14 means we are going to merge the section with the rules. Private placement. The proposal to make private placement has to be previously approved by shareholders by passing special resolution. So first board of directors, second shareholders by passing a special resolution in a general meeting. Next, whenever you are going for general meeting, you should tell which kind of business it is. There are two businesses in a general meeting: ordinary business, special business. Approval of accounts, A, D, DA. A accounts, D dividends, D directors, A auditors. These four are ordinary. Okay. Other than this, anything is special. Special business requires an explanatory statement. Special business requires what statement? Explanatory statement. In that explanatory statement, you need to mention certain important facts. What are those? Let us see. Whenever your company is going for a private placement, you need to conduct a general meeting, pass a special resolution. And to pass a special resolution, you need to conduct general meeting, you have to give a notice. In that notice, you have to mention one explanatory statement. In that explanatory statement, what should be there? Particulars of offer, including date of passing board resolution. I told the board of directors approval required. When board has given permission, you should tell which securities you are going to offer. Equity shares or preference shares or debentures. Second. Next. Price you are fixing now. What is the justification for that price? You are putting 120. Why 120? Why not 130? Why not 110? Why 120? How you got that? That you need to tell. Next. Who did the valuation? You are telling share price is this much. And someone might have valued done. Who valued? Name and address of the valuer. Next one. How much amount you wanted to raise? Amount intended to raise. Any other material terms and conditions. Okay. Read all these important here. First one. Particulars of private placement, including date of passing board resolution. Kinds of securities issuing. Basis for justification. Basis of justification for price. Name and address of the valuer who is doing valuation. Okay. How much amount you are going to raise. Any other material terms and conditions. Next. Next important. Okay. Up to here you have to read. Provisos you need not read now. Provided also that avoid now. We can discuss at a different place. Have you completed? Have you completed? Can we move to the next one? Okay, okay, I will wait. You read properly. Sriharsha, for your question, answer is yes. Yes, 200 limit is for each security, not on total aggregate basis. See, that's why restriction of 200 members would be reckoned individually for each kind. Okay. Sir, some provisos are given here, provided that all I will discuss at the end of this concept. Okay. Separately, we have to discuss 180 section, not linked to 42. That is 180. So I will tell what is 180 and then we will discuss on that. Okay. See here. We are coming into the core final discussion of this particular section. Okay. See the screen directly. I'm making it full screen and explaining. See here. Company making a private placement shall issue private placement offer cum application form in form PAS 4 to identified persons whose names and address have been recorded. Okay. Private placement offer letter shall not carry any right of renunciation. Means what? Rights shares, rights offer letter can be transferred and renounced to others. Like that, private placement offer cum application form is not transferable document. Okay. Next one. Mode of payment of subscription money. Identified persons willing to subscribe to the private placement issue shall apply in PP. Okay, and application issued to such person along with subscription money either paid by way of a check or a DDR or any other banking channel and not by cash. So mode of payment, one line if you have to tell, how to tell? Only in any other banking channel, not by cash. Next one. Application money not to be utilized unless allotment is made. Already we read in the previous section, same. Next one. Prohibition on fresh offer. No fresh offer unless allotments with respect to any offer or invitation made earlier have been completed or that offer or invitation has been withdrawn or abandoned by the company. Means you cannot go for fresh offer unless allotment with respect to any offer or invitation made earlier have been completed. Means you cannot go for fresh application forms for private placement unless the existing have been allotted and completed or that offer or invitation has been withdrawn or abandoned. Previous one should be either completed or you should abandon that, stop it, and then you should go for new one. Two private placements cannot run together. Okay. Next. Allotment. Company shall allot its securities within 60 days from the receipt of application money. Within 60 days. Company shall allot the securities within 60 days. So application money for private placement received today means within 60 days it should allot. Or else refund within next 15 days. Or else 12% interest. Next. Return of allotment to be filed with ROC within 15 days of allotment. Company making a private placement to file with ROC a return of allotment in PAS 3 within 15 days of date of allotment. See here. Their return of allotment ke 30 days time was given. But in case of private placement PAS 3 only 15 days time was given. Full details you need to submit. Next. Default in filing, there is a penalty. All penalties I kept in a separate chart. You can read that directly. Not like this. If company makes private placement in contravention of the section, this is also punishment only. Penalty. This is also penalty section. These two are penalty sections. Whenever there are penalty sections, see here. I prepared a separate chart for all penalties applicable for your exam. From here it will start. All penalties in a beautiful way, along with the full explanation I have added here. Last attempt, 4 marks came from penalties. So they are asking frequently. That's why see here. 12th penalty, if you see, private placement of securities. If a company defaults in filing the return of allotment within 15 days, company and its directors are jointly liable. This is a punishment. Next, 42 subscribe private placement. If a company makes any offer or accept monies in contravention, company and its directors and promoters are jointly liable. How much? 12%. Just now we read na? Same. Okay. You need not read here. Penalties whenever are there, you can read separately. Next. Same concept. Yeah, again, nothing new. Application money shall be kept in a separate bank account in a scheduled bank and shall not be utilized for any purpose other than to adjustment to allotment or for repayment if it is unable to do so. Next. Private placement. Return of allotment in PAS 3 shall include the following details. Number of securities held, nominal value, amount paid on such securities, and particulars of consideration received if entire securities were issued on consideration other than cash. Number of securities held. Nominal value means how many securities you are going to issue. Next one, nominal value, amount paid, and particulars of consideration received. How much you received if entire amount is given for consideration other than cash. Date of allotment, which securities you issued, equity or preference, all these details. Full name and address, all the details of that particular security holder. Next. Deemed public offer. What is a deemed public offer? If you make a private placement in contravention, along with those punishments, public offer provisions will also apply. If company makes an offer to allot the securities to more than prescribed member and more than 200, the same shall be deemed to be an public offer and provisions of part 1 will get applied irrespective of whether they have been received or not. So simply, if any contravention happened in following this, instead of issuing to 200, issue to 250. That's it. Immediately it will turn into a public offer. You should comply with all the conditions of public offer. If you do not comply, jail. That's why it's a danger. Next one. Private placement basic regulation. See here. Private placement offer cum application form shall be in form PS for serially numbered and addressed specifically to a person to whom the offer is made and shall be sent to him either in writing or in electronic mode within 30 days of recording the name of such person. Okay. So private placement offer cum application letter shall be in PS 4. Serially numbered and addressed specifically to the person to whom the offer is made. Means identified person will be there. Only to that person you have to send it. Okay. Next. Company to maintain complete record of private placement offers in PAS 5. Company shall issue private placement only after relevant special resolution or board resolution is filed with ROC. Okay. These are all some important concepts. This is only just a procedural thing. The most important one is in the first page. Everyone tell me, are you all comfortable with the procedure that is there in this section? You can also read it later, but actually the procedure everyone understood all the points. Most of them are repetitive in nature. Clear? Yeah. With this, we completed the most important segments in the chapter, prospectus. These areas are done. Now we will be going into other areas. Now I will divide how we are going to study this chapter. So we completed this segment. Now we are coming into this segment. Comparatively, this segment will have more sections, but easy, not that difficult. See, prospectus chapter we are having two parts, 1 to 2. One is prospectus related, allotment of securities related. Allotment of security related we completed. Prospectus related we will divide it into 3 parts. Big chapters, yeah, these are all big ones. It will take time. As deposits, registration of charges, 45 minutes, one chapter will get completed. But these are big chapters. 23 to 42 means 20 sections are there. 20 sections are there in this chapter. Your syllabus K 140 sections are applicable. 140 la interpretation, incorporation la 20, prospectus la 20, general meeting la 20, share capital la 20. 4 chapters are covering almost around 80, means what? 70% of your syllabus is in 4 chapters only, in volume. That's what I am trying to do. Once big ones are completed and small ones, 45 minutes we can cover and throw them away. Over. Okay. So see here. Prospectus again we are dividing it into 3 parts for our convenience. A, B, C. First one. Types of prospectus. Second one. Liabilities on prospectus. Third one. Miscellaneous. Types of prospectus there are red herring prospectus, okay, red herring prospectus, shelf prospectus, deemed prospectus, offer for sale, abridged prospectus. Liability, criminal liability, civil liability. Next one, inducement, punishment, personation, action by affected parties. Next, miscellaneous section number 26. The other small sections will come. Okay. So these are all the various segments we have to cover here. Okay. Will not take so much time here, but we need to understand them. Once understood, very easy. So now in this, I am going to first start with this segment. Okay. I am going to first start with this segment. So let us now start with section number 34, 35, 36, 37, 38. All these are liabilities relating to prospectus misstatements. Means what? If there are any misstatements mentioned in the prospectus, okay, if there are any misstatements mentioned in the prospectus, these are the liabilities. I will go into the core concept of this particular section. Listen, there are 3 important sections here. Number 1, criminal liability. Number 2, civil liability. Number 3, fraudulent inducement. I will tell the summary of all the 3 sections first. 5 minutes I will explain. After the direct reading, 10 minutes we have to complete all these 5 sections. Okay, listen. First one, point number 1. Whenever prospectus is issued which is containing any material misstatements, okay, untrue statements or false statements or omission of true statements, untrue statements, omission of true statement, material misstatement, then we call that prospectus as a misleading prospectus. Which prospectus? Misleading prospectus. See, listen carefully. Concealment of fact means what? I am telling truth, okay, but hiding some facts. It is as good as making a false statement. There is one case law which says that a company in its prospectus mentioned that it paid dividends in the last 5 years. Seeing that shareholders started investing in the company shares. Whenever your company is paying dividend means what anyone will understand, maybe company is making a continuous profit, but actually the company is in losses. They are paying dividends out of reserves. That is not disclosed. I am paying dividend in the last 5 years. Statement is true, but it is half true. Remaining half is I am paying the dividend not out of profit. I am paying the dividend out of reserves and surplus. So not telling complete fact is as good as telling a false statement only. Prospectus will become misleading prospectus. Whenever prospectus is a misleading prospectus, any subscriber subscribing to the securities, therefore if you purchase from third party, these sections will not get attracted. These will get attracted only if a subscriber subscribed to the securities from the company directly by reading the prospectus, incurred any loss, then criminal liability, civil liability will get attracted. So repeat, prospectus containing any misleading statement, untrue statement, false statement, omission of true statement or concealment of any facts, then the prospectus will be treated as a misleading prospectus. For doing this, first criminal liability means what? Punishment, imprisonment to fine. Along with that, civil liability also will get attracted. Generally, people think fine is civil liability, jail is criminal liability. No, fine, imprisonments, all these are criminal liabilities. Okay, civil liability means because of your misstatement, so many people have incurred loss. You have a responsibility to compensate the loss caused to others because of you. Such kind of liability is called as a civil liability. So there are two sections, 34, 35. Let us now read. If a prospectus includes any if a prospectus includes any statement, okay, which is untrue or misleading, every person who authorizes the issue, means who signed on the prospectus, shall be liable under section 447. Just a minute. Sorry, something important. So anyway, criminal liability. If the prospectus includes any statement, which is untrue or misleading, every person who authorizes the issue shall be liable under section 447. 447, there is a section called as punishment for fraud. It's a imprisonment and fine. You have to remember that. Okay. This is section number 34. Okay. So tell me, prospectus includes a statement which is untrue or misleading. Okay. This can also include concealing the facts, omission to provide the facts. All these will come into this. Okay. Then section not applicable if a person prove. What do you mean section not applicable? That liability, criminal liability will not apply if a person can prove that such omission was immaterial omission. Means even though such a statement is made or omission is made, that doesn't have any impact on investor investing in the company. My name is Koushik Mukhesh. I am a director of a company. Prospectus, my name was written like this. Okay. Actually, my name is KOU. They have written KAU. What difference will it make? It's a proper noun. Proper nouns, small spelling mistakes will come. Prospectus, there is a misstatement, criminal liability. This is mistake, but this is immaterial. People know that who is that Koushik Mukhesh very clearly. Number one. Number two, that he had a reasonable ground to believe. That the statement was true, or inclusion or omission was necessary. Means what? The mistake that was committed was not intentional, it was unintentional. I have a reason to believe that is true statement only. I did not do with any malafide intention. If you can prove that in the court, you can escape from criminal liability. Others will be subjected to that. Next, civil liability, most important for the exam. Where a person has subscribed, not purchased, securities of a company, and he read the prospectus, acting on that prospectus statements or omission in the prospectus. See, you said dividends are paid in the last 5 years. I believed on that. I acted on that belief. Okay, because you omitted to tell that dividends are paid out of reserves. I believe that it is paid out of only profits. So where a person subscribes for the securities of a company, acting on any statement which is included or omitted in the prospectus, which is misleading and sustained a loss or damage. So 4 conditions here. Company or a body corporate has issued securities and a person subscribed. Prospectus, like he read the statement and he believed that it is true. He believed that that inclusion or omission is correct. And as a consequence of that particular misstatement, I incurred a loss or a damage. In that case, see how much liability is there. Who is the person liable? There are 5 persons that will become liable. Number 1, director at the time of issue. Whoever is the director at the time of issue, all of them will be liable under this section. Not only that, some people will say that write my name in the prospectus. Okay, though I am not a director, write my name as a director. These are called as a name lending directors. What is it? Name lending directors. Those also will become liable. Some directors, before issue of prospectus, they will agree to become director, but they will become directors in future. See, name lending director, they will not become director. Next case, they agree to become directors in future. Promoters, whoever authorized the issue, expert under section 26(5). There will be an expert registered value or all these people who says, yes, share price is this much. They will agree and they will tell that, yes, I made analysis. This is the price, correct price, that fellow. So 5 persons. Number 1, directors at the time of issue. Number 2, who authorized himself to be written as a director. Number 3, who become directors in future. Number 4, promoters of a company. Number 5, whoever authorized the issue. Number 6 will be expert. In this, whoever authorized, advocates, auditors, everyone will come into the picture. I told now civil liability means what? Because of you, loss is caused to another person. Compensate to every person who sustained loss. Okay, next. No person shall be liable. Same like this. When you can escape the liability, when you can take a defense, see here, when having consent to become director, or actually I consented to become director, but I withdraw the consent. Okay, I withdraw the consent. See, 20 November 2025, issue of prospectus. Okay, 20 September 2025, I gave a consent to become a director. Okay, but later I withdrawn my consent on 17th November 2025. Means before issue of prospectus, I withdrawn my consent to continue as a director or not. But my name is still there on the date of issue. I am not responsible because I already withdrawn my consent prior to the issue of prospectus. Number 1. Number 2. Some person, some directors or some auditors or some person can prove that prospectus was issued without his knowledge or consent. Okay, without his knowledge or consent. For example, there is a director. That director was in Singapore in the last 4.5 months. He is not knowing what is happening in the company. Without his consent, they issue prospectus. Since prospectus is issued and made public, now it become a public information. Director come to know. Immediately he should issue a public notice saying that I am not aware of this prospectus. Don't make me responsible for anything happening wrong. Next one. Who can take a defense? Listen carefully. Balance sheet is there. Balance sheet assets side, land and building is there. Public offer time, what they have done, they revalued it. Okay. Who revalued? Company revalued on the basis of expert statement. There is a civil engineer expert. I called that fellow. Sir, there is a land and building belonging to company. There is a big land also. We purchased it for 10 crore 11 years back. Now price will definitely increase. You do the entire analysis and tell me what is the real value of the land today. That we will write in the balance sheet. Okay, that we will write in the balance sheet. They revalued the numbers. A registered valuer came. A registered valuer came. He said, sir, you purchased it for 10 crore. Now it is 60 crore. I value. This is my valuation report. Expert report he has given. Okay, that expert report was also kept in the prospectus. Prospectus has been signed by a director. I told him yesterday, whenever you sign on the last page of a document, what does it mean? You are accepting all the contents in the book. Prospectus is 200 pages. 158th page, expert consent is also there. Director signed on 200th page. Means what? They are also accepting the expert consent or not. Therefore, directors are responsible. Actually, that land value is not 60. Land value is only 30. Now, whose mistake it is? Expert. Along with that, whose mistake it is? Directors who signed the prospectus. Now directors can take a defense saying that, first of all, such a statement made by directors is on the basis of expert report. Okay. We believed in the skill and knowledge of the expert. We believed that expert is a competent fellow. And the expert has given his consent for that expert document. That means Koushik Mukhesh is an expert. I said, land and building has been personally valued by me. Okay. And I valued it 60 crore with all rules of valuation applicable. With the full analysis I have done, it is 60 crore. And I am giving consent for this expert statement. I am responsible. Like that expert has given a consent. And he has not even withdrawn the consent. Means what? Expert is absolutely sure that the value is 60 crore. Believing in him, I signed on the document. Mistake is not with the director now. Mistake is with the expert giving that statement. Okay. So this is the point. If proven that prospectus is issued with a defraud, means not misstatements, fraud is involved directly, then every person will be liable for personal liability without any limitation of liability. Unlimited liability it will become. Means what? Misstatements are different, fraud is different. If misstatements mean what? Omission to give anything, something like that. Fraud is your main intention. Court said that this is not a general misstatement or errors. Even for error you will be liable. But if the fraud intention is involved, if court proved that there is an intention to do the fraud, then every person who is involved in that fraud will become personally liable to compensate the loss caused to the public who subscribe to the securities. Okay. So this is the point. Section 34 and section 35. Complicated two sections here we completed. Everyone understood the concept clearly? Everyone understood the concept clearly? Okay. Next. Fraud 447, just I kept a chart, you can read it later. Just you can see this chart. If you want, you can take a snap also, such that future reference it will be useful for you. TO represents a turnover. If amount involved in the fraud is rupees 10 lakhs or 1% of turnover, whichever is lower. Okay. If it is 10 lakhs or 1% of turnover, 10 lakh rupees or 1% of turnover, whichever is lower. If it is that much amount or more than that. If it is less than that, right side. Whether public interest involved, yes, no. Jail, 6 months to 10 years, 3 years to 10 years. And fine. Up to 3 times the amount involved, up to 3 times. If it is lower amount and a small amounts of fraud is involved, 10 lakhs or 1% of turnover, then public interest involved, no, not involved. Then jail up to 5 years, that will be or 5 years imprisonment or 50 lakhs or sometimes even both. Okay, next. Everyone tell me 34, 35. Did you understand clearly? Yeah. Now let us come to section number 36. See, section 36 is completely a different Magnus. It is not like before. It will be having a different kind of applicability. Listen carefully. 34, 35 is relating to prospectus only. 36 is not relating to prospectus. May be prospectus, may not be prospectus also. Misguiding public, deviating public, spoiling the mind of public. Okay, all kinds of, with no exaggeration, this section was brought 100% with a view to avoid cheaters in India. Okay. Cheaters, where they are located? I don't know now where the location of cheaters are. That's why, if you remember, in India, COVID time, 2020 COVID time, share market boomed like anything in India because people were idle in the sense that they have no other great work. So they are free to analyze and understand how the stock markets are working. At that time, if you see, Instagram, so many people who doesn't have any kind of financial graduation, who doesn't have any kind of financial analysis skill, started making all nonsense in the YouTube as well as on Instagram. They started promoting about invest in this stock. I have kept 4 lakh, it became 100 lakhs. Okay, I kept 1 lakh. One day I got 25 crore. Like that, they started just for their views and just to grab attention towards them. They just made some nonsense statements, and moreover, sometimes stock market is just like a gambling bet. One day you might have got, we don't deny. That does not mean you have a skill in the market. Therefore, what these idiots have done in the past, Instagrammers and other people started making a lot of false statements and nonsense about the stocks. What they will do, they will make baseless statements. Okay, they will make baseless statements. This company has made this much profit. This company you can invest. It's a multi-bagger stock. Like that, they started making nonsense in the stock market or nonsense on the YouTube and Instagram channels. No qualification. That fellow will be a BCom graduate, or that fellow will be a normal MBA graduate from some university with due respect to the university. Okay, with due respect to the university, he is graduate from that, but he don't have professional skill to analyze stock market. That's the main problem. And these are not my words. These are the words given by SEBI chairman at that time, Sri Madhabi Puribash. She was the first lady to take a revolutionary measure in SEBI. Do you know what she said? 2021-22 time, she passed a circular, a serious circular to all Instagrammers and YouTubers. If you are promoting any stock on online platform, you should be either a chartered accountant or you should be either a SEBI certified person. Other than these two, if you unnecessarily do any nonsense in finance on the YouTube and Instagram platforms or any social media platform, we will be taking severe action against you under Section 36 of Companies Act. Under Section 36 of Companies Act. What he said, see, there is a person called as Mr. A. Mr. A is not a chartered accountant. Mr. A is not a finance professional. Maybe he might have got a general knowledge on overall stock market working. He will start doing all reels, everything, whatever they want on YouTube and Instagram platform. It can reach crores of people also. I'm not denying that fact. Reel reaching public means all nonsense reels are also reaching public today. What is so great about it? Therefore, what they said, they will suggest, I have invested this much, I received this much. You are having 5 lakh, 10 years, so this will become this much. Or you are a salaried employee, your money will become 10 times. You follow this strategy. Like this, they started making, weakness of the public, they made it as a strength to make money. SEBI took seriously. Do you know what it said? If you are a certified SEBI professional, you can do that officially. That's why if you see any Instagram channel today who is suggesting stock, he will first tell, I am Koushik Mukhesh, SEBI certified, he will tell first. Why? You should have SEBI certification to tell, or you should be a chartered accountant, Either become a CA and talk about stocks, or you become a SEBI certified professional and then talk about stock. Without being any of these two, if you stock now, you are gone. That's why what these people, Mr. A is there. Once upon a time, Mr. A used to blabber on YouTube and Instagram like anything. Became extremely popular during COVID time. Now what he has done, SEBI rule passed. Now he is not a CA, he is not a SEBI certified professional. Understood? Because of his practice, because of his skill to talk and make engaging reels and content, that does not mean you are an expert in stock market. You are expert in making reels and shorts. You are not expert in making stock market analysis. Therefore, what the SEBI has passed the rule, it said that you may be a very good analyst, but not a professional. By fluke, sometimes it will go hit, it will go flop. You don't know strategies inside stock market properly. You are not a chartered accountant. You are not a SEBI certified person. You are a normal MBA with due respect to the university. Okay, for that position, you are not fit. But you are talking all nonsense in the channels. Avoid it. If you don't avoid, we will avoid you. Therefore, what SEBI has done, it passed a rule saying that Section 36 will be seriously implemented on all social media platforms. Whoever blabber nonsense without having knowledge, without having proper certification. So what it has done, it said this way. See, either you should be a CA or a SEBI certificate to talk about stocks. That's why Mr. A, who used it to blabber himself on YouTube and social media platform, now he will start an organization. Okay, now he will start an organization called as X. In that organization X, he will not talk now. He will bring so many other persons who are SEBI certified, who are chartered accountants. From them, he will take commission now. That is allowed now. I said, who do not have a certification should not talk. You don't have anyway. Therefore, what this person started doing now, he will pick people from various places. Koushik Mukhesh, you are having a good knowledge on stock market, then join my club. Come, join this. Through you, I will do advertisement. I think you might have connected as of now. Everyone. So, point is, I will not do any advertising now. I will do through you. Because you are certified, though I am not certified, you are certified anyway. You are a chartered accountant. That's why I always tell, he is a CA. He is a CA in all reels. Okay. Why? If he is not CA, you will go inside. That's why this is all happening in India. That's all power of Section 36 of Companies Act. Companies Act Section 36 was implemented very strongly. Did you understand the point or not? So, whoever make any person knowingly, recklessly, and negligence just to make money, makes any statement, promise or a forecast statement. Sir, this company managing director I know very well. Invest in this stock. Your stock will grow. Statement. Sir, last month share price is in 100. Now it became 120. Promise, sir, it will become 145. Any kind of reckless promises you make. Forecast, sir. Markets are like this today. If this happens, this will happen. If Trump do this, India will do this. Because of that, markets will go like this. Who know all these things? Who know all the market? Big manipulation. On that, who you are, who I am, to forecast what will happen. Do you know what happened latest yesterday? Today, what is the date? 29th November. 28th November I am talking about. Which one? 28th November I am talking about. Okay, you can go. Today, Saturday markets will not run. Okay, every day I am the person who will trade. I trade on options, futures, everywhere. So, see, 28th November, yesterday, do you know what happened? Markets boomed like anything. 2.5 lakh crores boom happened. Okay, IT stocks are down. Completely down, IT stocks. Why? If your forecast is right, IT stocks should grow now first. IT stocks are dull today. See, first point number one, IT stocks are extremely dull yesterday. Not yesterday, last 3 days, IT stocks are dull. Markets are going raised. You understand the point or not? So, point is, lawmaker wanted to tell, if any fellow makes any reckless statement just for social media attention, making any knowingly or recklessly, making any kind of statement, promise, or forecast, which is a false, cheating, misleading, or deliberately conceals any material fact. That's why whenever companies produce or any company, merchant banking service, anyone provides any mutual fund, what they will tell in advertisement, mutual funds investments are subject to market risk. Please read the offer document carefully before investing. That's called as giving out the fact that markets are risky. But these people who are making nonsense on the YouTubes and Instagram channels on stock market, do they know consequences of middle class families investing the money in the stock market, believing in these fellows? Hard earned money, so many people are putting in stock market by believing in these people. So if the money is gone, who is responsible? Who will take you? You will come and save him. Your people will come and save him. That's the problem of SEBI. See, in my statement, you should understand the pain middle class is undergoing in India because of false statements. So the point is, if any person makes any knowingly, recklessly make any statement, promise, forecast which is false, deceptive, and conceals any material fact, and forcing another person to enter into any agreement, by doing all these things, what you are doing? You are forcing a person, inducing a person to do what? Buy, sell, buy, see, subscribe, buy, acquire, sell, dispose, underwrite the securities. Means you are doing four things. Either asking him to subscribe for an IPO, you will tell, this stock, it's a multi-bagger stock. Invest in this company IPO. That IPO company might have hired him as a broker. So many people will blabber on YouTube. What they will tell? This company is going for public offer. Invest in this stock. That fellow is a broker between company and public now. That's the problem. This broker batch will be there. The broker batch, what is their main purpose? The broker batch main purpose is company will hire them. Company will go for IPO. At the time of IPO, they want money. Means it should reach public. They will hire one person who is already having a charm in social media. They will pay money to him. They will tell, now you bark. That's it. He will bow, he will bark on YouTube. People will believe and invest in IPO. Share prices drop. That's the problem of SEBI. Do you understand the point or not, everyone? So, you are making me to subscribe. You are making me to purchase. You are making me to sell. You are making me to underwrite by your wrong statements. And or sometimes F&O segment, they will make you to invest money. F&O segment, recently when I am taking classes in Chennai, one student came to me and said, sir, I kept money, sir. 7,000 rupees I kept in F&O. Now it became 100 rupees. Lost everything. 7,000 rupees is extremely small amount in F&O. I know that. But for a student, 7,000 rupees is a big amount. Asal first, who told him to invest in F&O? Somewhere he might have seen. That's the problem. SEBI main problem is not about telling in anything in social media. But don't tell nonsense statements as if it is true. You should first give a disclaimer. What disclaimer? All the opinions that we are putting on social media are only my opinions. You take decisions gently with wisdom. That's why you see any official YouTube platform of any person talking about stock market, before starting the video, they will give a disclaimer. If I am wrong, you prove me. They will give it. If not disclaimer, then they are liable for fraud if something happens under section 36. They are subjected to fraud. So, what is your intention? Subscription, acquisition, disposing, underwriting. Done. Second, my purpose is not subscription, acquiring securities. Derivatives, I wanted to acquire profit with the change in fluctuations in the market. So, purpose for which is to secure profit from any of the parties from such securities. Okay. So your intention is not to make them buy. Your intention is make profit out of people buying the shares. Second one. The third one. This is much dangerous here. See what is happening in India, I will tell you. There is a bank. Okay. There is a bank. That bank name is ABC Bank. That bank will put Mr. A as a broker. What is the work of this broker? This broker fellow will go to public. He will tell, sir, you have stock market account. He will tell, no. Our bank will open Demat account for you. Free. You come. Our bank will open. Not only that, sir, our bank is providing loan for purchase of shares. See how great my bank is. Please subscribe to the shares by taking loan from our bank. Just 12% interest. Company will give 25% return. You will get bumper offer 12% extra. We will only give you loan. Like this, some people will force, some middle class families and weak-minded persons in finance, they will force them to take credit facilities from the bank by making wrong forecasts on prices of shares, etc. Innocent public taking loans and investing in the stocks. If stock prices drop miserably, they have to pay interest on that principal. And principal have to be repaid also. See, if I invest 1 crore on a land, 1 crore may either become 1 crore or it will go to more than 1 crore. Land life you invest, it will grow. If not, at least it will be stagnant. Okay, I will not lose the value. If you invest in shares, you can't give that guarantee. Share price from 100 can become 20 also, 100 it can become 2000 also. When there is a steep up is there is a steep downfall also for the stocks. The problem. So therefore, obtaining credit facilities in all these cases, SEBI is really doing a great job. All these idiots are liable under 447. Chalo Charlapalli jail. 447, like everyone will go inside. Understood the point? Could you relate to the realities happening around us? Everyone? Yeah. Now next, sir, company made a prospectus, sir. I'm not talking about 36. Listen first, listen. One case study. Company is there. That company is going for a public offer. That company is going for a public offer. Issued a prospectus. A prospectus misleading statements are there. Loss is made by shareholders believing in that prospectus. Okay. Loss is made by the shareholders who believed in that prospectus and subscribed to the stocks. Up to their understandable. Now question. Sir, one shareholder who made losses in Hyderabad. One shareholder who made losses in Vijayawada. One shareholder who made losses in Chennai. One shareholder may be in Bangalore. Like that, shareholders are scattered, sir. Where they should make a complaint. That's why whenever company prospectus is misleading, instead of making individual complaint to nearby NCLT, it is better to make a class action suit. Not there in CA Inter, but remember to the point. Okay, remember the point. What these all people can do, they can form a consortium, syndicate. All these affected parties can form a syndicate. They will form a consortium and then they will file a complaint. Then the strength of complaint will be extremely high than individual one person making a complaint in NCLT. So whenever group of people can form together, that will be the best way of filing a complaint. For that only section number 37 came. See here. Action by affected persons. A suit may be filed or any action may be taken under 34, 35, 36 by any person or group of persons or association of persons affected by misleading statement or inclusion or omission of any matter in the prospectus. Okay, that's it. So group of persons also can make a complaint. Okay, next. So 38, sir, 38 section we are not going to discuss now because 38 section is there in share capital chapter also. So there we will merge both and we will read. So with this, another set called as liabilities have been completed. Everyone please answer. Did you all understand the concept up to here? Okay. Liabilities also completed. Next one. 27 section, I will give you time. You just read and tell had we already completed this or not. Had we already completed this concept or not? Yesterday, objects clause alteration. I'm waiting for your answer. Okay, done. So next, see here. Now we are going into the next important segment. Now I have only the following areas to cover: red herring prospectus, shelf prospectus, deemed prospectus, offer for sale, abridged prospectus. Okay. Section 26 will contain contents of prospectus that I will leave it for you to read. Remaining everything we are going to cover. See, the 26 section, this small chapter. What will be there in the contents of prospectus that I am leaving for you. Just a small thing, just procedure. Generally, they don't test on section 26, but still, just give one reading and leave. Why to leave completely? Okay. We are now going to cover up remaining areas called as first, red herring prospectus. Which prospectus? Red herring prospectus. I will first explain. Okay. Section 32, red herring prospectus. What is a red herring prospectus? Is the first question. Okay. What is a red herring prospectus? See here. Whenever companies are going for IPO, first I will explain. Without explanation, directly reading the section will not give you anything. But once you understand, reading 1 minute, you can complete the concept. Okay. See here. There is a company going on an IPO. There is a company going on a IPO. Okay. Number one. Number two. Company is going for an IPO. Whenever company goes for an IPO, company will go for an IPO using a process called as a book building process. Simple angle I will tell you without going intricacies into the concept. Okay, I will just tell you overall what is the book building process in 2 minutes. Whenever company is going for IPO for the first time, it don't have any market price in the before time. First time it is going for listing, means market price will be obtained now. Before that, there is no market price for that company. Therefore, how to know at what price I have to issue? Therefore, we will put a electronic bidding wherein whoever is interested will click the prices there. On the basis of the prices received from them, on the basis of number of shares they are interested to buy, finally we will decide two things. One is price and the number of shares. Price and number of shares. Means what? Technically, red herring prospectus is a draft prospectus. What prospectus here? Draft prospectus. Means what? Public offer, prospectus, draft prospectus. The draft prospectus ki pere red herring prospectus. Red herring prospectus will contain all details about the company. Everything. Every detail will be there except two things. It will not contain full particulars. It will contain full particulars of price will not be there. Number of shares will not be there. Number of shares will not be there. Okay. Why? Price K we are going to issue that. What we will do, we will issue our red herring prospectus and say to the public, read my prospectus. Okay. I am giving you a price band. I am giving you what? Price band. 100 to 110. I am giving a price band. Within this price band, you quote one price. 107 or 106 like that. So many prices will come. I will average and fix one price. So I am fixing the price and then asking public to buy, or I am asking the public to fix a price. Public to fix a price through an electronic book building process, that's called as book building process. Beyond this, I don't want to discuss in a revision class. Okay. You know, book building process, normal class of 1 hour I will take and explain as all these things. Now this is not the time to discuss those. 5 minutes for each prospectus. That's it. So start again. Company is going for IPO. Wanted to issue red herring prospectus. Red herring prospectus is optional. If you want to issue, but generally in India everyone is doing that. They are issuing red herring. Reason? IPO means the danger is we don't know at what price to issue. Therefore, we will ask the public only. You fix one price. Finally, we will fix one average price called as a cutoff price. Then we will go with it. So therefore, red herring prospectus is a prospectus which may be issued by the company, which does not contain full particulars of price and number of shares issued. Okay, you will tell how many shares you want to buy. On the basis of demands I receive, I will fix the total number of shares. So red herring prospectus is a draft one. It do not contain price and full particulars of price and number of shares. But once I receive demand from so many public, I fixed the price at 107. Total shares are 5 lakh shares we try to issue. We receive demand like that from the public. Now, final prospectus will contain price or will not contain, will contain final price, will contain total number of shares issued and total capital raised. Okay, so red herring prospectus ki final prospectus ki what will be the difference? There is a variation between what? Red herring prospectus and final prospectus. Variation will be in two things. Price, final price will be fixed, not maximum number of shares. Total number of shares actually subscribed will be there in the final prospectus. Okay, so red herring prospectus when you issue to the public will contain some details. Some variations will happen in the final prospectus. That variation should be quotations, you should highlight. Red herring these are not there, final these are there. Red herring price band, here final price. Red herring maximum number of shares, here total number of shares actually subscribed. Like that we need to write. Red herring prospectus will be filed with ROC and issued to public. Final prospectus also will be filed with the ROC and issued to public. Okay. Red herring prospectus is meant to obtain price and demand discovery. Clear, everyone? Everyone, please tell me, did you understand the purpose of red herring prospectus clearly? Everyone? Everyone? Okay. See here, this is only for your reference. Recently, I have taken one capital markets class. In that, we analyzed lens card, recent public offer. Red herring prospectus. Please read section 32, 100% book built offer. See, if you observe the prospectus here, up to so much equity shares, number of equity, up to they said, this is the maximum number. This is red herring prospectus. We are going to maximum issue this. How many will be actually subscribed? I don't know. That's why red herring prospectus maximum only I will give, not actually how many subscribe. Price you see, they will not tell. It will not contain full particulars of price. Understood? This is how it will be. See, finally you will fix one price. How you fixed also you have to give basis for offer price. $100 to 110 I said finally 107 fixed. 100 is called as a floor price, 110 is called as a cap price, final price is called as a offer price, also called as a cut-off price. These are all some important things that I can tell you. We don't have time now. This is a revision class. I can't spend time to explain you. There I explained everything. Who are these people? What these people will do? Everything was analyzed there. Red herring prospectus. 100% book built offer. See here. I will show you one point. Initial public offering of up to means what? Maximum. We will give you 1000 shares. But how many you will subscribe? I don't know. That's why I don't write the complete particulars of shares. Price of. I won't write. Why we won't write price? A price we are giving this. You read everything other than this. See here. Number of pages if you see here. This side. My pen is there now. 1083 pages is there prospectus. 1083 pages ki final prospectus also will be there. Final prospectus dots will be filled. I will not write up to, I will write actually how much capital. I will not write dot at the price. I will tell actually what is the price. Understood the point? Did you understand practically also now, everyone? Okay, so this is how it will look like. Yeah. Beyond this, I can explain each and every point inside this, but this is not the time to learn them. Okay, we are short of time now. Revision time we can't do. So, red herring prospectus and final prospectus, there will be a variation. Variation means some additions will be there in variations separately you have to highlight. So that people will know, okay, previously this is not there, now it is there. For understanding sake. Understood the point? Yeah. Now, let us read the concept of red herring prospectus. Read this. Red herring prospectus meaning prospectus which does not contain complete particulars of quantum, means amount of shares and price of securities included. Company proposing to make an issue of security may issue RHP prior to main prospectus. RHP should be filed with ROC within 3 days prior to opening of subscription. Okay, 3 days before. If today you are opening book building subscription, 3 days before a RHP should be filed with ROC. Okay, RHP to have same obligation as prospectus means if any misstatements are made in the RHP, same whatever we read 34, 35, that's a criminal liability, all these will get attracted. Variations between RHP and final prospectus should be highlighted as variation. Okay, but when the offer is closed, you received final price upon closing of offer of prospectus, not RHP, final prospectus, stating therein total capital raised actually. No more up to, you should tell total capital raise and closing price, also called as the offer price, and other details which are not included in RHP shall be filed with ROC and SEBI. Did you all understand the point clearly or not? Everyone? Okay, that's it. This is all about which prospectus? Red herring prospectus. Next one. What is a shelf prospectus? See, there are companies who plan to go for multiple public offers in 1 year time. Multiple public offers in 1 year time. For them, there is one formality section came called as a shelf prospectus. What does it mean by shelf prospectus? Shelf prospectus is a final prospectus only. Shelf prospectus is a final prospectus only. But what happens is, there is a company. Why you will issue prospectus? I want to tell about my company, that's why I will issue prospectus. Kada? What great changes will happen in 1 year time to your company? Therefore, there is a company which planned for 4 public offers in 1 year. 4 public offers in 1 year time frame. They wanted to make 4 public offers. Therefore, 4 public offers when you have to make, you have to issue 4 prospectus. What will be there? 1000 pages of what you will write about your company. A 1 year time of 4 times your company will change. Therefore, they got a thought process. When companies are going for multiple public offers in 1 year time frame, you do one thing. This is called as at the time of opening of first issue. At the time of opening of first issue. A first issue time lo you prepare final prospectus, call it as a shelf prospectus, file it with ROC. He will keep it in a shelf. Whenever further public offers are going on in the same year, different multiple public offers, this will be given again to the public. That's all. If any public wants, now we will put this, they will read this. Are you understanding? So shelf prospectus is not given to public. Shelf prospectus will be filed with ROC. Filed with ROC. And you can give the first prospectus to public whenever they ask. After that, again and again, you need not give your prospectus to public. Okay. So now, what will be the time frame validity of shelf prospectus? 1 year, not financial and not calendar year. 1 year from the date of opening of first issue. For example, this was opened on 29th November 2025. 29th November 2025. What happened on 29th November 2025? On 29th November 2025, they opened the first offer of securities. From there, 1 year you need not again issue any fresh prospectus. The prospectus what you issued and kept in the shelf will be valid for a period of 1 year. Any number of public offers you can go with that shelf prospectus. Now question will arise, sir, no sir. For example, on 5th May 2026, 5th May 2026, company took 100 crore loan. For that, asset is kept as a security and a charge created, new charge is created. Now company financial position will change, sir, but that is not there in the old prospectus, sir. Then therefore any variations made, like new charges created, changes in the financial position of a company, if anything happened after issue of shelf, before going for subsequent public offer, anything happens, those variations should be filed with ROC in the form of information memorandum. So what will be there in information memorandum? Any changes which are not there in the shelf, which happened after shelf but before second offer or subsequent offer, those will be maintained in information memorandum filed with ROC. Okay, now question, sir, I am a subscriber, sir. I wanted to participate in all the 4 offers of this company. Okay, I subscribed. I paid application money for all the 4. Okay, I paid application money for all the 4. First offer going on. Second offer. Okay, second offer. First one over. Second one when I am doing, I came to know that these are variations that have happened. These variations are happening. Now I got a doubt. Since these variations are happening, I issued information memorandum. He saw. He thought that this is a bad company. Unnecessarily I subscribed to other public offers. Now he wanted to withdraw. Can he? Yes. So because of the variations happened in the company after shelf but before subsequent offer, those variations are not happy to the public. They can withdraw their application money and they can get back their money also. Is the concept of shelf. Everybody understood the concept or not? So this is concept. Whatever is there in the act only I told you. I did not tell any story. But let us see how to present in exam in the form of a chart. First, shelf prospectus. Meaning, shelf prospectus means a prospectus in respect of which securities or class of securities included are issued for subscription in one or more issues over a certain period without issue of any further prospectus. So you can subscribe for multiple securities, multiple public offers without issuing further prospectus. Provision. Any class or classes of companies as SEBI may provide in regulations may file shelf prospectus with ROC at the stage of first offer of securities, which indicate a period not exceeding 1 year. Validity shall be commencing from the date of opening of first offer. I told you not financial year, not calendar year. With respect to second or subsequent offer, no further prospectus is required. Information memorandum in form PAS2 within 1 month prior to the second or subsequent offer. Within 1 month prior to the second or subsequent offer, file with ROC an information memorandum. Information memorandum will contain the following: new charges created, change in financial position, other changes. Intimation of changes. Where company has received applications for allotment of securities along with advance payment for subscription before making such change, company to intimate such changes to applicant. If they desire to withdraw application, refund back within 15 days. Did you now see each and every point what I said is there? Everyone, are you clear now? So just you need to put your mind and read once. That's all. Matter is over. Next. Next one. So we now completed red herring, shelf. Both are completed. Abridged prospectus, let us cover. See here. I will give you an example. First, I will discuss. After that, we will read. Okay. See here. As I said already, same concept again. Same old discussion. See here. Whenever you are asking application money, you should not send prospectus. After that, you should not send application form. Okay. Whenever you are sending the prospectus, last page to the prospectus should be application. Means what? Read entire prospectus. If you like our company, then fill that application form, send a check or pay through NEFT or RTGS to the company account. This is the idea. Okay. Now tell me, 1083 pages of Lenskart IPO document, who will read in India? I only didn't read. I subscribe for Lenskart shares. I only didn't read fully. I just read some things which are very important, capital expenditure and certain things, prospects of the company I read. I felt okay, it is good, not great, it is good. So I started investing. I kept my good amount of money in Lenskart IPO. Sorry. Now my question is, I will invest in the shares of Lenskart. I understood. I will read only what is important for me because I am a chartered accountant. I've been in this segment of capital markets and I take sessions, say, for so many people in Chennai for capital markets and other things. Regularly, I will take. And being a chartered accountant, I am certified. So I will tell about how this public offer works. Decision will be always to the public. We can tell only what is happening. Decision has to be taken on own. So these many things I know, I only didn't read everything. Hardly 60-70 pages I read totally. Whatever is very important, I saw its financials, I saw their audit reports, I saw the auditor comment, I saw board commitment on the comments of auditor. I saw certain very important extraordinary items sitting on the P&L account of this Lenskart. And I understood, I have taken in my Excel, I have a, what to say, I prepared one software, my own software. In what? In Excel. Excel with good amount of formula, I prepared one document. Whichever company is there, if I put numbers there, they will give ratio results. On the basis of ratio results, I can analyze. See, in my YouTube channel, I kept one a TCS analysis on ratios. Like that. So when I teach FM, I used to teach that. So I know the ratios, whatever are very important. So I analyze those ratios. Around 17 ratios I have in my Excel document. I prepared like that. In that Excel document, a tailor-made. When you put the numbers, automatically ratio results will come. 17 ratios. 17 around 11 ratios are very good. 4-5 ratios are very bad. 2-3 are moderate. So I thought, okay, decent enough. We can invest in this company. So I invested. This much analysis I will make. But now tell me, how a normal investor will know 1000 pages what is relevant for him? How he know? Therefore, they brought a concept called as a abridged prospectus. Means what? Abridged prospectus is a extremely condensed form of 1000 pages prospectus. Means what? I said the final prospectus means 1000 pages. They don't send to public. They will die. Okay. Therefore, what they will do? They will give you abridged prospectus. Abridged prospectus is a material type where 10 pages, so they will complete everything in the prospectus. 10 pages, a restriction on 10. SEBI restricted to 10 pages. 10 pages, so they will tell everything in the final prospectus. Are you understanding the point? Don't tell entire Ramayana Mahabharatam now to me. I can't listen to that much of things. Tell me in a shortened version. What is this company? Tell in half line or one line or one paragraph. Who are the promoters? One paragraph. Public offer price, one paragraph. How you got that? One paragraph. Who are the auditors? Who are the directors? What is their commitment? What they are going with this money? What is the total profit in the P&L account? Don't give entire P&L statement. We don't have energy to read. Give me how much is the total profit in the last 5 years. Auditors comments, you tell me. Adverse, disclaimer, unqualified, qualified with some reservations. Only that summary. I wanted to know how many board meetings are held, whether dividends are paid out of reserves or not. Like this, some important things SEBI will already prepare. That prospectus we call abridged prospectus. Abridged prospectus will be there. Na? Final page of abridged prospectus is application form. Read this 10 pages and then invest in the shares of the company. That is the logic of this section. Every form of application form for purchase of any securities of a company shall be accompanied by abridged prospectus. Only application form cannot go. It should go along with prospectus. Okay, next. Copy of prospectus shall, on request being made by any person before closing of subscription list, be furnished. If any person asked, I want full, only to him you give the full. Default punishment. Next. When abridged prospectus is not required, this subsection shall not apply if it is shown that form of application was issued in connection with underwriter. Underwriter will read everything and then only they will underwrite. For them, don't give abridged, not applicable. Next one. Public offer not made. Private placement we are making. You need not issue any kind of prospectus. Application, that's why private placement, what is there? Private placement offer come application form is there, not prospectus come application. So it's not applicable for private placement. Where offer is made to existing members. Existing members already know about your company. What you will tell about your company again to them? That's why. Very, 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 very important. Examiner, they will ask this point. Be careful. Okay. Next. Sir, everyone understood this concept clearly. Live students. Last and final, yeah. Two very, very important sections are there. Last attempt, these two only made students' life miserable. Deemed prospectus and offer for sale. Okay. Deemed prospectus versus offer for sale. One is governed by 25, one is governed by 28. Both are offer for sale type. One is a deemed prospectus, another one is a direct offer for sale. First of all, everyone understood the concept up to here. Na? Everyone? Shall we go to the final point of prospectus chapter? Yeah. First, see this. I am making it available for you. First, read this. After that, we will go into concept. Till now, what I have done, first concept I explained, after that you read. Now reverse, let us do. Read the rule also. Okay, have you read? Everyone, have you read the point? Shall we now move on? Listen, I have given good time, around 3 minutes time I have given you to read. See here. What is this concept all about? Let us first try to understand. See here. India, last 4-5 years if you take, 100 IPOs will be made, means 95 IPOs are attracting section 28 including Lenskart. See this. Offer for sale. That's how it is happening. Offer for sale. So everyone, almost everyone, offer for sale. So what is this concept of offer for sale? We need. That's why exam questions are asked. Students are not reading because of complexity in its language and other things. Gone. So let us understand properly. Okay. See, companies, for example, let us take LIC. Let us take LIC. LIC went for a public offer in the year 2021. 2020 ending, like went for public offer. LIC 2021 public offer, IPO it made. As per the balance sheet and other things of LIC is having cash deposits, time deposits, demand deposits, insurance policy receipts, all put together running into some lakhs of crores. And already it is having lakhs of crores of rupee with it already, LIC. Understood? Now question is, LIC public offer amount, you know how much they raised? 21,000 crores, which is not even 1% of total LIC's net worth. Not even 1% of LIC's total net worth. I see. My net worth is 2 crore. I wanted to purchase an apartment worth 3 crore. Then what I will do? I will go for a bank loan. Basic understanding, na? Because my existing net worth is not capable of buying that property. Therefore, we all go for a loan on a building. Correct or not? That means we will be capable of paying some amount on the building. 1 crore building na, or 4 crore building na, 1 crore I will pay. 3 crore we go for a loan. Correct? Now, 1 crore, 3 crore means 1/4 I have, 25% I am having. 3/4 I am going for a loan. Here, I am already having lakhs of crores of cash balance. Then why you are going for 21,000 crore public offer? That's the question. For that only offer for sale. First person, not first person. So many times it happened. But the craze of offer for sale increased after LIC. What LIC has done? LIC do not want any money. No, LIC don't want money. LIC has a lakhs of crores. Yeah, what is your 21,000 crores? It's peanuts for them. Therefore, 21,000 crores money of public is not going to survive the LIC. LIC la promoters are there. Promoter is a central government. Central government wanted to sell its stake to public. Till then, LIC shares are only in the hands of central government. And some big industrial companies are there. They are holding it. Government of India is one of the promoter of LIC, one of the core promoters, 75 to 80% holding is there. This government of India wanted to privatize LIC. Privatization of LIC means what? Shares of LIC will not be no more in the hands of government only. It should also be in the hands of public. Therefore, what they said, they diluted their stake. Means what? Government is holding, let's say for example, 70%. Actually, do you know what happened? 3.2% stake of LIC was sold now. 3.2% value at 21,000 crores. Understood? Government stake, let us say 70%. 70% 3.2% belonging to the government, they sold. Okay, how much percent? 3.2. Coming to how much? 21,000 crore. Now, who sold? LIC did not sell. LIC issued shares to government long back. Government of India, who is one of the shareholder of that LIC, is selling the shares to public by putting an offer for sale. It's not subscription. LIC is not giving shares for subscription. It's a sale. For other party, it will become purchase. It's not subscribing the shares. So they are purchasing the shares of this particular company, LIC. So LIC is issuing the shares. No, LIC shareholders are selling their stake to public. Public are purchasing it. Okay. So now government cannot go to public and directly do that now. So Government of India through LIC, they are issuing offer for sale to the public. So Government of India is selling 3.2% of their stake to LIC. They will not sell. They will sell 3.2% stake to public, but they will not do it directly. They will do it through LIC. Okay. Now LIC, what it will give? On behalf of Government of India, LIC will issue prospectus. No. LIC will issue offer for sale. Offer for sale. This offer for sale is an offer document. It should contain details about company. This offer for sale will be deemed as a prospectus under section number 28. But Government of India is making LIC to do this, all this circus. So LIC board of directors should first approve. That's what said in that section number 28. So offer for sale, existing members of the company will sell their stake to the public. Any document which is issued as an offer for sale by LIC, by company to public, will be deemed as a prospectus. In this offer for sale, if there are any misstatements or omissions, same punishments for section 34, 35, 36 will get attracted. This is what they wanted to tell in this particular concept. See, where certain members, LIC, here Government of India, individual or body corporate, of a company propose in consultation with board, LIC board of directors, to offer whole or part, 3.2, part of government holding, okay, to public, the members shall authorize company, authorize LIC here, to take an action for offer for sale. Then they shall reimburse the company. LIC is doing all this work. Whatever expenses LIC incur, company will reimburse them. Document by which offer for sale is made, LIC, to public, shall be deemed to be prospectus issued by the company, and all provisions relating to content and misstatement shall apply. See how easy it is. Everybody now understood the main crux of this section 28. Okay. The promoters who will sell, the promoters, so members who will sell, they don't know at what price they should sell. Market price is always manipulative. They don't know at what price they should go. Okay. And if company is no more, LIC is not a listed public company at the time before government went for public offer. Therefore, the promoters wanted to know at what price they can sell. That's why they issued book building. Lenskart also same. Lenskart is a public company, but it's not a listed public company. Lenskart plus shareholders are there. Those shareholders wanted to sell their stake to public now. They wanted to know at what price they can sell. That's why book building process is introduced there. Do you all understand? Everyone? Therefore, see, that's why whenever you are going by offer for sale, application, allotment, first call, second call, final call, all these nonsense will not be there. Money will be collected in one stretch. No application, no minimum subscription. Take, go on, over. That's why it became fast food center type. India it's becoming popular. Provisions relating to minimum subscription shall not apply. Minimum application value 5% shall not apply. Provisions relating to the provisions requiring any statement to be made by board of directors in respect of utilization of money does not apply, because company is not getting money. LIC is not getting money to utilize money. Shareholders of LIC are getting money. Therefore, how LIC will utilize that money? Public are giving money to LIC, public are giving money to the shareholders, in this case, shareholders. Then how LIC will utilize money? No. So, any other provision or information that cannot be compiled with everything. That's it. I hope every one of you now really understood what is the idea behind section 28. Correct? Now, let us see. This is one of the questions that they tested in the latest exam. Now, what is the next concept? Deemed prospectus under section number 25. The last section for prospectus chapter in our revision. Please. 10 minutes time we have to spend. Listen carefully, very, very important. See. Okay, see here now. There is a company, public. Okay, public. Market intermediary, also called as issue house. Persons who are helping us, mediation. Okay, now listen what happens. Please. This company wanted to go to public. Okay, this company wanted to go to public and issue its stocks. But no one know about this company. Public offer can become failure. Therefore, they wanted someone to spread positive about this company and then go to public offer. For example, I said you, go and take that book, you buy that book, good for law. You may not buy. But if a authentic person like me say you, go and buy that book, you will buy. Some third party coming to you and saying that buy that book means you will not. But if some authentic voice say you, you can buy that book, now you will buy. From this, what you understand, people may not believe others' voice, but authentic person, if they say, people will believe that. Same concept here. Company, if it goes directly to public, public may not care it. But company will take the help of market intermediaries, issue houses, etc. And then they will ask them, you stand as an intermediary, you do all the things about my company. You do all the things required. I will pay you commission for that. Okay, who will tell? Company will tell a market intermediary, who is also called as a issue house in our example. So listen carefully. Diagram makes all the sense. Company will issue prospectus to issue house. Issue house will read it. Okay, and it was satisfied. Then company will issue shares to the issue house. And issue house is a shareholder? No. With a view to, wording important. Wording important. With a view to allot to public. Means I am issuing you shares not with an intention that you will become shareholder. With a view that you will issue to public. So repeat. There is a company. That company issued prospectus to a market intermediary or a issue house. Just a minute. Company issuing a prospectus. Okay, issuing a prospectus to issue house or a market intermediary. Next, they issued also the shares. Next, they also issued the shares of the company to the market intermediary or to a issue house. Their main motive is with a view to allot the shares to the public. With a view to allot the shares to the public. Finally, the shares should reach public. That is the intention. So, prospectus is issued by whom? Company to the issue house. Issue house will read that prospectus. If it finds that this is a genuine company, they will promote that company to public and they will sell the shares to public. Now, what will happen? Public will subscribe. And they will give money to this issue house. This issue house will take that money minus commission they will deduct. Net consideration will be paid to the company. Net consideration will be paid to the company. So see the entire diagram. How it look like? Company issued prospectus to the market intermediary. Market intermediary or issue house will read it. Then it will issue shares to market intermediary. Not with a view that you will become member, with a view to allot to the public for public offer. They will give consideration. You will deduct some amount of commission and pay me net consideration. And a very, very important condition is time gap between them should be not more than 6 months. Means what? The day on which I allotted and the day on which you are giving it to public, should not be more than 6 months. Now question, sir, you issued prospectus, okay, to market intermediary or issue house. Let us say it's the Access Capital, SBI Cap Securities, okay, like that. So many market intermediaries are there. See, if you see the lens public of a document, na, so many people are there, market intermediaries and merchant bankers. See, Kotak Investment Banking, Morgan Stanley, Avendus, Citi, Access Capital, okay, Intensive, MUFG, like that. So many people are there, na. So those are the market intermediaries who are standing in between both of us. Now listen carefully what happened. Company will issue prospectus to market intermediary and also issue shares to them. They, with a view to allot the shares to the public. Now they will issue shares to public. Through what? Prospectus issued by company to market intermediary or merchant banker or issue house. Now this market intermediary will issue a offer document. Issue a offer document. Who? Issue house will issue what? Offer document. Offer document providing for what? Providing for offer for sale to public. Because I already purchased the shares from company. Now my work is to sell them to public. Now I will give offer for sale. Now this section says this offer for sale is also deemed as prospectus. Deemed as a prospectus. All liabilities for omission and misstatements will equally apply also in this case. Okay, that's the point. So if there are any misstatements, in this prospectus, this is not deemed prospectus. This is actually a prospectus. This is not actual prospectus. This will become a deemed prospectus. Okay, both sides prospectus provisions will get attracted. This issue house or market intermediary is there, na? This person can be company, LLP, even a firm also. That's why this offer document will be there, na? In case of a company, signed by director. In case of LLP and firm, signed by partners. Therefore, offer document lo any misstatements are there, na, these people will become liable. Prospectus any mistakes are there, na, company will become liable. Did you all understand the diagram clearly, everyone? Okay. See section number 25 now. Company issue to issue house. Okay. To issue at public at large. The document whichever you are issuing will be deemed as a prospectus. See. Whatever I said will be there. Diagram you remember, answer will be completed. Where a company allots or agrees to allot securities of the company with a view that those securities shall be offered for sale to public. Any document by which offer for sale is made and market intermediary to public shall be deemed to be a prospectus. Because of its deeming provision, law relating to contents of prospectus and liabilities will apply. Presumption. How to know whether this is a deemed prospectus or not? Unless contrary, it shall be evidence that allotment of securities was made with a view to securities being offered for sale to public. If it is completed within a period of 6 months and whole consideration had not been received, why? Commission will be deducted. Whole consideration will not be received. Net consideration. Okay. Next, very important thing is signature of a document. In case of company, 2 directors have to sign. Here I said directors. Na? How many directors have to sign? 2 directors have to sign. Okay. If it is, in case of a partner, at least 3/4 of the partners has to sign. These are all the main contents inside section number 25. With this, we completed one very important chapter for the Jan 26 exam. Prospectus chapter has been completed successfully. Okay. So over here, prospectus chapter is completed successfully with this. So the next chapter we are going to revise is declaration and payment of dividend. Declaration and payment of dividend. This is the next segment we are going to start with. In this chapter, declaration and payment of dividend, we are having sections ranging from 123 to 127. So sections start from 123, ends with section number 127 in this segment called as declaration and payment of dividend. Okay. Let us first understand the basics and then start with. See here. Definition of dividends and types of dividend. Definition says like this. 2 class 35 defines dividend includes interim dividend. Means what? Every provision applicable for final dividend is applicable also for interim dividend. That's the meaning. Except if it is provided separately in a different way. For example, there is a provision which says interim dividend this rule will apply, which is different from that of final dividend. Then follow that. If nothing is said, whatever the provisions that are applicable for final dividend equally applies also to the interim dividend. That's the meaning of this definition. Next one. Dividend is declared as a proportion to the nominal value or face value of a share. So dividend is a rate applied on face value. Face value 10 rupee. 20% dividend means 20% into 10 rupees. 2 rupee dividend. There are two types of dividend. Interim dividend and final dividend. Interim dividend and final dividend. First, listen carefully. Interim dividend is declared by the board of directors directly. There is no proposal and declaration. Directly declaration. So who will declare? Board of directors. Okay. Next. It can be revoked with consent of all the shareholders. Means if all the shareholders give the permission, then dividend which is already declared can also be revoked, provided if it is an interim dividend. Okay. Final dividend. 2 steps. Recommended by the board, approved by the shareholders at a AGM. There is a regulation called as Regulation 80 of Table F, which says that rate of dividend recommended by the board cannot be increased by shareholders. Means if a board recommended 10%, shareholders cannot declare 12%, maximum 10%. Who will propose? Board. Who will declare? Shareholders. Who cannot propose? Shareholders. Who cannot declare final dividend? Board of directors. What dividend board can directly declare? Interim dividend. What is the rate fixed by board? It is at the discretion of board. Once the rate is fixed, what shareholders cannot do? They cannot increase it. These are all the various points. Next one. Provisions relating to the dividend. Sources of declaring the dividend. From where dividend has to be declared. Listen, very important concept. Okay, very important concept. Source of declaration of dividend. Final dividend. Final dividend, there are technically 3 important sources. Current year profits after providing for depreciation. Depreciation, how to provide? There is schedule 2. As per that rates you have to provide. Again, current financial year profit after providing for depreciation. Accumulated profits after providing for depreciation. When I say accumulated profit, do not take 4 kinds of reserves. Reserves which are created by notional gains, revaluation gain, fair value gain, unrealized gain. Again repeat, reserves created out of notional gain, and a really gain is not there. Notionally we written in the books. You should not consider into the free reserve. Second, fair value gain. Fair value previously is 1 lakh. Now it became 2 lakh. 1 lakh is a profit. No. Third one, similar to this, revaluation gain. Really it is not really realized by you. Fourth one, unrealized gain. I invested in the shares of a company. X Limited invested in the shares of Y Limited. Investment made is 1 lakh. It became 2 lakh now. 1 lakh is not a profit made by you. It will be the profit you make if you sell. It is realized or unrealized or unrealized. Those gains also should not form part of reserves. So, previous financial year profit means simply he wanted to talk about accumulated profit. But what accumulated profits? Accumulated profits are of 2 types. credit in P&L account and free reserves. I will tell you the difference first. See here. P&L account is there. Understanding sake, I am writing T-shaped P&L account. Originally, that kind of P&L account is not in usage today. Vertical P&L they are using. Example sake, I am telling. Okay. See here. Gross profit is there. Other incomes are there. Salaries, other expenses are there. Profit before tax. Tax is there. Profit after tax minus preference dividend is there. Earnings available to equity shareholders. Earnings available to equity shareholders. Equity dividend paid. 100 crores came, 50 crores paid. Still, earnings available to equity shareholders after equity dividend 50 is there na. This 50 is called as P&L account credit balance. Okay, it is not transferred to any reserve. It is not transferred to any reserve. P&L account credit balance means what? See, in this 50 I transferred 20 rupees towards dividend equalization reserve. Now that will become free reserve 20, P&L account balance is 30. From this again I transfer 10 crores towards general reserve. Now free reserve became 20 plus 10, P&L account balance will become 20. P&L account credit balance has a great significance in Companies Act. Do you know what? P&L account credit balance is not a free reserve. It is a much powerful than free reserve. P&L account credit balance means it is considered as profit directly. Profit transferred to reserves is a free reserve. Profit transferred to reserves is a free reserve. Profit not transferred to free reserve will stay in the name of profit only. It's called as P&L account credit balance. Did you all understand my words clearly or not, everyone? Everyone reply. Understood? Okay, well, everyone understood clearly what I said now. That clarity you should have always. When you are writing exam also, you should have a clarity. P&L account credit balance, P&L account credit balance, and this particular concept both are not same. P&L account credit balance is much powerful than that of what? It is much powerful than that of normal free reserves. Got the point? So than free reserves, it is much more powerful. Okay, done. Next. So point is profits came transferred to dividend equalization is 100 rupees came. Okay, this 100 earnings available to equity shareholder, profits 100, dividend equalization reserve I transferred 20, DRR I transferred 20, CRR I transferred 10. Okay, I transferred 10. Next, general reserve I transferred 50. Now what I have done, profit of 100 is there. In the 20 went to dividend equalization reserve, 20 went to debenture redemption reserve, 10 went to capital redemption reserve, 50 went to general reserve. So 100 is distributed among various reserves now. Now how to understand? Dividend equalization reserve is a reserve kept aside only for payment of dividend. Means it is a free reserve only. Free reserve means any reserve freely available for dividend. It's called as a free reserve. General reserve is also a free reserve. DRR is a committed reserve, not uncommitted reserve, because that reserve is created only to redeem the debentures. So using this you cannot pay dividend. CRR is issued only, CRR is made only to issue bonus shares, not dividend. This also cannot be used to pay dividend. So these two are not free reserves. So these are not sources to pay the dividend. In our company, what are the two sources from which you can pay? You can pay out of dividend equalization reserve. You can pay out of general reserve. 70 crores available for payment of dividend. Second example, profits 100. Okay. Dividend equalization reserve, DRR, CRR, okay, DRR, CRR, general reserve, balance in P&L account, okay. Dividend equalization reserve ki 20 crore transferred, DRR ki 10 transferred, CRR ki 10 transferred, general reserve ki another 20 transferred, okay, wow. Balance in P&L account is 40 CR. This is called as not as a free reserve. This is a free reserve. This is a free reserve. This and this is not a free reserve. This is not a free reserve. It is more powerful than a free reserve. This will be called as P&L account credit balance. Simply we call it profit. Simply we call it as what? Yeah, profit. This is not a free reserve because we did not transfer to any other reserve account. Profit in the name of profit account directly. It's not a free reserve. It is a profit. That's all. That can be used for payment of dividend. That's why see here clearly. Please, everyone, apply your mind. Previous financial year profit. That profit can be either in the form of free reserve. That profit can be either in the form of P&L account credit. Credit balance in P&L and free reserve. Okay, next. So, profit of the current financial year or previous financial year or both of the above. Means you can use once current year profits are completed, you can also go for past accumulated profits. Next, sometimes central government or state government, will give assurance to the company shareholders in order to develop the companies in cess area, etc. Government will tell, central government or state government will give assurance to them. What it say? Your company started in cess. It will take minimum 5 years to 6 years to come into profit. Till then, shareholders should have a motivation to continue in the company. Therefore, they will tell every year 3 rupee dividend, government will give your company will pay dividend to you. Now, how the money is provided? Not out of profits. Money provided by central government or state government for payment of dividend as per the guarantee given by the government. Next one. Interim dividend. I have to explain interim dividend with a good example. Please concentrate. Okay. Industry is the best example on interim dividend. How to understand interim dividend is the discussion now. Okay. See here. I am going to spend time only on these sections. Once other sections begin, fatafat we will complete the chapter. So please concentrate and put amount of time when concept is complex. When concept is easy, let's move on very faster. Okay, let us see here. Please see here. (31.3.23). 39.23. (31.3.24). 39.24. 31.3.25. 39.25. 31.3.26. Different scenarios we are considering. I am going to explain you the concept of interim dividend. Okay, listen first. Properly focus on the concept. First, end of financial year 22-23. End of financial year 23-24. End of financial year 24-25. End of financial year 25-26. AGM for financial year 22-23. AGM for financial year 23-24. AGM for financial year 24-25. D1, D2, D3. 3 dividends are declared. Okay, 3 dividends are declared. Now the question. 39-2023, there is a dividend declared. 39-2023, there is a dividend declared at the AGM. Okay, this is called as final dividend for 22-23. This is D2 is the final dividend for 23-24. This is the final dividend for 24-25. Okay, for these three, you have sources. Current year profits, past year profits, both CGR SG guaranteed amounts. When I say previous year profits, accumulated profits transferred to free reserve, and P&L account credit balance. Up to here, everyone listening to the class, are you all having a clarity? Yeah, all live students, please answer. Okay, done. Now the second question. So here clarity is there. Okay, here clarity is there. See here. I1, I2, I3, I4, I5, I6. Okay, I1, I2, I3, I4, I5, I6. What are all these? These are all interim dividends. These are all interim dividends. Okay. First of all, question number 1. I1 is a interim dividend paid after the financial year 22-23, before. I1, see the screen and tell. I1 is the interim dividend that is paid after financial year 22-23, before financial year 22-23. I am waiting for your answer. I1 is an interim dividend paid after 22-23 financial year or before 22-23 financial year. Perfect. After they paid means that is the interim dividend belongs to which financial year? That is interim dividend belongs. I1 is an interim dividend. Sir, let us say it was paid on 5th June 2023. 5th June 2023. So that is a interim dividend belongs to which financial year? 22-23, 23-24. Okay. So I1 is a interim dividend belonging to 23-24 because it was declared after 31st March 2023. Okay. Like this, you should not think, sir, what sir? It was paid after financial year, na? Financial year changed. That's the problem with interim dividend understanding. Students are understanding like this wrongly. Any interim dividend, I repeat, any interim dividend declared by the company after the financial year, but before approval of its financial statements in its AGM, will be treated as interim dividend of the last year only. It is only an event occurring after a balance sheet date. Do you all understand what I said? Everyone understood? So, any dividend declared after the financial year, but before the AGM approval of financial statements, will be treated as interim dividend of the previous financial year only. Okay. So, it will not be treated as interim dividend of the financial year, next financial year, just because of the reason that it happened after the 1st March. After the 1st April. So, any dividend declared by the company, repeat, any dividend declared by the company after the financial year, but before the AGM, where financial statements are getting approved, is not treated as interim dividend of that financial year. It will be treated as interim dividend of the previous financial year itself. That's why provisions of Companies Act section 123(3) says that from where you can pay interim dividend can be paid out of profits of the financial year in which such interim dividend is declared. Profits of the financial year in which interim dividend is declared. Like that they will use the word. What does it mean? From the profits of 2022-23 only you will pay interim dividend. Understood the point, everyone? This is one thing that you need to remember. Okay. Second. Now, let us write down point now. This is interim dividend of which year? 22-23. Next one, I2. Interim dividend for 23-24. 23-24. I3. Interim dividend for 23-24. I4. Interim dividend for 24-25. I5. Interim dividend for 24-25. I6. Interim dividend for 25-26. Did you understand all the notations given clearly, everyone? Okay. Now listen carefully. Listen. Story doesn't end there. I1, I3, I5, I2, I4, I6. Okay. I1, I3, I5. These all are paid after financial year but before AGM. Correct? After financial year but before AGM. Now, what are the sources for payment of interim dividend? In this case, the sources of payment of interim dividend are, see here. First, see here. See the screen. Surplus in P&L account. Interim dividend is one of the source. Surplus in P&L account, mean P&L account credit balance if any. Profit of the financial year for which a dividend is to be declared. Old financial year. Current financial year, next one. Interim dividend. So profit of the financial year up to the dividend is declared. And most important thing is third one. See here. Branches you have to see. Interim dividend source. Branch 1 surplus. Branch 2 profit for which the dividend is declared, or branch 3, profit till the quarter preceding the declaration of dividend. Profit till the quarter preceding the declaration of dividend. Okay. So now listen carefully. If you are declaring like this, there are technically three sources available for you. Number 1, P&L account credit balance. Second, profits of the relevant financial year. Because I1 you are paying on, let us say, after financial year, means those are taken from what? You have to pay out of the profits of the previous financial year, 22 to 23. So profits of the relevant financial year. And third source is profits till the quarter. Profits till the quarter. Next one. I2, I4 and I6. I2, I4, I6. What is I2, I4, I6? Interim dividend 2, interim dividend 4 and interim dividend 6. These all are declared after AGM. Okay. So that will be paid not out of previous year profit. Current year profits you should pay. Financial year not yet completed by that time. There are only two sources available in this case. 1, P&L account credit balance. Second, profits till the quarter. Profits till the quarter. This is how we need to understand interim dividend as a concept. This is a full chart. If you understand, then you can score super marks in examination if interim dividend question comes in exam. Did you all understand this chart properly? Yeah. Everyone reply. Did you all understand this clearly? Okay, that's it. So interim dividend will be paid out of what sources is a question. Now we answered. Now question will arise. Sir, I am paying interim dividend on, say for example, 30th October 2025. 30th October 2025. Okay, sir. Now what are the sources that are available for me? Two sources. Okay. Financial year for which interim dividend is declared. That is anyway not completed. So we can't use that. We have two sources. One is P&L account credit. Another one is a profit till the quarter. See here. Quarter 1. April to June. Quarter 2. July to September. Quarter 3. October to December. We are in quarter 3. How many quarters are completed? 2 quarters are completed already. Now, either here there is a loss, here there is a profit. Here there is a profit, here there is a loss. Here there is a loss, here also there is a loss. Here there is a profit, here there is a profit. In the first case, in the last case, you can pay whatever amount you want now. Okay, on 30/10/2025, you can pay any amount of interim dividend, whatever amount you want. If there is a loss anywhere till the quarter, that's why they use the word till the quarter, before the date of declaration of dividend. If there is any loss, he did not tell immediate quarterly loss should be there. If there is any loss till the quarter before, then rate of interim dividend in these three cases, rate of interim dividend should not exceed average rates of dividend declared in 3 immediately preceding financial years. Means final dividend rates you take last 3 years, average it. One average rate will come now. It should not exceed that average rate. In this case, there is no such problem. Whatever rate you want, you can declare interim dividend. First of all, everyone answered this also. Everyone understood clearly? Answer. These are all various issues that we need to understand in interim dividend and final dividend. Okay. Final dividend key, I will tell you more. There are so many other conditions also for a final dividend that we will see when we come there. So up to here, I hope everyone understood clearly, right? Next one. Free reserves are reserves available for distribution as dividend. Okay. But the following reserves are not treated as free reserves. Already I told you this. Unrealized gain, notional gain, revaluation gain, and capital reserve. Next one. Fair value gains. This is. Next one. Before declaration, depreciation must be first considered. Payment of dividend. See here. See, I will tell you some rules. Whenever dividend is declared, see here. Again, another timeline chart. See here. Whenever dividend is declared, D0, within 5 days, transfer the amount to a separate bank account in a scheduled bank. Transfer the amount into separate bank account in a scheduled bank. Total 30 days. Between date is 25 days. Pay dividend to the shareholders. Pay dividend to the shareholders. If you could not pay 7 days, transfer to unpaid dividend account. Whenever you transfer amount to unpaid dividend account, within 90 days of such transfer, statement of unpaid dividend should be placed on website. Should be placed on website. After the transfer to UPD account, it will stay there for a period of 7 years. After completion of 7 years, they will transfer to IEPF account. This is the whole timeline chart for dividends chapter. Okay. Whenever dividend is declared within 5 days of such dividend declaration, amount should be transferred to a separate bank account kept with a scheduled bank. And once transferred, from there within 25 days you have to pay. Until totally within 30 days of declaration you have to pay the dividend. If it could not be paid within next 7 days, transfer to UPD account. Details of whatever is transferred to UPD account within next 90 days you have to place it on website. By the time 127 days completed. Okay. I will wait for 7 years from the 37th day. In that 7 years, no one has claimed any dividend. The dividend will be transferred to IEPF account operated by MCA and SEBI together. Okay. Everybody understood the timeline chart clearly? Okay. Now listen, what I am going to discuss now is, listen carefully first. Okay. What we are going to discuss is, whenever dividend is declared within 5 days, you have to transfer the entire dividend to a separate bank account kept with a scheduled bank. Dividend should be paid only in cash. Dividend cannot be paid in kind. Okay. When I say cash, cash represents not currency notes. Cash here represents what? Cash here represents check or warrant also. Check or warrant also is included. Next. So cash only allowed, kind is not allowed. Cash includes check or warrant. Dividend will be paid to whom? Dividend will be paid to registered shareholder. Registered shareholder said pay to him. Order of registered shareholder. Or directly he said pay to a bank. Banker of registered shareholder. Banker of registered shareholder. Next. Instead of paying dividend, there are some alternatives available. Two alternatives. Company went for public offer 10 months back. It made first call, second call, sorry, it made application money, allotment money, first call and second call. Final call, still 3 rupees has to come. Now you will pay dividend of, say for example, company decided to pay dividend of 3 rupee per share. Example, it can be 4 also. Example, I said, company wanted to declare a dividend of 3 rupee per each share. Now you will pay dividend. 3-4 months after you will tell, dear shareholders, pay me 3 rupees unpaid money on the share. Why you will give 3 rupees? Why you will again ask them 3 rupees? Okay, so partly paid shares may be paid up, need not be fully paid. For example, application money, allotment money, first call, second call, final call. Application money to, allotment money to, first call to, second call to, third call, final call also to. I called up to first call. Now I want to pay 2 rupee dividend. Instead of paying 2 rupee dividend, this 2 rupee deem that they have paid. So partly paid shares can be paid up fully or paid up to some extent. This is one option. Or capitalization of reserves or profits to issue what shares? Bonus shares. So instead of paying a dividend, see, I'm saying instead of paying the dividend, what do you mean by that? Company, whenever make profit, options are there. Either declare dividend. Once you declare dividend, you should pay only in cash. If dividend declaration decision is not there, now alternatives to the dividend, they can either make partly paid shares to be paid up. Some paid up, either fully paid up or partly paid up, they will try. Second one, capitalization of reserves. Capitalization of reserves means what? Money is there in this pocket now. Now it comes into this pocket. Reserves converted into capital. We call it as a bonus shares. Each and every point what I said will be there. Have you read everyone? Okay, enough time such that you might have revised also. Next, see here, read this point also. This one. Okay, va? Have you read everyone? Okay, now listen. Listen again. Again, a lot of drama will be there in this concept. Big concept we completed. Now listen, again drama starts. This is accumulated profits dabba. This is accumulated profits box. Okay. These diagonal lines are, see here. Amount drawn out of accumulated profits. This is accumulated profits box. Diagonal lines are there. Below lines are there. Yes, already there are lines. Blue color lines. Na? This balance is called as This is called as balance after withdrawal. Balance after withdrawal. Okay. So I will be middle. See here now. Concentrate. 2 minutes. Listen. Company wanted to declare final dividend, but in the current year, company is making inadequate profits or absence of profits. Means no profits. 0 or less than 0. Or inadequate profit. Profits are there. I mean, namesake profits are there, but not that much great. But company wanted to maintain average rate of dividend which it paid in the last 3 years. So it wanted to pay some dividend. Can it pay? Yes, it can pay, subject to 4 conditions. Condition number 1. Condition 1. Rate of dividend in the current year should not exceed average rate at which dividend is declared in the last 3 financial years. For example, last year 10%, before last year 8%, okay, and before last year, let us say 9%. So like this I paid 10, 8, 18, 89, 27. 27 divided by 3, how much? 9%. So this year your rate of dividend should not go beyond 9% of the par value of a share. For example, company par value 10 rupee. 10 rupee into 9%. Okay, 10 rupee is there. 10 rupee into 9%. Or if it is 100 rupee, 100 rupee into 9%, 9 rupee. Into you are having 1000 shares. 9,000 is the total dividend you can pay. Understood the point? So on par value, you have to apply that particular rate of dividend. So the rate of dividend should not go beyond how much? Should not go beyond 9%. In that example, how that 9% came? Average of rates of dividend declared in the 3 immediately preceding financial years. Sir, no, sir. In my company, variety situation came. I paid dividend in first year, 0 in second year, again some percent in third. How to do? Then let us say 10% is paid. 10% plus 0 plus 10 divided by 3. Sir, my company itself is in existence for 2 years. Then what to do? Then RD1 plus RD2 divided by 2 you will do. If it is not for 3 years. Sir, only 1 year. That 1 year rate you will take. Sir, my company did not pay any kind of dividend in the last 3 years. Then what will happen? This condition A will not apply to you. This condition A will not apply to you. This is condition 1. This is rate condition. Rate. On this rate we have to pay. Therefore, second condition. The amount to be drawn, arrow marks are important. The amount to be drawn should not exceed 1/10 of paid up share capital and free reserves. Equity and preference both. So 1/10 of paid up share capital and free reserves. So the amount drawn should not exceed 1/10 of paid up share capital plus free reserves. Next, third condition. You will draw amount na, amount will be drawn na. Second step, condition number 2 la amount will be drawn na. So from this, condition 3 is condition 2 amount minus current year losses set off. Current year losses set off. Okay. Next, balance after withdrawal is condition 4. The balance after withdrawal should not be less than 15% of paid up share capital. 15% of paid up share capital, both equity and preference. Okay, this is the situation here. Observe all the 4 conditions. What is the 4 conditions? The rate of dividend declared in the current financial year should not exceed the average rate at which dividends are declared in the 3 immediately preceding financial years. Amount drawn should not be exceeding 1/10 of the paid up share capital in free reserves. The amount drawn should be first utilized to set off the current year losses. Amount after withdrawal, the balance after withdrawal in the free reserve should not fall below 15% of paid up share capital. These are the 4 conditions that you need to satisfy. This provision does not apply to 100% government company. Means what? 100% government company means no other person is shareholder. Government is full. In that case, no problem. Understood the point clearly? Read this. One-tenth means 10%. That's why they have written 10% there. Shiva? I recommend all of you solve illustration in ISM. ISM they have given one illustration. Solve that. If you solve that, you will get lot of clarity. Now we have theoretically discussed na. Okay. Now once you do that illustration, you will get full clarity. You have doubts illa. Next one. Listen carefully. Next concept also let me discuss. I will not take lot of time. I will explain only once. So listen carefully at the time when I am explaining itself. D0. X, Y. X transferred shares to Y. Y paid consideration. Y paid consideration to X. Both of them executed instrument of transfer in form number SH4 for transfer of shares, attached with share certificate also. So D0 what happened? X transferred shares to Y. Y paid consideration to X. For that instrument of transfer is executed between them. SH4 is executed and share certificate is also attached to that. D60. Y sent to company instrument of transfer and share certificate along with the fee for registration. Done. Let us say two different situations. Company have completed its registration on D75. Second case, company completed its registration on D125. D125. So start. D0, X transferred shares to Y. Y paid consideration to X. IOT executed. Instrument of transfer in form SH4 is executed. Share certificate is also attached to that. D60, Y transferred it to company for registration purposes. IOT and share certificate with the fee for registration they transferred to company on D60. D75 came. D75 case 1. D125 case 2. D75. Transfer registered. D125. Transfer registered. Two situations. Case 1, case 2. Independently see both the cases. Now, D70. Dividend declared. D70 dividend declared. Okay. Now, listen carefully to the point first. Okay. See the scenario. First simple concept that we need to understand. Dividend is declared. As per the provisions of 127, whenever the dividend is declared, you have to pay the dividend within 30 days. Okay, you have to pay the dividend within 30 days. Okay, now see here. D70, company declared dividend. D0, X transferred shares to Y. X transferred shares to Y. Y sent it to company on D60. Now transfer is completed, registration is pending. Once the registration is completed, what will happen? Company will remove the name of X in the register of members, put Y in the place of register of members. That will happen. Ideally, that is the thing that will happen always. Okay. So D60, Y sent it to company. D75 registration company has done. Means who is the owner now? X is the, sorry. Y is the owner and the member. Owner and also a member. But when that got declared, D75. When dividend is declared, D70. Whenever dividend is declared, within how many days you should pay? Within 30 days. D75 is within 30 days. 5 days when it was declared. Na? So, company will pay this dividend directly to whom? Mr. Y, the owner of the shares, being a member, after getting transferred. Second situation. Dividend is declared on what? D70. Registration when completed? D125. 30 days from here will fall to D100. D100. D100, if you cross, it will become a contravention committed by the company because dividend is not paid within a period of 30 days. Now the question started. D70 I received, dividend declared. 30 days it has to pay. D100 is the last date. But D100K registration not completed. Registration is not completed. Now the question. Dividend will be paid to whom? Dividend will be paid to whom is a question now. Therefore, what they said situations like this. See here. Ideally speaking, if you observe the case clearly, X transferred shares to Y. Y paid consideration to X. Therefore, Y will tell that, Arey X, I already paid you money, na? Again, how will you get this dividend? You should not get. Because I paid you money. Everything, whatever you have to receive, you received, na? From now, I should get the benefit out of the shares. Like that, Y will argue. Okay, like that, Y will argue. Next, X will argue, sorry, Nyayama Pata, everything you have paid me. I am not doubting that. But I have one important question. Whose name is there in the register of members of a company? Whose name is there in the register of members of the company? Your name only is there. Y said, X, your name is only there. Therefore, dividend should come to me. Substance over form. Substance over form. If you see form, your name is only there. But substance, if you observe, rights are already transferred to me, na? Dividend should belong to me. He said, no. Substance over form, you should not apply here. Go as per literal interpretation of section 123. Dividend will be paid to registered shareholder. Shareholder name, whose name is in the register. Still my name is only there, na? X will argue. Now there is a dispute in right to receive the dividend. There is a dispute in right to receive the dividend. When there is a dispute in right to receive the dividend, dividend will not be paid to X, dividend will not be paid to Y also. What they will do? Dividends will be kept in unpaid dividend account till the dispute is settled. Once the dispute is settled, immediately the dividends are transferred either to X or to Y. Now see, D125K registration completed or not completed? Completed. On this day, from unpaid dividend account, we will pay dividend to Mr. Y. Did you all understand the point clearly? Yeah? Everyone? Okay, next. Sir, dividends are not declared. Sir, bonus shares came. Bonus shares can't be transferred to unpaid dividend account. Na? Therefore, if there are any bonus shares or right shares, they will be kept by a company in a separate demat account. We call it as abeyance account. Which account? Abeyance account. That's what they wanted to discuss here. Okay, but one small exception. D100, dividend is the last date. Okay, D70 dividend declared. On D0 itself, on which date? D0 itself, X said like this to company, I took money from Y. Okay, he paid me including the dividend also. Come dividend price he paid to me. Who? Y paid. Come dividend price to me. Therefore, if any dividend comes after the transfer but before its registration, give it to Y. X only give an intimation. And a transferor intimated company to pay dividend to the transferee. At that time, all these concepts do not apply because X himself is saying that pay to Y. Understood, everyone? Everyone understood? See here. Now you read all the provisions. Also read the timelines. These timelines also I said you. Read the timelines. Have you read or not? Everyone? Completed? Have you completed? Whatever I said in the timeline chart, did you find all the points there? Okay. Next. See here. Some important points are there. See here now. Those only will come in exam, becoming dangerous for you. Listen. Shares for which dividend is not paid. Okay. No one claimed a dividend. Okay. No one claimed a dividend for 7 years. Not only the dividends, shares also will get transferred to IEPF. Okay. To the IEPF. But if anyone claimed any dividend, then shares will not get transferred. I repeat one more time, listen carefully on that, they can frame a question. If dividend which is belonging to a particular year is unclaimed for 7 years, after 7 years, IEPF it will be transferred. So, no one claimed that dividend for the last 7 years. When you transfer, don't transfer only the dividends, also transfer the shares. However, after some number of years, for example, this year dividend no one claimed for next 7 years. 2-3 years after dividends, people started claiming, then shares will not get transferred. Like this, if I tell you don't understand, I will create one case study, how they can test in exam, I will tell you. See the screen. See the screen. Year 0, X is the owner. Okay. Date of dividend declaration 39 of a particular year. Okay. 39 of a particular year. What is declared? Date of declaration of dividend or date of dividend declaration 39 so and so year. Okay. Let us say year 0. Year 0. Some year you can write any year you want. So X is the owner. Date of dividend declaration 39 of some particular year. Dividend is declared. X transferred his shares. X transferred his shares on 27/9 of year 0 to Mr. Y. To Mr. Y. Okay. Now listen carefully. Dividend is declared on 30. X transferred to Y. That's it. Transfer completed. Registration, all these things are not completed. Okay. So X transferred the shares to Y and he closed his bank account as well. He left to USA. 30th September, company declared dividend. It tried to make payment to X. Okay. But because his bank account is inoperative, company could not pay the dividend. Company could not pay the dividend. Y don't know about dividend declaration. He also did not claim. Y became the owner after, say for example, 50 days. After 50 days, Y became the owner. But Y don't know about the dividends that were declared. Repetition one more time. Year 0, 39, today is 27th September. Today, X sold his shares to Y. X sold his shares to Y. After selling shares to Y, Y left to USA from India. Okay, he left to USA. You can see on the screen now. He left to USA. Completely all the bank accounts are closed. 27 September, he closed everything. Final settlement shares also transferred to his friend Y. Company declared dividend exactly on 39. Okay. Bank account closed. Dividend can't be paid to X. Dividend can't be paid to X. X is the owner of the shares. X is the owner of the shares. Or say for example, for you to understand, dividend declared on 27. X transferred on 39. Okay. Now clarity. Dividend is declared on 27 September. X transferred its shares on 39. Dividend can be paid within 30 days. 3 days completed. Dividend did not, company hasn't paid. Separate bank account ki transfer is happening now. Okay, it will be paid. So 39 he transferred. dividends kept in abeyance, unpaid dividend account, when it will come? Transfer should be in process and dividend should be declared. Here dividend, when dividend is declared, transfer is not yet happened. X is the owner of this dividend. So 27/9 dividend is declared. They tried to pay on, say for example, 10th October of year 0, company tried to pay to Mr. X promptly to his bank account. His bank account is closed. Dividend became unclaimed. Okay. Transfer happened on 39. Na? This transfer is executed on 50th day. 50th day. Next year onwards, Y started taking the dividend. Y will take the dividend. Now, year 0 dividend, X has to claim. Y don't have any right on that. Company waited for 1 year, 2 year, 3 year, 4 year, 5 year, 6 year, 7th year. 7th year also completed. They will transfer to IEPF. Now shares with regard to this dividend also will be transferred or will not be transferred, because from the next year onward, why has accepted and claimed the dividends or not? When shares also will get transferred? See here. Year 0. Year 0. X left to USA. Company declared dividend on 27/9. He did not transfer to anyone. Just left India. Forgot about the shares. Company declared dividend on 39. 1 year, 2 year, 3 year, 4 year, 5 year, 6 year, 7 years completed. Dividend not declared. Shares are also not transferred to anyone. Now this is idle, this is idle. Now both will get transferred to IEPF account. Everybody understood the concept clearly? I'm talking to everyone. Understood the concept clearly? That's the idea behind. Like that, they will blast questions in exam. So, if you want person entitled to money in unpaid dividend account, if any amount is there in unpaid dividend account, any person can claim. Person entitled to shares or dividend in IEPF account can reclaim it from IEPF as per prescribed procedure. Generally, once IEPF lo money is transferred, it will not come back. But now they brought a procedure. Even after 7 years, once you transfer to IEPF with a separate online procedure, SEBI procedure is there. By following that, you can get back a lengthy procedure, but there. Okay. These are punishment. You can read punishment chart. Okay. Next. Just now we read na. If you declare dividend, you should pay within 30 days. If you don't pay, punishment. Company should pay simple interest at the rate of 18%. Okay. And the directors will be liable to imprisonment up to 2 years and fine up to 1,000. Penalty chart I shown na. Here I have given already. 127. See. 127. Punishment of failure to distribute dividend. Where a dividend has been declared by the company but has not been paid or warrant in respect thereof has not been posted within 30 days from the date of declaration, company will be liable to pay simple interest at the rate of 18% per annum during the default, and the director minimum 1,000 per day and imprisonment maximum 2 years. Any other liability? No. Nature of liability, criminal liability. That's it. Next, very important exception. In case of a Nidhi company, if dividend payable to a member is rupees 100 or less, it is sufficient declaration of dividend is announced in one local language in a newspaper and displayed on the notice board of Nidhi at least 3 months. Means, if any dividend is payable rupees 100, then it is sufficient if declaration of dividend is announced in one local language newspaper. Means, you need not tell to anyone. You need not tell to each and every shareholder. You can tell them, please come to company and collect it. Because you can pay in cash na 100 rupees. Give a newspaper advertisement. Next. Sir, whenever dividend is declared, you have to pay within a period of 30 days. Or else punishments you said. Company will pay simple interest, directors ki jail and fine. Okay. When can they escape? If they can escape in 5 cases. Next. When by operation of any law. By operation of any law. Because, for example, our shareholder is an insolvent shareholder. Insolvency code, there is an act in insolvency bank. That act said don't make payment to him. By operation of law, I am not paying him. Or else we will pay. Then no punishment. Second, very important, examination of multiple times they tested this. Shareholder has given directions to company. Shareholder said that no, don't pay dividend in cash. through check, send me dividend warrant. Dividend warrant is transferable. You can transfer to some other person also. Gift coupon type. So don't pay dividend to me. Give dividend warrant. Post it to my house address, he said. Who? Shareholder. Sorry. Shareholder gave directions. Na? We prepared a dividend warrant and posted. He shifted his house. He did not give updated address. That went to old address. Okay. Came back to company again. Since that fellow is not there. Company has to now inform that member. Sir, you gave me directions to comply with. I could not comply with that directions. Company should communicate back. If company did not communicate back, even though I gave you wrong address, company will be responsible to pay penalty. Therefore, shareholder has given directions and those directions cannot be complied. And same has been communicated to him. It is important. Same has been communicated. Dispute regarding right to receive dividend. It is abeyance concept. If there is a dispute, I will not pay. For that, you should not tell you are liable for punishment. Dispute is there. Who is the owner is not yet declared. Next one. Shareholder is there. He is a debtor and a shareholder. In capacity as a debtor, he is not paying money. I can adjust the dividends to the debts. Lawful adjustment of sum against any debts. Next one. Any other reason not due to the fault of company. Okay. Next. Which company cannot declare dividend? Section company cannot declare a dividend. And a company which fails to comply with 73 and 74. 73, 74 will be deposits. You accept deposits. You are not paying principal and interest properly. At that time, don't declare dividend. Okay. Okay. Next. IEPF account. Sir, IEPF account, I am not going to discuss everything. Waste of time. I will just tell you, hey, I am not telling it won't come in exam. I never said that. I am saying I will not unnecessarily discuss this and waste my time now. Because IEPF account ki credits and debits will be there. What will be credited? Central government grants. Okay. Central government to state government to local authority, statutory authority grants. Companies donations. Okay. Unpaid dividend account through 7 years after will come that amount. Okay. Any kind of allocations made by central government, all these will be credited. Debited. For what purposes you can utilize that? IEPF full form investor education. So you will use for promotion of investor education. Prospectus chapter we found if any person has incurred loss or damage because of company misstatements, at that time sometimes government also will pay, SEBI also will pay compensation to the innocent shareholders through IEPF account. They will take money and they will pay. All those debits and credits will be there. If you want, I will just show one. Amount credited. See here, what are all the amount credited? Amount in general reserve account of central government. So central government amount. You made investments. IEPF will make investments. That interest and income from investment made by IEPF. Some received from any central government source. Grants by CG. Unpaid dividend account transfer for 7 years. Okay. All these. Donations by CGSG. Application money received. Mature debentures, mature deposits. What do you mean mature debentures, mature deposits? IEPF invested in debentures. Those debentures came for maturity. Redemption value will come. That amount will be there in IEPF account. Right. Okay. Sale profits of shares. Redemption amount of preferred shares. All these will come. How to utilize? You can give back the unpaid dividend, refund of unclaimed dividend, mature deposits, mature debentures, investor protection and other things. Just now I said, distribution of disgorged amount means compensation amount to the eligible and identified person who suffered loss due to the action of a person. All these things. C and AG will conduct its audit. It's a general thing. Okay. Don't leave. Read everything. But this is general section, not so great. Multiple times if you read, you will remember. Okay. With this, we completed another very important chapter for the coming examination. We completed the chapter called as Declaration and Payment of Dividend. Completed. So very good morning, everyone. So today in this session, we are going to continue with our revision on CA Inter Law for the Jan 26 exams, wherein we are now going to cover 3 very small areas but significant areas in the examination. One is the debentures, another one is the deposits, and third one is the charges. Okay. We are going to start with three different areas. One is debentures, another one is deposits, and another one is charges. Just a minute. So debentures, deposits, and charges. See here. Before we start with okay. See here once. So there are three areas. One is debentures, another one is deposits, and final one is charges. How many are there? Three concepts are there. This is governed by section 71 along with rules. This is governed by section number 73 till 76 capital A, and this chapter covers from section number 77 to section number 87. These are the sections that will be put as a target, and maximum time that we can give to all these in the revision session will be 2.5 hours. We are going to complete. Let us try to complete. If not completed, we will extend by another half an hour and complete. But targeted, we will definitely complete all these three now. Okay. Once these three are completed, then we will go on with the next area called as what is the name? Accounts of company. Accounts of company. Okay. So accounts of company also we will start and we will try to complete that chapter. Okay. So first target number 1, debentures, deposits, and charges. Okay. From these three areas, 8 marks will come in examination for sure. Okay. How many marks? 8 marks will come in examination from all the three put together. Minimum. Okay. Minimum. And easy area, if you read properly, happily marks will come. And again, the danger is most of the times one of these chapters or two chapters out of these three will come as an MCQ. That's why I always say, again I'm repeating my statement, 4 marks descriptive question versus 2 marks MCQ question. 4 marks versus 2 marks, which is important? I will tell 2 marks is more important than this 4 marks descriptive. A reason, this 2 marks you can gain in 1 second. This 2 marks can be error free because your comprehension has nothing to do with. Completely, if you give right answer, right, wrong answer, wrong. And third, very important, there is no choice in MCQ. Here at least you can put it as a choice question. So I always say 4 marks descriptive versus 2 marks objective means I will tell 2 marks objective important. Okay. So therefore, because of all these reasons, these chapters gained its importance. Okay. So let us first understand what are all these concepts all about. See here. We are going to start first with the concept called as debentures. Debentures is a small segment, 30-minute segment. I will not spend more than 30 minutes. First point number 1, I wanted to make everything clear one more time. This is a quick marathon of the concepts. We are not going through any revision, regular batch. So don't expect me to explain each and every minute detail again and again. Okay. For some chapters, I will be little faster, cope up with the speed and then continue. Okay. Shall we begin, everyone? Okay. So first let us start with the area called as, the name of the segment is the name of the segment is debentures. Name of the segment is what? Debentures. First one. What is a debenture? Debenture includes debenture stock, means group of debentures, bonds. Listed debentures are popularly called as bonds, or any other instrument evidencing a debt. So debenture is a evidence. Debenture is a evidence. For example, I gave loan to company. Okay, what is the evidence that I have given loan to the company? Company in return will give me a document called as debenture saying that yes, R. Koushik Mukhesh has given the company this much amount of loan. For that, as a token of proof, we are giving these debentures. So it's a evidence. So debenture is what? Any document evidencing the debt is a debenture, but does not include, what is not included into debenture? Number one, instruments referred to in RBI. RBI will also issue debt instruments. Okay. For example, RBI will raise the T-bills. T-bills means on the T illa. T I am talking about treasury bills. Treasury bills they will issue. It's a debt instrument only, but it's not a debenture. So RBI prescribed instruments are not debentures. Are you understanding? Or any instrument of company prescribed by CG in consultation with RBI. Means sometimes some companies will issue certificate of deposits. Which one? Certificate of deposits as per the RBI guidelines. In that case, this chapter will not apply. Means debentures will not apply. And another example, Nidhi companies are there. Nidhi companies also will take loan. But at that time, debentures will not get attracted because Nidhis are governed by both MCA as well as RBI. So whatever we have to remember for this examination is debenture includes what? Debenture stock, bonds, or any other instrument evidencing a debt, but does not include instruments referred in RBI Act and instrument of a company prescribed by CG in consultation with RBI. Next one. Sir, debenture will be, how it look like? Debenture is a certificate. Sir, who should sign on that? Debenture certificate is issued by the company under its common seal. If the company has a common seal, no signatures required. Company common seal is required on that. If company do not have a common seal, then signature of two directors, or if company has a CS, director and a CS is required to sign. Next one. Next one. Debenture trustee. Sir, who is a debenture trustee? See, I will give you an example first. Okay, I will give you an example. There are so many debenture holders in a company. There are so many debenture holders in a company. For example, company is accepting deposits from 10,000 debenture holders. 10,000 debenture holders, company is accepting money, taking loan from 10,000 debenture holders. Company balance sheet la liability side debentures 10 crores, 10,000 debenture holders. Clear. These are secured debentures. These are what debentures? Secured debentures. Whenever the debentures accepted are secured debentures, secured debentures means debenture is a loan. Company may pay this, may not pay this. So the person who given this loan will always have an insecurity in mind. Maybe company will pay, may not be paid. If it don't pay, I will die. Therefore, they will ask a security from company. What security? Asset security they will ask. Which security? Asset security. Means what they will tell company, we are ready to give you loan, no problem. In the name of debentures, no problem. But one thing we wanted to have very clear. The point that we wanted to make clear is, whenever we take the loan, whenever company take the loan, security should be given. What do you mean by security? If you could not pay, I repeat, if you could not pay that particular amount in the liability, then we have a right to sell these assets and get back our money. That's the concept relating to the idea behind the concept of, okay, security. This concept we call as a charge in charges chapter. I repeat one last time. Company balance sheet assume liability side there is a debentures loan. On this loan, assets are kept as a security. Generally, they will keep equal value or higher value asset, because even if asset value depreciates, it will match to the interest and the principal component of a loan. And a 100 crore loan is taken. Example, they will put asset security of 120 crores like that. Higher side only they will go always. 99%. Okay. So I repeat one more time. There is a balance sheet. Balance sheet la liability side debentures. Debentures are secured by charge. Charge again is the assets of the company. Charge again is the assets of the company. So means what? Whenever you take loan from a company, whenever you take loan, company take a loan, assets are kept as a security for the loan. Yes. So assets are kept as a security. If company fails to repay, assets are taken away by the debenture holders. Okay. Now the question starts. Now debentures loan is taken by company from one person or 10,000 persons. 10,000 persons. But I don't have 10,000 assets. Na? Koushik Mukhesh gave 1 lakh. 1 lakh, 1 lakh asset, I don't have to put security. I have only one asset which is worth 10 crore. Okay, which is worth 10 crore. Debentures accepted are 8 crore. So 8 crore debentures, 10 crore asset I can put as a security. But each and every person inside the debentures, I can't do like that. Therefore, what law has said, I know that it is impracticable when secured debentures are issued. Therefore, whenever secured debentures are issued, always appoint one person called as a debenture trustee. Company will create security on assets and transfer that security document in favor of one person called as a debenture trustee. This debenture trustee will be working in the interest of debenture holders. Means he will protect the interest of whom? Debenture holders. Day and night he will be thinking only about whom? Only about debenture holders. So I repeat one last time, not the concept. Concept I already explained. So whenever the debentures are issued to debenture holders which are secured in nature, I can't create security in favor of each and every debenture holder of equal amount. Therefore, I will put one person. This fellow will be the pratinidhi of, representative of all the debenture holders in the company. That fellow is a debenture trustee. If that fellow is a cheater, debenture holders are gone. Therefore, lawmaker has kept so many concepts relating to debenture trustee. Let us see one by one. Appointment. Company issuing the prospectus or making offer or invitation of subscription to the debentures to public means company issuing prospectus for debentures. Okay, for subscription of debentures to public. So if your debentures are accepted from general public, or no sir, we are accepting from members only, but the number is exceeding 500, shall appoint debenture trustee prior to the issue of prospectus. What do you mean prior to issue of prospectus? Prospectus to accept debentures from public or any circular to accept debentures from members. In that you have to mention the name of debenture trustee. Means what? First you should enter into agreement with debenture trustee and then write his name in the prospectus. Okay. So company issuing the prospectus or making offer or invitation for subscription to the debentures or to the public or members exceeding 500, not public exceeding 500. Public one person also debenture trustee mandatory. Members of the company, if you are accepting, if it exceeds 500, debenture trustee is mandatory. Next, consent. Obviously, debenture trustee is an agreement. Therefore, name of the debenture trustee shall be stated in the offer letter with a written consent. Next one. Who cannot be appointed as debenture trustee? Market important, can come in examination. Here, I have used one keyword. Just a minute. Important call. Just a minute. 1 minute. Yeah, see here. So, appointment we understood, consent we understood. Eligibility criteria. Eligibility criteria is extremely important for your examination. So, mark it very, very important. They can ask in exam. So, here we use one keyword called as company, associate company, subsidiary company, holding company. In simple language, people call it CASH. Okay. Whenever I use the word CASH, it means company, associate, subsidiary, holding. So, following person shall not be appointed as a debenture trustee. Who? Beneficial holder of a shares in a company. Okay. Not necessarily a registered holder. Beneficial holder of a share. Simply remember, this is not the time to explain what is a beneficial holder. All these things I don't want to do. Remember, if you are a shareholder of a company, you cannot become a debenture trustee. Debenture trustee should protect the interests of the debenture holders, not the shareholders. If you are a shareholder of a company, you will not take any action in the benefit of debenture holders because debenture holders will take interest. Debenture holders will take the cash of the company, money relating to the company at the time of principal repayment. So company money will go down. So your dividends will come less. Therefore, if you are a shareholder under debenture trustee, as a shareholder, your independence is lost. Therefore, you cannot become a beneficial shareholder of a company to become a debenture trustee. Next one. You should not become a promoter, director, KMP, or any other officer or employee of company or associate company or subsidiary company or holding company. Next one, you should not become a relative to the promoter or KMP of the company. Here only company is included, not the holding subsidiary and associates. Okay. Next one. You are not beneficially entitled to any money from the company. Okay. That means, for example, there is a debenture trustee. The debenture trustee is also acting as a commission agent for the company. You are not receiving any money in shares, but you are having some beneficial money from the company. Means you are getting, for example, company is having a building, company is having a godown. That godown belongs to Mr. A. He will be getting a rent from the company every day, every month. Okay, every month from the company will be getting around 10 lakh rupee rent for the godown. Now he is beneficially entitled to some money from the company. Such a person cannot become debenture trustee. Reason is, when you are getting so much money from the company, you can never take any step against the company. So therefore, beneficially, if you are entitled to any money other than shareholding, etc., then also you cannot become a debenture trustee. You are indebted to group companies. You are indebted to group company means what? You have taken loan or you have furnished guarantee for the debts secured by the company. Means you did not give any kind of debt. You did not take any kind of debt. Some other person has taken debt. For the debt, you are the guarantor. Means what? If that fellow fails, you have to pay that money. Very important. Pecuniary relation. What is pecuniary relation? Pecuniary means monetary relation, financial relation. So you are having some financial relationship with the company, All other associates, subsidiary and holding are not covered. Okay. Of lower of during last 2 financial years or current financial years. A 2% or more of the gross turnover or total income or rupees 50 lakh or higher amount has been prescribed. As of now, higher amount is not prescribed. See, read all the points here. Have you read, everyone? So hopefully everyone read that. This point I will explain one more time because one person asked the doubt. See here. You are indebted. Means what? You have taken a loan. You have taken a loan from whom? See, I'll explain this way. Mr. A has taken loan. Okay. From whom? Company. C. Holding. H. Subsidiary. Yes. Associate. A. Subsidiary of holding company. Subsidiary of holding company. Means what? If you have taken loan, A cannot become a debenture trustee in the company because A has taken loan either from my company, holding company, subsidiary company, associate company, subsidiary to holding company. Subsidiary to holding company means, do you know what does it mean? See, holding company is there. There are two subsidiaries, A and B. Okay. Now who am I? Subsidiary. Who is this? This is also subsidiary. That's what he wanted to tell. What is the relation between these two? They are not subsidiaries. And A B is not subsidiary, B A is not subsidiary. These people are called as sister concerns. These are only called as sister concerns. Nissan, Renault, first Skoda, Highway. Those are all sister concerns. BMW, all these companies are there. Those are all sister concerns. And one holding company, these are two subsidiaries. Okay. So, if debenture trustee, if the person has taken loan indebted either to my company or my holding or my subsidiary or associate or subsidiary to holding company, such a person is disqualified from becoming a debenture trustee. Everybody in the class, please answer. Understood the point clearly? Okay. Next. After that, if you have doubt on the last point also, I will explain one last time, because those are all dangerous areas. Pecuniary relationship with the company and a monetary relationship you are having means what? See, I am one of the most important supplier to the company. I am most important supplier to the company. Means what? I am dependent on company. Company is also dependent on me. Dependence to some extent is okay. But if that dependence, financial dependence is, see here, 2% or more of, and more than or equal to 2% of gross turnover, or more than or equal to 2% of total income, or rupees 50 lakhs, whichever is lower, means, for example, listen carefully. Gross turnover is there for the company. Which one? Gross turnover. In that total turnover, you are the supplier for 2% or more. Okay. Next, our total income, turnover I did not satisfy, but in the total income, your share of total income is 2% or more, or 2% may not be satisfied, but if it is 50 lakh, any of these, if it is satisfied, lower of the above, then you will not be allowed to be appointed as a debenture trustee. Everyone understood the concept clearly? Everyone, tell me, understood the pecuniary relationship concept? Okay. Next. Sir, eligibility criteria, mark it extremely important. This is not a regular class. I could not go inside the concept and explain everything. In the time available, I am trying to complete as fast as possible. Okay. Please try to understand, we are having some deadlines and completion date. Still, I am taking extra, but no problem. Let us complete everything. A 60-70 marks if it is covered. So there is a peace of mind. You will cover each and every point inside. Okay. Let us begin. Point number 2. Duties. What are the duties of a debenture trustee? His first duty is to protect the interests of the debenture holders and grievances redressal. Redressal means resolving. So whenever debenture holders are facing a problem, you should not sleep. Your appointment purpose itself is to protect their interest. Next one. Convene a meeting of debenture holders. So whenever required, you convene a meeting. Okay. When to convene the meeting? If request comes from the debenture holders holding at least 1/10 in the value of debentures, not 1/10 of the debenture holders. There are 10,000 debenture holders, but 3 people are holding 10% of the value. Those 3 people can call for a meeting of debenture holders. Next, or on happening of any event, if any danger events are coming. For example, company accepted debentures from the debenture holder, debenture trustees appointed, assets kept as a security. Those assets are losing value. Immediately he will conduct a meeting of debenture holders and say the fact. And he will ask them, what step you want me to take? That's why, on happening of any event, either breach or default or anything which affects the interest of debenture holders. Next one. Very, very important. Filling of vacancies. Hey, listen. Vacancy can be created in 2 ways. One, removal. Second one. First one, removal. Second one is resignation. If the debenture trustee is not performing well, he can be removed from the debenture trusteeship. Okay. Debenture trustee may be removed before expiry of his term if it is approved by the debenture holders, okay, of not less than 3/4 in value of debentures outstanding. Okay. Means total debentures are 10 crore. 3/4 means 7.5 crore. Whoever debenture holders are holding that 7.5 crore, their approval is required in order to remove the debenture trustee. Mark it important, MCQ they can ask. Okay. Simply, board of directors cannot remove, government cannot remove, shareholders cannot remove, Only debenture holders only can remove debenture trustee. Okay, next. Sir, removal time la vacancy is created and who will fill? If it is caused by casual vacancy by removal, death, etc. Any casual vacancy, including removal, board of directors themselves will fill the casual vacancy. But if the debenture trustee resigned and went away, it's a red flag. Something is wrong with the company. Therefore, with the written consent of majority of debenture holders and more than 50% of debenture holders head count, not amount of debentures, head count. That's why you have to remember all these points. So any resignation, any vacancy caused because of resignation of a debenture trustee has to be filled only with the written consent of the majority of the debenture holders. Majority means more than 50% of the total head count of debenture holders, not monetary content. Okay, I am putting this chart. These 2 points we have to read. Debenture trustee is liability. Debenture trustee, liability. Okay. If a debenture trustee fails to show care and due diligence, and he is a negligent, okay, as per the trust deed, okay, as per the trust deed, any provision in trust deed or contract with debenture holder that exempt or indemnify him from liability for breach of trustee is void. Sir, what does it mean? See here, debenture trustee will be appointed by company through a document called as a debenture trust deed. Debenture trust deed. Okay, now listen. This debenture trust deed, in that so many terms and conditions are there. In that terms and conditions, we have written like this. Even though debenture trustee is negligent, even though debenture trustee have made a breach of trust, punishment will not be given to him. We will excuse him. Like that, if you exempt him from liability for breach of trust, such provision, such a term and condition in the document becomes invalid, void. Second, I have written like this. If a debenture trustee does not show care, due diligence, negligent, breach of trust, he will be punished. But whatever the fine he paid, company will reimburse him. Indemnifying him is also void. Everyone understood this point? They did not test this question till now in the examination. Okay. Everyone understood? Reply. Yeah. So please, I'm making it full screen. Read the entire concept. I'm freezing the full screen. Wait a minute. 2 minutes time I will give. From my side, I am pausing this. Next one. Next concept. See here. Next concept. Secured debentures when a company can issue. Next, first one. Tenure means the term shall not be more than 10 years. So normally the tenure of a secured debenture should not go beyond 10 years. Should not go beyond 10 years. But sometimes it can be more than 10, but should not be more than 30. Which cases? Not all. Number one, if it is an infrastructure project company, okay, L&T type, or you are a company which finances infrastructure project companies. So infrastructure financing company. Next one, same like infrastructure debt fund NBFC and company permitted by CG, RBI, National Housing Bank, etc. Okay, so you have to remember these 4 names: infrastructure project company, infrastructure financing company, infrastructure debt NBFC, any company permitted by CG, RBI or National Housing Bank, etc. For those persons, it can be more than 10 but less than 30 years. The reason I told you in the regular classes very clearly why they kept all these provisions, but this is not the time to learn that. This is the time to rapidly cover everything. Next one. Charge. Whenever it is a secured debenture, you have to create a charge. In whose favor you will create? Just now I told you. Charge is created in favor of a debenture trustee on the assets of the company, holding, subsidiary, associate, etc. So necessarily there is no need that if your company is taking a loan on your assets only, you should create the security. No, on your holding, subsidiary, associates also you can do. Next one. Debenture trust deed, okay, in form SH12 shall be executed within 3 months of the closure of issue. It should be executed within 3 months from the closure of issue. Means a debenture trust deed should be prepared in form SH12 and should be executed, means signed within how many months? 3 months from issuing the debenture. So if you issue debentures and complete today, from here 3 months the debenture trust deed also should go out. Next, if debenture trustee concludes that assets of the company are insufficient, means what? Slowly asset values are depreciating in the market. This value and the loan value both are, see, loan taken 100 crore, assets 120 crore kept as a security. These assets are slowly losing their value. Such that what will happen? See, my asset values are 150 crore. My loan is 100 crore. What companies generally do? 100 crore ke 150 crore will be kept as a security. If they take a 10 crore or 20 crore loan from another bank, for the 20 extra loan also they will put this security only, because there is a marginal gap of 50% or 50 crores. But loan taken is the debentures issued are 100 crore. Assets kept as security are 150 crore. Slowly these asset values are depreciating. 150 came to 140, 140 came to 130, 130 came to 120. Immediately debenture holder will file a complaint in NCLT. Sir, assets which are kept as security for our debentures are losing their value. Immediately tribunal will tell that stop accepting any loan or don't put this asset again as a security to any kind of loan. Okay, so it will stop company from charging this asset to any other loan. If debenture trustee concludes that the assets of the company are insufficient, okay, to discharge the principal amount when it becomes due, he may file a petition with whom? NCLT. NCLT may order to impose a restriction on the company not to incur. So it will impose a restriction to incur further liabilities as it considers necessary. It will restrict. Don't incur other liabilities. Don't put other securities. Next one. Yeah. See here. For example, now just what we discussed, if the amount becomes, if the asset values are slowly coming down, then that complaint will be made. Company due date came, debentures ki due date came, principal interest has to be repaid, but company is not paying, it's defaulted. Previous example, default is not there, asset values are falling down, there is a likely default, chance is there, but now really default happened. Then what debenture trustee has to do? NCLT may, on application of debenture holder or trustee, order company to redeem debentures forthwith, means immediately, on payment of principal and interest. If it fails to redeem debentures or maturity on the due date. So if you fail to repay principal or pay the interest on due date, NCLT debenture holder or debenture trustee will make a complaint. Immediately NCLT will order immediate payment, or else other consequences will apply. What are those? We will see. Okay, not in this chapter, different chapters it will come. Whenever debentures are allotted to the debenture holders, file form PAS3 with ROC within 30 days of allotment of debentures. Next one. Company cannot issue debentures with voting rights. Now we are going to read basic concept of what is the features of a debenture. Company cannot issue debentures with voting rights. Company may issue debentures with conversion option. Means you can issue convertible debentures if it is authorized by special resolution. Okay, if it is authorized by special resolution. Next. Board resolution is sufficient for non-convertible debentures. Okay, if it is convertible debentures, special resolution is mandatory, but board resolution is sufficient if it is a non-convertible debentures. Non-convertible debentures. So something is written here 181C. We will see in the debentures chapter anyway. At that time only I will tell you. Okay. So I repeat one more time. You cannot issue debentures carrying voting rights. Next one. Company may issue debentures with an option to convert. Okay. But convertible debentures can be issued only with a special resolution. Reason, half an hour I told in the regular class. Why convertible debentures require a special resolution? Next one. If you are issuing non-convertible debentures, board resolution is more than enough. Next one. Final touch. Creation of debenture redemption reserve. Creation of debenture redemption reserve. Mark it very, very important. This one and this one. Okay. Creation of debenture redemption reserve account. Company shall create a DRR account. So DRR account should be created out of what? Out of the profits of the company available for payment of dividend. Okay. What do you mean by that? Free reserves. You cannot use committed reserves to transfer to free debenture redemption reserve. Okay. So companies shall create a DRR account out of profits of the company available for dividend. See, I will repeat one more time. DRR is created out of, I repeat, DRR is created out of profits available for dividend payment. But DRR cannot be used for dividend payment. Repetition one more time. DRR is not a free reserve. DRR is created out of free reserve. Means from the free reserve debit will be made, to DRR credit will be made. So DRR is created out of real cash profits. Okay. But DRR cannot be used to pay the dividends in cash. DRR is not a free reserve. DRR is created out of free reserve. Everyone understood the difference between two statements? Everyone? Everyone, both the statements, did you understand the difference? Next. Following companies are required to create DRR. Following companies are required to create DRR. See, who are required to create DRR? Unlisted companies are required to create DRR, except when unlisted companies are not required. See, if it is NBFC registered with RBI or housing finance companies are registered with National Housing Bank in case of private placement. In case of private placement. So simply to tell, NBFC's case, though they are unlisted companies, it is not required. Sir, I am a listed company. DRR not required. Why? SEBI is already covering, you know, why security, why again DRR is required? Enough care is taken by SEBI already. So DRR is not required. DRR is mandatory only for one company. Which company? Unlisted companies which are not NBFCs. Which are not NBFCs. Okay. So otherwise, exempted from DRR. Exempted from DRR. Sir, I am an unlisted company, but I am a all India financial institution and banking company. For me also required or not required? Question will arise. Correct or not? So if it is unlisted, not required. So how much a DRR should be created in case of unlisted company? DRR equal to 10% of the outstanding debenture. Outstanding debenture. Means what? Outstanding debentures means how much amount is outstanding on that. 10% has to be created in the form of DRR. Okay. That's it. Next one. Amount and method. So simply DRR is mandatory in whose case? Whose case it is mandatory? It is a mandatory if you are an unlisted company, not being a NBFC, not being a AIFI, not being a banking company. Then DRR creation is mandatory for unlisted company. How much amount? 10% of the debentures value you should create a DRR minimum. Okay. Outstanding debentures 10% you have to create a DRR. Next. Other cases not required. So exam question comes. Listed company, DRR not required. Okay. If it is a AIFI, not required. Not required. If it is a banking company, not required. NBFC registered with RBI or National Housing Bank or any other person that way, not required. I am a normal unlisted company, required. How much? 10% of the debentures value. Next one. Amount and method of investment of or deposits for the debentures. See, whenever you create DRR or whatever the amount you create, so what is the point? You have to put it somewhere. Simply to tell, DRR is one thing, DRF is another thing. This is a concept of DRF. DRF means you should not just keep aside, you should invest amount also somewhere else. See, by 30th April, required companies shall invest or deposit amount equal to 15% of the debentures maturing during the following during the financial year in the following deposits or investments. Read the point clearly. What we need to create? DRF, fund. Reserve means amount kept aside. Fund means kept aside and invested elsewhere. So amount and method of investment or deposits for the debentures. Okay. See there. See here. By 30th April, required companies shall invest or deposit an amount equal to 15% of the value of debentures maturing during the financial year in the following deposits and investments. Okay. So there are some required companies are there. Those required companies should not just create a DRR. They should create a DRF. Means what? They should deposit 15% of, they should deposit 15% of the deposits maturing. For example, my deposits are coming up for maturity on September 30th this year. By April 30, you need to deposit some amount. How much percent? 15%. It is like traffic signals, 3 signals are there. One green, another one is amber, orange, third one is a red. Red means stop. Green means go. What is orange? Get ready. This is a get ready concept. When your debentures are maturing in the financial year, okay, then you should not wait till the date and pay. Get 15% of the amount ready by investing in these kind of deposits. Note, required companies, who are required? Public debentures issued, means what? Public offer of debentures made by all listed company, unlisted company, other than AFI and banking company. I am a listed company, went for public offer of debenture. DRR not required, but DRF is required. Okay, next. Sir, in case of private placed debenture, I did not go for public, then also required. Unlisted companies are required. Unlisted companies are required. So I am a listed company or unlisted company other than AIFI and banking company. Then for public placed debentures, it is required. Clear or not? NBFC is also required. Only AIFI and banking company not required. Next, privately placed debenture. Unlisted companies only private placed debentures also required a DRF. DRF means what? It is not just creating a reserve. You should deposit that amount. How much percent? If you are going to redeem debentures on next March 31st, March 31st of 2026, you are going to redeem debentures worth 10 crore. 1.5 crore money, get ready by investing in, not in stock markets and risky investments. Scheduled bank you should put. Okay, that deposit again you should not create a charge. Unencumbered means uncharged. Charge should not be there. You should invest them in securities of CG or SG or securities issued by company under Indian Trust Act. Sir, what is this unencumbered? Unencumbered. See, company wanted to redeem debentures. Company wanted to redeem debentures. How much worth? 10 crore. How much we have to deposit? 1.5 crore. Can I invest in shares of Reliance? No, because Reliance is not a security of CG or SG. So central government securities, so you can invest. Okay. Now company invested 1.5 crore in CG securities. Very good. How much? 1.5. Now that is an asset to the company. Yes. Company has taken loan from SBI. For that loan, they wanted to keep this investment as a charge. Can they do? Assets can be kept as a charge, and they wanted to keep this asset as a charge. Possible or not possible? Not possible. That's the meaning of unencumbered securities of CGSG. Means you have to invest, but those investment assets should not be kept as security to any loan of your company. Okay, so unencumbered deposits of scheduled bank, unencumbered securities of CGSG, unencumbered securities issued by a company under the Indian Trust Act. In these three cases, in these three places, you have to invest that 15%, such that this 15% will be mature into some value and you will be ready to repay your deposits. This is the point here. Everybody in the class, did you all understand? Everyone? But one last time I am repeating this, please listen. Who is required to create DRR? Who is required to create DRF? 1 minute I will cover. DRR is a nominal optional part. Only unlisted companies are required to create a DRR. Only unlisted companies are required to create DRR. But that unlisted companies like NBFCs, AIFI, banking companies should not be included. Number one. Sir, I am a listed company, not required. I am a AIFI, not required. I am a NBFC, not required. Sir, I am a banking company, not required. Because you are all governed otherwise around by some other authority, not required. Sir, I am a normal listed company, XYZ Private Limited, required. How much, sir? 10% of your debentures. Very good. Sir, along with that, should I do any other thing? Yes. Okay, 10% of the debentures outstanding, every year you have to create DRR. But DRF is not for every year, it is for the year of maturity of debentures. Your debentures are coming up for maturity on December 31st. By 30th April, you have to make a money, 15% of the money coming up for maturity deposited in unencumbered deposits of a scheduled bank, unencumbered securities of CGSG, unencumbered securities issued by a company under Indian Trust Act. There you have to invest 15% of the debentures maturing in the coming year. Did you all understand that? Everybody understood the concept clearly? Okay, yeah. So listed companies are not required to create DRR, but listed companies are required to create DRF and 1 year before. Unlisted companies, all cases they have to prepare, except in case of AIFA and banking. Okay, I am making this chart also available on full screen. Please read and complete it. So the next chapter is acceptance of deposits by companies. So let's have a clarity. Acceptance of deposits by company means we are going to learn what is a deposit and what is not a deposit. What is a deposit and what is not a deposit. Okay. First one. What is a deposit? Deposit provisions are not applicable to following companies. First, to whom it does not apply. Okay. First one, banking company, NBFC, housing finance company, company notified by CG. Why not applicable? They also accept deposits, but those deposits are governed by RBI guidelines. Therefore, for them not applicable. Next one. Deposit provisions only regulate acceptance of deposits by non-banking, non-financial companies. Means normal trading companies, etc. Okay. Next one. First, deposit includes what? Sir, I will show you a different chart for deposits. This might be more easier. Okay, see here. First one. What is a deposit? Okay, what is a deposit? First one. Deposit includes any amount received by the company in the form of deposit or loan or any other amount. Okay. So now doubt will come. Sir, any other amount means debenture is a deposit. That's why we are going to see exclusions. I repeat, debenture includes any amount received by the company in form of deposit, loan or any other amount, but does not include, okay, such amount received by the company as may be prescribed in the rules. So now we are going to read the rules. So normally deposits definition is very, very big, vast word. Deposit means any receipt of money by the company in the form of deposit. Either deposit means you accept it in the name of deposit. Sometimes we don't put the name deposit. We will take in the name of loan. Loan also will become deposit in some cases. Okay. Or any other amount is received, that also will become deposit in some cases. What are all those? Let's try to understand. Fastly, I will cover the concept. Please listen carefully. Again, I'm telling you, deposits, there are so many rules. Only the core rules which are very important for exam, those I am going to cover now. Okay. Now, what is not a deposit? Mark it very, very important. Last attempt it came for 2 marks. So 2 marks are very small, sir. No, they asked in MCQ. There are 18 points in this. How many? 18, 18 categories are there which are not a deposit. From that, one will be coming in exam for 2 marks as an MCQ. If you do not read this definition, you will attempt exam only for 98 marks. That's a danger. So let us cover. What is a depositor? Not a depositor. Not a deposit. Okay. First, what is not a deposit? Government and related receipts. Any amount received from central government, state government, local authority, statutory authority is not a deposit. Receipts from a foreign source. Foreign source means foreign government, foreign bank, multilateral banks, okay, foreign citizens, person resident outside India under FEMA, foreign companies. From any foreign source, if you receive any amount, that will be governed by FEMA guidelines, not by Companies Act. So, foreign government, international bank, multilateral financial, foreign collaborators, foreign body corporate, foreign citizens, PROA under FEMA, from any of them, if you are receiving any amount, that will not be regarded as a deposit. So, two situations completed. Next one. Another 2 we are going to read in one block. Banks and financial. If you see the bare rules, bank separate, financial institution separate. 18 we are going to complete another 2 now. Any amount received from banking company, okay, SBI like that. So in this loan, bank loan will not be included because amount received from the banking company is not a deposit. Na? So that's how we need to read the definition. So amount received from banking company, SBI. Sir, SBI is not a banking company, sir. Banking company word is defined under Banking Regulation Act. State Bank of India is formed not under Banking Regulation Act. It is formed under its own act. That's why for SBI that concept does not apply. So anyway, banking company, State Bank of India, public financial institution like LIC, UTI, etc. These kind of companies. Next, cooperative banks, scheduled banks, regional financial institution and insurance companies. Any amount received from any of these people will not be regarded as a deposit because they are all under the umbrella of RBI. Next one. Receipts as short-term securities. Any amount received by the company from commercial paper and intercompany deposit. These are another 2 points. See, 1, 2, 3, 4, 5, 6. If you see study material also, these are all separate points. In the chart pattern, I made it as simple as possible for the student. So, receipts as a short-term securities. Any amount received from the issue of commercial paper or intercompany deposits. Or what deposits here? Intercompany deposits. Okay. So, any amount received from the issue of commercial paper or intercompany deposits will not be regarded as a deposit because deposit key maturity period is given in the provisions. What is the maturity period? The minimum maturity period should be minimum 3 months. Normally 6 months. Some exceptional cases the 6 months minimum, maximum 36 months and 3 years. From this, what you have to understand, commercial paper life itself is for 14 days, 21 days, 30 days, etc. Means they don't match with the tenure of that particular deposit. Therefore, commercial paper issue and intercompany deposits, one company depositing money with another company should not be regarded as a deposit under this chapter. Commercial paper ke reason I told you. What is the reason? Short term. It is a shortest term. Intercompany deposits, it is governed by a separate section in Companies Act, section 186. That's why this chapter does not apply. Next. Very important. Listen carefully this one. Already we discussed this in Prospectus chapter. Whenever you receive application money, allotment should be completed within 60 days, or else you have to refund the money within next 15 days, or else you have to pay interest at the rate of 15%. Why you are paying interest on application money? Because after 60 days, within 15 days, you have to repay back. If you do not refund back the money within 15 days, from the 61st day onwards, it will be regarded as a deposit. Deposit carry interest. That's why we pay interest at the rate of 15% per annum. Everyone understood the logic clearly? Yeah? Okay. So, is the idea behind this. So, company accepted application money, allotment is pending and it is done within 60, then not a deposit. When it will become a deposit? If allotment is not done within 60 days, then within 15 days you have to refund. If not, from the expiry of 60 days, it shall be treated as a deposit. Okay. Next. Very important next point. Receipt from the directors and related parties. See, listen. Amount received from director of a company. Amount received from director of a company. Okay. So, amount received from director of a company is a deposit or not a deposit? Not a deposit. Not only that, if it is a private company, amount received from relative of director is also not a deposit. See, a company means public or private company. Amount received from director of a public company, amount received from director of a private company, both not a deposit. But in case of private company, amount received from a relative of director will become a, in case of a private company, amount received by the company from the relative of director is not a deposit. Public company, if it receives money from a relative of a director, it becomes a deposit. Okay. And moreover, in these cases also, okay, if you don't want it to treat as a deposit, some conditions are there. What are the conditions? Amount must be given by the aforesaid persons. Means whom? Director of public company, director of private company, relative of director of private company. Amount must be given by the aforesaid persons out of their own sources of money, but not their borrowed. Means, I am a director of a company. I will borrow money from a bank and I will give it to company as a loan. Means what? Indirectly, company is taking loan from bank through the director. That is not allowed. The director who is giving loan to the company should give the loan out of his own sources. It should not be borrowed by him. And they should give a written declaration to that effect. That we are not borrowing money and giving to company. This is our own funding. Next. Receipts from issue of debentures. Debentures, whenever you issue, listen, this is very important. Whenever you issue debentures, okay, debentures are of two types: secured, unsecured. Secured, unsecured. First, secured, unsecured. Next one, unsecured, convertible, non-convertible debenture, convertible debenture. Secured, non-convertible debenture, convertible debenture. Okay, listen carefully now. Okay, first, there is a debenture. The debenture is secured debenture, and it is a non-convertible debenture, and it is a non-convertible debenture. Debenture, secured, and a non-convertible debenture. It will not be called as a deposit. It will not be called as a deposit. Like this, you should not think. See here, there are two situations here. What are the two situations? Debentures are issued, 10 crore. Security is created, 8 crore. Means debentures are 10 crore, securities kept are 8 crore. Automatically, what is happening here? Debentures value is more than security provided. Means 2 crore worth, it is unsecured. Correct or not? That will go into this category. Now, did you understand the danger of how they ask questions in exam? Everybody. Fast. Okay. See here. That's why. Debenture, secured, non-convertible debenture. In such a case, non-convertible debentures, what they say is two situations: debenture value more than security value, less than or equal to security value. Okay. In this case, debentures, second case, debentures less than or equal to security value. Debenture will not become a deposit. Debenture value more than security value. Up to security value, not a deposit. Beyond security value, it will become a deposit. It will become a deposit. Next one, convertible debentures. Convertible debentures. What do you mean by convertible debenture? Okay, what do you mean by convertible debenture? Question will arise. What really a convertible debenture means? Convertible debenture means debentures will be converted into equity shares. Debentures will be converted into equity shares. So anyway, when equity shares is converted, security is not required. Therefore, it will not be treated as a deposit. So convertible debenture is never called as a deposit. Next, unsecured. Non-convertible unsecured debentures, again two branches: listed, unlisted. Listed, it is not a deposit. Unlisted, it is a deposit. Okay. Next, that's why see here they kept this way. They are secured debentures. If the debentures are secured, then they never be called as a deposit. If the debentures are convertible within 10 years, never they are called as a deposit. That's why here also it will not be called as a deposit. So convertible debentures are not called. But see here, even though you are non-convertible, even though you are unsecured, you are not treated as deposits if you are listed. If SEBI is taking care, then you are not a deposit again. Okay. So I am not a secured debenture. I am not a convertible debenture within 10 years. Then automatically whom I am? I am an unsecured non-convertible. No problem. Even if you are unsecured and non-convertible, even if you are unsecured and non-convertible, if you are a listed debenture, again you are not a deposit. Did you all understand or not? These are all minute points you should learn. Yeah, you are just like that reading and going. Next one, secured debentures beyond security value is treated as a deposit again. Secured debentures beyond security value is treated as a deposit. Next one, Receipts from employee. Receipts from employee. See here. Any amount received from employee as a security deposit. Okay, as a security deposit. Not more than his annual salary under a contract of employment, and it is non-interest bearing, then it is not a deposit. All the conditions should be satisfied. You should accept money from employee as a security deposit. Amount should not exceed his annual salary, and that security deposit should be taken not generally by a contractor, and it should not carry any interest. If all the conditions are satisfied, amount received from that employee will not be treated as a deposit. Next one, receipts as a trustee. Okay, if company is receiving money from some other person in capacity as a trustee, then not a deposit. Next one, receipts in ordinary course we will discuss separately. We will first cover all the other things. Okay, amount received from promoters. Promoters or relatives are giving money to the company. Okay, they are giving unsecured loan to the company. Term of such unsecured loan is not more than the term of bank loan, as a condition imposed by a bank or financial institution against giving such loan. Sir, I didn't understand. I am putting it before you. You have to read these 4 points. See, I will tell you what for. Either 1, 2, 3, 4. Read these 4 points once. I repeat. See here. Company is receiving money from the promoters or relatives in the form of unsecured loan as a condition imposed by bank or financial institution against giving the loan. Term of such unsecured loan should not be more than the term of the bank loan. What is this logic? Promoters went to the bank, asked bank, please give me a loan. Then bank asked, who are you? They said, we are promoters. What you want? We want loan. Loan for what? Loan for my company. What is the guarantee that you will repay? We will definitely repay. Word of mouth we never believe. Banks never believe. So give some other assurance. What assurance you need? Security. Security, okay. What is the confidence that you have that your company will repay loan back to me? No, sir, our company is a very nice company. Last 7 years ago we are there. So we will definitely pay. Okay. We will definitely repay. So this is what they said. We are not believing that. Let us have some confidence point. What bank says? You are asking money of 5 crore from me, loan. Do one thing. You give 1 crore to your company as a loan. You give. Oh, I should give, sir. Okay, sir. I will give a loan with security. No, if security is secured loans, if you give, even if your company don't repay, you will sell the asset and get back your money. You should take a risk. Then I will believe that you are confident on your company performance. Therefore, you do one thing. Promoters, you are giving loan to company, give unsecured loan. Give which loan? Unsecured loan. How much loan you want from me? 5 crore. 20% of 5 crore. Example, get 20%. Don't write this in exam. 20% of the bank loan. Okay. Means 1 crore. 5 crore, 20%, 1 crore. You give as an unsecured loan to your company. You give. Once you give unsecured loan to your company for that particular amount, whatever bank said, then I believe that you are having confidence on your company. We will sanction the loan. Understood? Now, second question. Unsecured bank loan given, sanction. Bank loan sanctioned for 10 years. Okay? Promoters gave unsecured loan to company, that is for 12 years. Now, what is happening? Your unsecured loan is for 10 years, or 12 years. Bank loan is for 10 years. Means, even after paying the bank loan, still there is an unsecured loan taken by the company from the promoters. For that 2 years, it will be treated as a deposit. That's why term of such unsecured loan should not be more than term of the bank loan. Do you understand the meaning, everyone? Reply. Okay. Next. Deposits accepted by Nidhi company. Nidhi company ke work ke deposit acceptance. For them, you should not apply this. Deposit accepted by chit fund company. Okay, amount accepted by collective investment schemes, SEBI operated collective investment scheme. Next one, any other mutual fund, etc. All these things will not be included into deposit. Next, amount received by startup. This is important. Yeah, exam question can come. Any amount received by startup under 4 conditions. Amount is received by startup from a person in one single tranche, means not in installments. Amount should be more than 25 lakh or 25 lakhs or more. So amount is received by a startup company from one person in one single tranche, and it should be 25 lakhs or more in the form of convertible note repayable in 10 years. Okay, if all the conditions are satisfied, startup company accepting any money will not be treated as a deposit for them. Final touch. Receipts in ordinary course of business. See here, business advances, advances against capital assets, advances against immovable properties. Okay, advance against immovable properties, all these things will not be treated as a deposit. Example, fatafat, one by one example I will give you, listen carefully. Advance against supply of goods, advance against supply of goods. See here, listen carefully, one time I will tell each example. Okay, Mr. A went to company. Mr. A went to company, said that company is in manufacturing of furniture. Manufacturing of furniture. Mr. A went to company and said, we want 1,000 benches for our school. 1,000 benches for our school. Each bench is 5,000 rupees. Say example, each bench is 5,000 rupees. I asked 1,000 benches. 5,000, see, I'm telling you clearly, 5,000 benches. Each bench is 5,000 rupees. So, this much I need to pay. Are you understand the point or not? So, I should pay 2 crore 50 lakh. That means, simply to understand, to manufacture, who will, companies in furniture manufacturing, they will manufacture benches and put it in godown, unnecessary waste of working capital. On order, they will manufacture. So, Mr. A went to company and said that I want 1,000 benches manufacturing. Company said that, yes, sir, we will do that. No worry. So then he said that, then start. What start? We need wood. We need material. For all these things, we require some cost. That cost we only give as an advance. So they ask 2.5 crore is the total value of the contract. You pay 50 lakhs now itself. Advance you pay. Okay. Whether that advance towards the supply of goods is a deposit, it will become a deposit if supply is not completed within 365 days. Okay, or you are not doing appropriation of these amounts. What does it mean? See, benches of 1,000 manufacturing, 5,000 benches manufacturing will take, say for example, 6 months time or 7 months time. So supply should be completed within 365 days. That is number one. Number two, 6 months completed. How much you have to pay now? How much Mr. A have to pay to company? 2 crore only. Why? In that already 50 lakh I paid. If A pays again 2,50,000 and that 50 lakh which is paid, if we repaid back later, then it will be treated as a deposit. Always the adjustment should be done. Advance means it is an amount to the total amount adjustment. So 2 crore 50 lakhs, the 50 lakhs I paid means again how much I should pay? 2 crore I should pay. Again, if you pay 2,50,000, that's it. The first 50,000 will be treated as a deposit. Everybody understood the point clearly? Everyone understood the concept clearly? Yeah. So, advance towards supply of goods. Advance should be appropriated against the goods. Okay, that's it. That's the main point to remember. Next one. Same concept. Advance towards immovable property. Whenever you wanted to purchase any building, okay, company is in infrastructure, company is in real estate. Mine is a real estate company. Mine is a real estate company. You are a customer. You came. You said, sir, I want this building. I said 5 crore rupee. Yes, sir, I will come and take after 1 month. Okay, then I said, pay 1 crore advance, balance 1 crore you can balance 1 crore you can pay later, I said. Now 1 crore you pay now, as a deposit for the company. Advance is collected and it is adjusted to sale, towards sale of immovable property. Same. Advance against other capital goods, other than immovable property, any other capital goods. Next one. Security deposit for performance of a contract. Okay, security deposit against performance of a contract. See, marriage time, generally what they will do, they will give food contract to someone. Food contract. They will tell, sir, you pay 1 lakh advance first. Their 1 lakh is not to buy any material. It is a doubt on you. If you do not perform that particular function, I will be at risk after buying all these things. Now, security deposit for performance of contract, not a deposit. Next one. Advance for future services. A simple way I will tell you. Companies, so many companies, Vijay Sales or Bajaj Electronics, Reliance Digital, Chroma, all these electronic companies, whenever you go to these electronics, whenever you purchase an iPad, something like that, they will tell, sir, shall we add additional insurance, 5,000 rupees for next 3 years, like that. That 5,000 rupees is advance collected for future services. Future, if any warranty service is required, we will do that. For that, we are collecting. Is that a deposit? It will not be a deposit, but it will become a deposit if the term of that warranty period is exceeding 5 years or such period generally followed, whichever is, okay. So if it is exceeding, that's why, see here, how much term of warranty should not exceed time which generally in practice are 5 years. So for example, general electronic goods term of warranty generally practicing is what? 3 years. If your warranty collection is for 5 years, balance 2 years, I will call that 5,000 as a deposit, okay, or 5 years. Or 5 years. Sir, there is no general practice in this industry about that. Then 5 years period is the maximum warranty period you can take as a deposit. Okay. Then allowed. No problem. It's not a deposit. With this, we completed main concept of deposits chapter. What is not a deposit has been completed. First of all, everyone give a reply. Did you all understand and felt comfortable with this area up to here? Everyone. Are you all clear? Okay. So let us continue with the remaining rules in deposits. See here. Prohibition on acceptance of deposits from public. Prohibition on acceptance of deposits from public. A company is prohibited to accept deposits from public except in the manner provided in section 76 with the rules. So public deposits can be accepted only if you comply with provisions of section 76. Okay. Next. Conditions for acceptance of deposits from members. Listen, whatever conditions you are reading now, deposits to be accepted from members, same concepts are also applicable for acceptance of deposits from public. Along with these, some additional conditions will come. This is discussed in section 73 subsection 2. So 76 section is public acceptance of deposits. 73 is member acceptance of deposits. Public acceptance of deposits ki rules are there. What are the rules? These rules plus 76 points. Okay. So first one, conditions for acceptance of deposits from members. If you want to accept deposits from members, what is the condition? First one, it can either be a public or private company. So you can be public or private. Private company can accept only from members. Public company can accept both from members as well as public. Now we are reading the member deposits. First one, obtain the approval of shareholders by passing ordinary resolution. Special resolution in some cases. What are those some cases? We will see in 76. So normally acceptance or deposit require what? Shareholders by passing ordinary resolution. Next one, issue a circular. So one circular has to be issued. Circular means what? Circular means within the company. Prospectus means to the public. Okay. So this is the circular containing the details. What circular? Financial position of a company. You should tell whether your financial position is good or bad. You should tell. Depending on the people will invest in your deposits. Next one, the credit rating obtained. What is obtained? Credit rating is obtained. Next one, number of depositors and amount due. Number of depositors and amount due. So repeat again. What are the things that are required? Financial position of a company, credit rating required, number of depositors and number of depositors there in the company, and the amount due. So these three things must be there in the circular. Financial position, credit rating, and number of depositors. What is number of depositors? Already if the company accepted any deposits in the past, those depositors will be there na, the list of all the depositors along with the amount due to them. Okay, these are the three things that you need to provide, must and should. So financial position, credit rating, number of depositors existing and amount due to them. Done. So what is this credit rating? Credit rating can be given either by chartered accountant in practice or by credit rating agencies. Member deposits ke credit rating agency is not required. Chartered accountant also can give a credit rating. Credit rating means whether this company is proper in making the due payments to creditors or not. Bank loans interest paid properly or not. TDS deduction properly made to employees or not. Like this, so many financial constraints will be there. 21, 25 categories will be there. A categories like if you are perfect, they will give AAA++ rating. Some defaults, AAA plus, more default, AAA, more default, AA. Like that, it will go down. Okay, B rating is C rating, now you can forget about that company. So that's how credit rating will be given. So if there are any existing depositors, number of depositors and amount due to them, you should give in the circular. So what is the guarantee that whatever the circular you are issuing to the members is a correct circular? Prospectus we read the misstatements in prospectus, like that in the circular also misstatements can be there. Therefore, don't issue circular to members directly. At least 30 days before issuance of circular to members, you should file it with ROC. Prior, 30 days prior. Before you issue to the members, first issue to the ROC. DRF we read na? Debentures DRF, 15% April 30, same concept here. April 30 is common, but it should be 20%, not just 15%. Okay. Next. If a company has committed any default with respect to any deposits already accepted, it cannot accept money in the form of deposits for 5 years from the date of making good the default. Means what? Already you accepted some deposits. Those deposits say you did not pay properly. Default committed. And the default has been rectified. The date on which you rectified the defect, from there 5 years, you cannot accept the deposits. Next one. If the deposits are unsecured, circular clearly mention in the quotations that the deposits are unsecured deposits. Everybody, please tell me, understood this clearly or not? 6 points are there. First, it will be either public or private company. Obtain the approval of shareholders by passing ordinary resolutions in a general meeting, sometimes special resolution. Circular should be issued containing financial position, credit rating, and the details of the existing deposits and the amount and number of depositors. File the circular with ROC 30 days prior to the issue of circular. And deposits repayment fund we need to create on April 30th for the deposits maturing that year. 20% should be deposited in that on or before 30th of April. And next one, if there are any committed defaults on deposits, then you have to clear them. Once you clear from there 5 years, you are disqualified from issuing the deposits. Next one, after that, if the deposit is a secure deposit, okay. If it is unsecured, clearly keep in the quotations, it is unsecured. Everybody, please answer, understood this point clearly? Clear? Next. Acceptance of deposits from public. Acceptance of deposits from public. Applicability. Public company only, not applicable to private company. So private company cannot go for public deposits. Private company cannot go for public deposits. What are the conditions? It should be a public company. Very, very important, listen carefully. It should be a public company. Every public company cannot go for public deposits. They should satisfy some conditions. It should be public company. Net worth should be 100 crores or more. Or turnover should be 500 crores or more. Condition 3. Pass a resolution subject to section 181C. 181C I left there and I said I will discuss in deposits. This is the time. I will tell you what is that. 180 subsection 1 class C. Bare Act 181C will say 180 subsection 1 class C. Bare Act it will tell that to borrow money where the money to be borrowed together with the money already borrowed will exceed aggregate of paid up share capital, free reserves and securities premium apart from the temporary loans obtained from the company's bankers in its ordinary course of business. This is what they actually tell in 181C. I will tell in a easy way, listen carefully. They will say to borrow money where the money to be borrowed and proposed borrowing together with and addition money already borrowed existing borrowing will exceed more than aggregate of sigma paid up share capital plus free reserves plus securities premium account, then special resolution is required. Okay, now listen. Proposed borrowing plus existing borrowing, if it exceeds paid up share capital, free reserves and securities premium, paid up share capital paid up equity and paid up preference both will come. What is the meaning of paid up share capital, free reserves and securities premium? This concept financial management I used to teach. I used to tell this is called as equity, not equity share capital. Owner's fund is called as equity. Is called as what? Equity. Owner's fund is called as equity. So this is equity. Both put together is called as what? Debt. Debt, if it exceeds equity, special resolution required. That's the logic. Did you understand? Everyone, I'm talking to you. Do you understand or not? Yeah. So what is the point here? Existing borrowing plus existing borrowing plus proposed borrowing is a debt. If the debt exceeds equity, what do you mean by that? If the debt equity ratio exceeds 1:1, special resolution is required. Okay, this is the idea. Now listen carefully. Company accepted deposits. Now you all people should answer. Company is accepting deposits. Okay, means RHS is increasing, LHS is increasing. If company accept deposits, RHS increase, LHS increase. Everyone, all the participants. So LHS will change. That's what he's saying. Existing borrowing, let us say, he paid up share capital, free reserve, securities premium is 100 lakhs. Okay, 100 lakhs. Existing borrowings 95 lakh. Now proposed borrowing is a deposit. This deposit is 6 lakh. Now instead of ordinary resolution there, special resolution required. It is only 4 lakh, 99 lakh only, which is not more than 100, then ordinary resolution is required. Now did you understand when ordinary and when special? Okay, so that you need to keep in mind. So therefore, start. Mine is a public company. Okay, that public company has a net worth of 100 crore or more, or turnover of rupees 500 crore or more. Okay, and pass a resolution subject to 181C. Means if the limit exceeds 181C, special resolution or else ordinary. If special resolution is passed, MGT 14 you have to file within 30 days of passing SR. This is not as per deposits chapter. This is as per general meetings chapter section 117. Section 117 what they say is, if any special resolution is passed, wherever, whichever section, entire company cycle, wherever special resolution is passed, within 30 days of passing special resolution, file the copy of special resolution with the ROC in form MGT 14 within 30 days. I need not tell this again and again. Wherever special resolution comes in syllabus, this will apply. Okay, next one. So conditions of applicability we read. Other conditions. Comply with 173(2) means all the 6 conditions. So 6 conditions plus rules compliance, credit rating conditions. Here public deposit credit rating should not be with a CA. Credit rating should be from a credit rating agency like CRISIL, etc. Credit rating should be informed to public before accepting deposits. And if the tenure of deposits is 3 years, all the 3 years you have to obtain credit rating. Okay, all the 3 years we have to obtain credit rating. Next one, where the company accepts secure deposits, it shall within 30 days therefrom shall register the charge. This we will see in the charges chapter. Okay, next. First of all, everyone tell me, did you all understand section 76 clearly? Yeah. Final touch rules we will read and close this chapter also. Everyone understood section 76 clearly? Okay. I am making it full screen. I will pause the video like this. You read and complete. So let's continue. Next one, punishment for contravention. Punishment for contravention of what? Section 73 and section 76. Punishment for contravention. When section gets attracted, company invites or accepts deposits in contravention of 73 or 76. Means we read na 73, 76. In contravention, you accepted deposits. Okay. Next, condition 2. Or second condition, you accepted properly only, but you failed to repay the deposit. In these two cases, who is liable? Both company and officer in default. What is the liability? On the company, liable to repay the deposits and interest due, and liable to fine minimum 1 crore or 2 times the deposit, whichever is lower. Maximum can run up to 10 crore. On officer in default, imprisonment will be maximum 7 years and fine minimum 25 lakhs and maximum 2 crore. Punishments I will not discuss in the class, you know, just you have to remember. And this is one of the most important penalty sections in exam. Okay, just read and remember. That's it, more than enough. Now we are coming into some summary of rules attached to 73 and 76. Okay, see, content, acceptance of deposits from members. 73. 76 will be talking about acceptance of deposits from public. Who can accept deposit? Both public as well as private. Here, only eligible public company. Eligible public company means it should be a public company. Net worth should be 100 crores or more, or turnover should be 500 crores or more. Pass the special resolution if it is a 181C crossing limit. Am I clear? All these things, credit rating, etc. Next, issuance of circular. Circular is mandatory. It shall be in form DPT1. Circular shall be attached with the certificate of statutory auditor that there is no default in the deposit. So circular should be given in form DPT1. It should contain a no objection certificate from the chartered accountant auditor of the company that there is no default in deposits already accepted. Public deposit also same. Validity period of a circular. Circular is valid for 3 periods whichever is earlier. 6 months from the closure of financial year until 30th of September. AGM date if held. For example, if I held AGM on 10/9, that 10/9. Or last date on which AGM should have been held as per section number 96. Whichever is earlier. Okay. Next. Same as section 70. Tenure of deposits. What should be the general tenure of a deposit? Minimum 6 months, maximum 36 months. Demand deposits you should not accept. Demand deposit means a saving deposit. Whenever a person demand, you should give back money. Like that you should never accept. Maximum term, there is no exception. Means what? Maximum 36 months means 36 months. Next, minimum exception is there. What is the exception? Minimum 3 months you can accept, and amount of deposit should not exceed 10% of paid up share capital free reserves and equity premium. Means the amount of deposits you are accepting is not exceeding 10% of the equity. Then you can. Same as section 73 here. Next one, maximum amount of deposits. ED means existing deposit, PD means proposed deposit. Okay, maximum deposit. We are talking about acceptance from members. From members, how much you can? Private company na, anyway it cannot accept from public. The only thing is members. So 100% of paid up share capital free reserve securities premium you can accept in case of which company? Private company. So existing deposits from proposed deposits, if it does not exceed 100%, you can accept. In case of a public company, borrowing two types are there. Borrowing in the form of deposits, other than deposits. Deposits should not exceed 35% of equity. Okay, 35% of equity, and a balance 75% can be in the form of others. So existing deposits and proposed deposits, not all borrowing, deposit borrowings should not exceed 35% of paid up share capital free reserves and securities premium. Next, sir, I am not accepting, sir. I am not accepting from public under 76, sir. My company is a private company. 76 does not apply. So private company anyway prohibited. If you are an eligible public company, those eligibility from members, public means what? From general public, from members also you can take. During public acceptance of deposits, members also you can accept. That should not go beyond 10% of paid share capital securities premium. Public should not go beyond 25%. Total again will come to 35%. But if that eligible public company happens to be government company, there is no bifurcation on members and public, maximum 35%. Next, premature settlement. Okay, premature settlement means what? A depositor said that normally we gave for 2 years. A depositor came and said that, sir, I want after 8 months only. Then request should come from depositor. Company cannot voluntarily do. Interest will be reduced by 1% and paid to him. Same as 73. Read all the contents. I'm making it full screen. Okay, next. So with this, we completed another chapter called as acceptance of deposits from public. Acceptance of deposits by companies, anything you can call. This is also completed. So we have successfully done with another chapter called as deposits. First of all, everyone tell me, are you all confident with both the chapters now completed? One is the debentures, another one is the deposits. Everyone, are you all confident with these two chapters? Everyone? Yeah. So, I just wanted to tell you that we are now going to start with a next chapter. Name of the chapter is Registration of Charges. One attempt also came for 15 marks, but don't expect that 15 marks to come in every examination. Generally, they will give a good amount of marks only. Very important. Okay. But try to understand. 4 marks to 5 marks you can expect from this chapter. Okay. Name of the chapter is Registration of Charges. Okay. Let us now start with the chapter Registration of Charges. As I said, 35 to 40 minutes is the time that we have to spend on this chapter. Beyond that, don't spend. Okay, unnecessary. Let us understand what is this concept. Registration of charges, definition of charge, and types of charges. Let us see what is a charge. Charge is an interest or a lien created on the property, assets, or undertaking of a company, both as a security and includes a mortgage. Both as a security and includes a mortgage. So, charge means an interest. Interest means not interest payment. Interest means a particular concern on the assets. Okay, on the property, assets, or undertaking of a company, either or both as a security or as a mortgage. Mortgage will be created on immovable properties. Securities and other things will be created on movable properties. Okay. Now, next one. There are two types of charges. First one, fixed charge, floating charge. Fixed charge, floating charge. Read the content clearly. Charge is an interest or a lien created on property, assets, or undertaking, or both of a company and includes a mortgage. Number one. Number two, there are two types of charges. Fastly, I will cover, listen carefully. There are two different concepts we are going to discuss now. One is meaning of fixed charge, meaning of floating charge, and next one, crystallization of floating charge. Crystallization of floating charge. Crystallization means conversion of floating charge into fixed charge. Okay, first let me explain what is a fixed charge. Fixed charge is a charge created on specific identified assets of a company. Specific identified assets of a company means it will be fixed in nature. Means the charge once created on the asset, generally they do not change. Such kind of charge we call as a fixed charge. I repeat again. Fixed charge means a charge created on specific identified assets of a company. That's called as a fixed charge. Next one. There is another charge called as a floating charge. It will be always on fluctuating assets. So now examples. Charge created on land, charge created on building, charge created on plant and machinery. All these are called as a fixed charge because there is a separate asset, land. That's it. Okay, that's a fixed charge. Floating charge. Charge created on current assets of a company, which are fluctuating every day. I will create a charge on goods. Okay, I will create charge on goods. Today goods, tomorrow it will become debtors. On the debtors I will have charge. Debtors will realize into cash. On the cash I will have charge. Cash again turn into stock. Again in the stock I will have a charge. I will tell I have 10 lakh charge on current assets. Whatever form of the current asset is there, I will have a charge on that particular current assets. But every day it will fluctuate. Every day it will fluctuate. I created charge on stock. Stock will go out, become debtor. Now on debtors I will have charge. Debtors realized and became cash. On cash I will have a charge. Cash again became a stock. I will have a charge on the stock again. Now can you identify on what you are having a charge? You cannot. That's called as a floating charge, which will float every single day. Okay. Second point. Once the assets are kept as a fixed charge, for example, you gave me loan. Okay. I gave my land as a security. Without your permission, I can't sell the land. Point one. So once the assets are subjected to fixed charge, charge holder, okay, or you are the charge holder, I am the debtor. So the debtor cannot deal with the assets under charge without the approval of charge holder. Simply here, who is the debtor? Company. So once the assets are kept for fixed charge, company cannot deal with the assets under fixed charge without consent of the charge holder. Everybody understood the concept clearly? Floating assets, floating charge, you can, floating charge, the stock will be there. Stock will be sold every second. I will ask creditor always, creditor, can I sell? How many times you will ask? So assets are subjected to floating charge can be dealt by the company even without taking the consultation of charge holder. Next one. Crystallization of floating charge. Normally, what is the concept of floating charge? You can deal with the assets subjected to floating charge without the permission of a charge holder. However, whenever company goes into liquidation, means company is not there. Second, business is not operative. Business is seized. Number three, company is not paying the debts properly. Means terms and conditions are breached by the company. In these three cases, breach of terms and conditions, or company discontinued the business, or company is going into liquidation. At that time, company has no right on the assets. Floating assets also will be taken by charge holder. You cannot sell those floating charge assets also. That means crystallization of floating charge. Floating charge has been converted into fixed charge. Up to here, everyone understood the point clearly? I'm talking to everyone. Understood everyone? So now read the first page. Let's continue. Next one. Now we completed what is the meaning of a fixed charge and what is the meaning of a floating charge. See, from now onwards, 20 minutes you spare your time properly and listen. Okay? Spare your time and listen to all the concepts carefully from now. Okay? So the next part will be very important. Each and every section 5 minutes to 6 minutes I will cover. Small sections ki 1-2 minutes we will spend. So please listen carefully. I will not repeat a number of times. But chapter is very important, as you know, and as I already said. See, first one, duty to register the charge. Duty to register the charge. Whenever charge is created, it is a duty of the company creating the charge on property, assets or undertaking. So whenever company has taken a loan and it is a secured loan, charge is created. This chapter is not talking about creating the charge. After creation, you should register the charge such that it will become a public document. So anyone coming into the company, when they see what assets of the company are under the charge, it is a public information and available on the public platform called as MCA website. MCA website. So repeat again. Whenever company create a charge, creation of charge is not dealt by this chapter. Once you create the charge, registering the created charge is the subject discussion of this chapter. So what happens? It is the duty of the company. It is the duty of the company creating the charge on the property. Okay. On what property can create charge? Tangible property, intangible, movable, immobile, in India, outside India. Whatever you want, you can. Either in India or outside India. To register the particular subcharge within 30 days of creation. Very important due date. Whenever charge is created, within 30 days of creating the charge, file it with the ROC. Okay. If the charge is not registered within 30 days, okay, if the charge is not registered within 30 days, company shall make application to ROC for extension. Okay. ROC, if he is satisfied that there is a sufficient cause for not filing within 30 days, he will give another 30 days time, totally 60 days from creation. Okay. So another 30 days. So how to understand? Normally you should file within 30 days. If you could not file, ask the ROC to go for extension, that you want an extension. ROC can give extension of time such that you should file within 60 days from the date of creation. Means a maximum extension is possible for how many days? 30 days. Next one. If you do not register the charge even within that 60 days time totally, then again a 30 days time will be given. Okay. Again a 60 days time will be given. So 30 plus 30 plus 60. So first timing 30, extension 30, totally 60. Again extension 60. Now I will not charge additional fee. I will charge ad valorem free and daily fees, daily 100 extra or daily 1000 extra, like the daily payments. So summarize everything on 77 and tell me now. Point number 1. Whenever company is creating a charge on any assets or property undertaking, it should file a registration of charge within 30 days. Okay, within 30 days. Could not, next 30 days. Could not, another 60 days. Very good. What is the form you need to file? If charge is created on the debentures, CHG 9. If charge is created on other than debentures like deposits, loans, etc., CHG 1. CHG 1 you have to file, 9 in case of debentures. Okay. It is an instrument creating the charge. It is an instrument creating the charge. Okay. You filed with ROC. What you filed? You filed for registration of charge. Registration of creation of charge. Now ROC will give you certificate of registration of creation of charge in form number CHG2. So company will file in CHG 1 or 9. ROC will give you certificate in CHG2. Okay. Sir, I have a doubt. I created a charge. But I did not register it with ROC. Now what will happen? Nothing will happen. Loan will be treated as unsecured loan. Creditors will die. Okay. Loan will be treated as a unsecured loan. Okay. Number 1. So therefore charge will become valid or void? Void. Ade point. Consequences of non-registration of charge. Charge will become void and it is not taken into account by liquidator or creditor. Okay. So at the time of winding up, creditor whose charge was not registered would be treated as a unsecured creditor. Charge holder loses the priority. Okay. That is the point. Sir, then company will intentionally do that. That's why there is a punishment under section 86. Okay. We will read that. Okay. Now listen. Just now I told you, you created a charge, but you did not register the charge. Loan will become invalid. Charge will become invalid. Charge will become invalid. You have a liability to repay the loan, but as an unsecured loan. That's why non-registration does not damage the obligation. Prejudice means damage. Does not damage the obligation of company for repayment of money. Okay. So money will not be, money repayment is mandatory, but you should pay it as a unsecured loan. Next. That's it. These are all some important points in section number 77. Everybody please answer section 77. Everyone understood clearly? If you say yes, I will go into the next concept immediately and I will complete. Okay. Okay. Let us now focus on next one. See, there are three sections for us. Okay. 78, 79, 80. Small sections. 78. Before that, I will first tell you. Just now I told you. Company has taken loan from creditors, debenture holders, bank, etc. Created charge, but it did not register. Now, who is the affected party? Company or charge holder? Charge holder is affected because if you do not register the charge, my loan will become unsecured loan. Therefore, within 30 days, if company do not register the charge with ROC, charge holder themselves can apply to ROC for registration of charge. So, company did not register within 30 days. Charge holder immediately can apply for registration of charge. ROC will not directly register. ROC will give a show cause notice to the company. Are company mutal, you are sleeping. You are not applying for registration of charge. One of your charge holder has applied for it. Why you are not registering? Show cause notice will be sent. A reply should come from the company within 14 days. What reply should come? Either company should tell that we will register by extension, or reason they will tell why they are not registering it in 30 days. If proper reply comes from the company within 14 days, ROC will tell to the charge holder, or a charge holder, unnecessarily you are getting excited, they are ready to register. No worry. If no reply has come within 14 days, or if the reply is insufficient or inadequate, charge holder's documentation is made to ROC, that will be registered. But you have to remember, company will apply in CHG 1 and 9. Charge holder also will apply in CHG 1 and 9. Fees will be paid by company. Now charge holder is applying, charge holder will pay the fee. But charge holder will get the reimbursement of fee back from the company because your work I have done, right, idiot. That's what lawmaker intention was. Everybody understood? Okay. Now read 78. Let's continue with the next part. What is the next one? We completed 78. Now we are coming into section number 79. Okay. Listen. There is a concept called as modification of charge. Okay. Modification of charge. For that also same provisions of 77 will apply. And CHG 1, CHG 9, all these will apply. Okay. So listen carefully. What is this concept? Listen. I will first explain like previous one, then you read. Clarity will be there. There is one company called as X Limited. There is another company called as Y Limited. Listen carefully. There is a company called as X Limited. There is company called as Y Limited. X Limited balance sheet la, there is a land and building worth 100 crores. Which is kept as a security for the loan worth 70 crore. Okay. This land and building was kept as a security for that loan. X Limited la. X Limited sold that asset which is under the charge to Y Limited. With the permission of charge holder. They said that we will create charge on another asset. This asset we will sell. So it is already under the charge. That charged asset was sold by X Limited to Y Limited. Now Y Limited is acquiring an asset which is subjected to charge. Means what? On the due date, X Limited taken loan from its creditor. Now the creditor will come to Y Limited now. If X Limited fails to repay, you should pay me. Therefore, whenever company is acquiring assets under the charge, Okay, company is acquiring assets under the charge. Whatever the loan you have taken from that person, I will deduct that amount and balance they will pay. Sir, I did not understand. See here. X Limited, Y Limited. X Limited took loan of 70 crore, kept land and building of 100 crore as a security. Okay. Now this is under security. Under security. This land and building. This land and building was sold to Y Limited. Now Y Limited is acquiring a asset free from charge, already under charge. Already under the charge. Already under what's a charge. But Y Limited will pay 100 crores. No, it will pay only 30 crores to Y Limited, X Limited. Why? Array 70 crores I have to pay if you don't pay. Correct or not? Therefore, I will pay only that particular amount and I will take this asset. Okay. So, land and building worth 100 crores was acquired, which is purchased only at 30 crore because on the due date, I will pay him. Okay. Now, Y Limited is acquiring an asset which is already subjected to charge. Okay. That means Y Limited, though it did not take any loan directly, others loan it has an obligation now. For this also, if the loan taken is other than debentures, CHG 1 you have to file here. If it is a loan, if it is debenture, CHG 9 you have to file. Who should file? Y Limited has to file. Old charge created in the name of X Limited will be vacated. New charge will be created in the name of Y Limited. Did you understand what I said now? Everybody. Did you understand what I said? Okay, done. So this is one point. This is called as a modification of charge. Or second thing, loan is taken by Y Limited. Asset also belonging to Y Limited kept as a charge. Now terms and conditions we are changing. Normally loan term is 7 years. Now I wanted to make it 10 years. Interest is only 9.5%. Now I wanted to make it 10.5%. Terms and conditions are changing. Again you have to refile the charge to the ROC. So for modification of charge, what are the forms? Same forms. Okay, same form. That's why they said section 77 shall apply to the company acquiring property subjected to charge or modification terms and conditions. Same CAG1, CAG2, 9 law you will apply for modification, but ROC certificate will change. ROC certificate for creation is CHG2, modification certificate will be in CHG3. Okay. If a property which charge is registered, if a property on which charge is registered is sold with the permission of charge holder, the company acquiring it shall get the charge registered. Earlier charge gets vacated. In our example, X Limited charge vacated. New charge is registered. Y Limited namely registration. Modification, that is variation in terms and conditions, will also shall be registered under section 77, CAG1 and CAG9 respectively. ROC will give a certificate of modification of charge in form CHG3. Okay. Now, I have one small question before we move on into the next part. What could be the possible question? Listen carefully. Company is acquiring asset under charge. In our example, X Limited is selling the asset, Y Limited is buying the asset. X Limited at the time of sale did not tell that a charge is there on this asset. Okay, I repeat again. X Limited is selling asset to Y Limited which is already under charge. Y Limited is purchasing it. X Limited did not tell to Y Limited that this asset is under the charge. Is it the mistake of X Limited or not? Like this exam question can come. Not at all a mistake, because once the charge is registered, it's a public document. It's a public document. What will happen if it is a public document? Whenever X Limited is selling to Y Limited, X Limited will deem that Y Limited has a notice of the charge. Sir, I did not read. That's your mistake. I made it public. That's the meaning of this 80 section. So read section number 79 and section number 80. So let us continue. 84, you keep it aside, different chapter we will read. Company to report satisfaction of charge. Whenever the loan is repaid, and the charge is satisfied, whenever the loan, whenever the loan is repaid, about repayment also you should inform the ROC. That repayment information we call satisfaction of a charge. Whenever the charge is satisfied, that also you should intimate ROC within 30 days. But extension is not 30 and 60, extension is directly 270 days. Okay, how many days here? 270 days extension will be given. Until 300 days of satisfaction, you can inform to ROC. There only the chance was given. Okay, satisfaction of charge. See here. Company shall give intimation about the satisfaction of charge in form CAG4 to ROC within 30 days of payment. Okay. If intimation is not given within 30 days, he may allow even beyond 30 days. Okay, he may allow even beyond 30 days. $300 days, not 30 days. 300 days from the date of payment or satisfaction. Okay. Next. So mainly, one second. Ah, 300 days. 300 days of payment or satisfaction. Next one. 300 days means how to understand? Extra 270 days extension was given. Extra 270 days extension. But here, there is a catch point here. Previously, we read one point. Company has to register the charge. Company did not register. Who can apply? Charge holder himself can apply and ask the company to ROC to register. Now, what ROC will do? ROC will tell that, okay, I will first give a show cause notice to the company. Let us see what company will reply. If no reply is coming from company on the show cause notice within 14 days, then I will register the creation of charge. Same concept. Now satisfaction happened. What happened? Satisfaction happened. Normally company has to apply to the ROC saying that satisfaction happened, release the charge. Release the charge. But here one problem is there. Company did not repay to the debenture holders. Okay, it wanted to get its assets released. It wanted to do some fraud. Company will directly apply to ROC and say that I repaid everything. Please release the assets under charge. ROC released it. Later ROC found that the company did not repay the amounts properly. By that time they sold their assets also. Problem or not? That's why whenever satisfaction of charge intimation comes from the company directly, ROC will not directly register the satisfaction of charge. He will give a show cause notice to the charge holders now. He will give the show cause notice to the charge holder and ask the charge holder, do you have any objections? If you have any objections, show a cause. That's the show cause notice. Show a cause. Why we should not register the satisfaction as sent by company? Tell me one reason. If charge holder gives a proper reasoning why charge should not be registered, I mean the clearance of charge, the satisfaction, then ROC will not register the satisfaction of charge. He will intimate the company about the objections raised by charge holder. See. On receipt, ROC shall send a notice to the charge holder asking him to show cause within 14 days as to why satisfaction should not be recorded. Okay. Notice need not be sent if the intimation to ROC in form CAG4 is signed by charge holder. If charge holder himself said that they made entire payment release, then okay, no problem. You need not again give. Okay, next. If cause is shown, ROC shall record a note to that effect and inform the company. If no cause is shown, okay, ROC shall order entering of memorandum of satisfaction in the register. Simply he will register the satisfaction. ROC shall issue certificate of registration of satisfaction in form number CHG5. CHG5. So we will apply for satisfaction in 4. He will give certificate in 5. Next. Satisfaction happened. Company did not register. Company did not apply. Then who can apply? Charge holder. Or ROC, if he sumoto no, he can also do. This section empowers ROC to make entry for satisfaction or release of charge, even if no intimation is received by the company. So from whom you receive? Charge holder. If evidence is shown to the satisfaction of ROC that debt secured by charge is paid, or there is a seizure of company property, he himself can do the release of property from charge. This is not that important. Next one, register of charges. Register of charges. Okay. There are two types of registers. Register kept by the ROC. ROC will keep register on MCA portal, www.mca.gov.in. There, ROC registers will be available. What is ROC register? Your charge documents filed with ROC will be kept in MCA website. ROC is not for your company. ROC is for entire state. So he will maintain on MCA website. But my company charge register, I only should keep or not. So register of charges kept by company. Company shall keep register along with all the details in Form CHG 7 at its register office. Register shall include the particulars of registered charges, property kept as a register, any details of creation, modification, satisfaction. Okay. Entry shall be made forthwith after creation, means immediately. Whenever a new charge is created, immediately you need to note it on the register. That's it. This is all about 81 and 85. Everyone tell me, did you all understand the concept up to here? Everyone? Simple concept here, nothing great in this area. Just a procedural compliance. Next. Punishment. Just read. Now, last one for this. A rectification by central government. See, what rectification? I will tell you what rectifications will cover this. Okay. See, satisfaction of charge made. What is made? Satisfaction of charge. I need to intimate within how many days? 30 days. I did not. How many days I have to do? Next to 270 days and a total 300. I did not do even within that time. Then what will happen? Loan is repaid, but assets are still under the charge. We have to release them. It's a genuine case. Therefore, if you could not register the satisfaction of charge even within 300 days, still extension is possible. This is not applicable for creation. Creation ki 3 dates, 30, 30, 60. That's it over. Or else the default date. But satisfaction ki 30 plus 270, totally 300 plus. Okay, we will ask for extension now. Central government will give extension of some time. Okay, that is one time. Satisfaction of charge we can ask. Second one, you filed charge registers and charge documents with ROC CHG1, CHG9, CHG4, CHG5, CHG7, all these things you have done. In that some mistakes and errors went. And those are unintentional, inadvertence, not intentionally committed. By mistake they committed. Now, section number 87 will empower company to ask for two things. Extension for satisfaction of charge beyond 300 days. Second one, rectification of errors and omissions in the registers already filed. So, this section empowers central government to order rectification of register of charges in following cases. Omission to give the intimation to ROC about satisfaction within specified time, 300 days. Omission or misstatement of particulars in filing with ROC. Okay, so that was accidental or due to inadvertence. Okay, inadvertent, by mistake, accidental or by mistake, we did not file that, or there is a small mistake in that. Next, CG may, on application made by company in form number CAG 8, give chance to rectify the omission or misstatement and extension of the time. Okay, that's it. So you can apply for ROC in form CH, central government in form CAG 8 for two things: rectification of mistakes in the registers caused accidentally or by inadvertence, or for asking for extension for registration of satisfaction of charge even beyond 300 days. Okay, that's it. Everybody understood the concept clearly? Everyone clear? With this, we completed another 3 chapters revision. Debentures, deposits, charges. What we completed now? Preliminaries, incorporation, prospectus, dividends, debentures, deposits, charges. All these are completed. Okay. Next target, accounts of company and foreign company. Okay. Accounts of company and foreign company. 1 hour for accounts of company, 1 hour for foreign company. Like this, 2 hours. Next session, we will cover another two chapters, accounts of company and foreign company. Once accounts of company, foreign company are completed, substantial part of your areas will get completed with that. Okay. So accounts of company and foreign company, next chapter, next discussion, we will close. Okay. So thank you very much, everyone. Meet you again in the tomorrow's class. So, okay. So the today's concept is accounts of company. This will be covered by Companies Act, Chapter 9. So Chapter 9 of Companies Act will be covering the aspects on accounts of company. How many marks we can expect from this chapter? Okay. First, let me show you for how many marks this has come in the last exam. See, accounts of company came for 15 marks in September 2025 exam, 10 marks in May 2025 exam, 13 marks in Jan 2025 exam, 8 marks in September 24, 10 marks May 24, 12 marks November 23. 5 attempts if you go back. 12 plus 10, 22, 22, 8, 30, 30, 13, 43, 43 and 10, 53, 53 and 15, 68, almost 70 marks. Okay, almost how many marks here? 17 marks, 70 marks. 70 marks in how many attempts? 6 attempts. Means average of 5 exams if you take, it's not even 8, it is somewhere around 11 marks on an average every year, every attempt they are asking from the chapter accounts of company. Okay. So accounts of companies chapter, please do not neglect at any cost. They will ask with high magnitude. Okay. Reasons are very clear. Reasons are very clear. Why this chapter was mostly tested in exam? Reason is very clear. Every auditor's firm you take, without this chapter there will be no audit firm, because accounts of company preparation comes mandatory for every kind of company. Preparation of books of accounts is mandatory for every kind of company. Even if you are a one-person company, that is applicable to you. So therefore, what you have to understand, books of accounts preparation, okay, preparation of financial statement, auditor's report, board's report, this is a mandatory requirement of every company. Definitely they will ask questions in exam. So therefore, accounts of company is one such chapter which comes for on an average 10 marks in exam. Okay, least case let 10 marks will come in this chapter in the examination. Shall we all begin, everyone? Okay, can we begin? Listen, time that we are going to spend on this chapter, 1 hour 15 minutes. That's it. More than that, 1 minute also I am not going to spend on this chapter. This chapter will come for high marks, but chapter is not difficult. Very easy chapter if you understand properly. Okay, let us begin. Name of the chapter, accounts of company. First one, there are some important definitions to cover. I will not repeat even once. I will tell once. If you listen, listen. That's it. Okay. So chapters like accounts of company, I can't spend lot of time just because of the reason that 10 marks will come. 10 marks will come because they want to test the student ability. That's it. Chapter was not difficult. Okay. Concentrate properly. Point number 1. What is the books of accounts? Books of accounts includes all records maintained by the company. Okay, all records maintained by the company. But here the word used is accounts. Therefore, books relating to the accounts only will come. 4 related accounts. Okay, sums received, sums spent, purchases, sales, assets, liabilities. If the company is involved in manufacturing, processing, etc., then cost records also will become mandatory. Answer over. So sums received and spent, purchase, sales, assets, liabilities. If company is involved in manufacturing, items of cost. That's why if required. Next one. What do you mean by book and paper? Book and paper, books of accounts also will be included. Means which is a more wider definition. Book and paper is a wider definition under Companies Act. Book and paper includes the books of accounts. Means all these are included. Okay. So next, deeds, minutes, documents, registers, writings and vouchers. Remember any 4 or 5 for the exam. Next, what is a branch office? What is a branch office? Branch office is another company or another place of business, another establishment recognized as a branch by the company. For example, our company is a head office is in Hyderabad. It said, my branch is in Chennai. That's all. That establishment is called as a branch. Branch is not another company. So, what is a branch? In relation to a company, branch means any establishment described as a branch office by company. Company, if it recognizes it as a branch office, it becomes a branch office. Okay, carrying on operations is not important. Description by company is important. That's the meaning. Next one. Financial statements. Very, very important definition. What are financial statements? In relation to company, financial statement includes books of accounts, includes book and paper, includes. Means what? These are all examples. Books of accounts include sums received, sums spent, purchase, sales. Next one, items of cost and section liability. Where is ledger? Where is journal? Where is all these? In that includes, they are already there. Okay. Next, book and paper includes books of account, deeds, vouchers, etc. All these they have given. There can be other books and papers also other than this. Okay. See, if you can see here, records are not there, but records have to be maintained. Returns are not there, but returns also you should maintain. Where are those? Includes, they are already included. Okay, next one. Financial statements in relation to a company includes, first one, financial statement. Don't tell P&L. Don't tell P&L. First, what should come? Companies Act, first thing is balance sheet. Next one, in case of Section 8 company, income expenditure. Other cases, the P&L account. Along with that, cash flow statement, statement showing changes in equity, explanatory statement. Okay, explanatory statement. Cash flow statement except for OPC, small company and dormant company. So in case of one person company, small company and dormant company, what is not required? Cash flow statement is not required for the financials. So only 4 will be there. Balance sheet, P&L, statement showing changes in equity and explanatory notes or notes forming part of accounts. Cash flow statement will not be there in case of small company, dormant company and one person company. Next one. So where is consolidated financial statement? It is already there in the word includes. Okay. So Section 8 company ki income expenditure, other companies ki P&L account. Next one. Next important definition. Financial year. Financial year means something which ends on 31st March. Something which ends on 31st March. A 12 months period with the 31st March ending. Means what? Starts on 1st April, ends on 31st March. Means normally period ending on 31st March of a year. It is generally. However, if you are a newly incorporated company, listen carefully. If you are a newly incorporated company, so my company is which company? Newly incorporated company. In a newly incorporated company, if your company is incorporated on or after Jan 1st, on or after Jan 1st, if your company got incorporated, your financial year will not end on immediate 31st March. Rather, your financial year will be ending on the following year 31st March. Means your financial year can be 15 months also. Your financial year can be 15 months also sometimes. Okay. So again I am repeating. Listen carefully. Your company got incorporated on or after Jan 1st. Your first financial year will end not on immediate 31st March, but it will end on the following year's 31st March. If your company got incorporated on 1st January 2025, your financial year will not end on 31st March 2025. Your first financial year will end on 31st March 2026. Thereafter again normally 12 months period will continue. Okay. So newly incorporated. When incorporated? Before Jan 1st. Then normal provisions only will apply. 31st March, 12 months. If you are incorporated on or after Jan 31st, financial year ends on 31st March of following year, in respect of preparation of its financial statements. Next one, special case. Special case. What is this special case? In case of a company or a body corporate, which is a holding company, subsidiary company, associate company of a company incorporated outside India. So there is a holding company, there is a subsidiary company, there is an associate company of a company incorporated outside India, and this company incorporated outside India required to prepare its financial statement by following a different financial year, okay, different financial year, then such company or a body corporate shall apply to CG, and CG may allow a different financial year which may not be a year. Means what? If you wanted to change your financial year, first condition number one, you should be either a holding company or subsidiary company or associate company of a company incorporated outside India. There is a company incorporated outside India. That company incorporated outside India has a holding company or a subsidiary company or associate company in India. Now this company incorporated in India, that holding subsidiary or associate, should apply to the central government. I want my financial year in tune with the financial year what we follow outside India. Then in that case, government may consider and ask you to follow a different financial year, which is not a year. Okay. Everybody please answer. Understood all the points clearly? Up to here, everyone had a clarity? Next one, section number 128. This is a section relating to the books of accounts, their preparation, preservation, placement, and inspection. How to prepare features of books of accounts, placement, where to put the books of accounts, inspection of books of accounts, preservation of books of accounts. These are the 4 things that we are going to cover in section number 128. Okay. Books of accounts, etc., to be kept by the company. Basics. Applicability. Every company, whether public or private. Next one. Nature of section. Mandatory. Obligation imposed. Shall prepare the books of accounts. Okay. Obligation 1. Relevant books and papers. Obligation 2. And financial statement. Obligation 3. So 3 things. Books of accounts, other books and papers, financial statements. For a financial year relating to registered office and branch office. So everything you need to put. Not only just a preparation. With proper narration you have to write. Explain the transactions effected both at RO and at BO. Okay. Next. Place to keep. Where to put the books of accounts? Generally books of accounts are kept at RO. However, in a special case, board of directors may decide to keep the books of accounts and books and papers at a place other than RO if the following conditions are satisfied. So you can put your books of accounts at a place other than that of registered office if such other place is in India. Means even if you want to change the books of accounts, you cannot put it in some other country. Within India you can place, and inform ROC about such place within 7 days, inform AOC 5. So what is the point here? Normally the books of accounts of a company should be kept at the registered office of a company. However, board of directors may decide to shift the books of accounts to some other place, but that some other place should be within India, and you have to file form number AOC 5 telling ROC what is that new place. Okay. 7 days of decision taken means what? The date on which board of directors took a decision to shift, from that day within 7 days. Next. Place to keep also over. Miscellaneous. Books of accounts shall give true and fair view. Double entry system should be adopted. It should be on accrual basis. Okay. First part I am putting it before you. Read it and complete. Then we will be going into the next part. Now. Next one. Other points in section 128. From here, it takes a difficult turn. So please listen carefully. One by one, let us understand. Okay. Special provisions for branch office. See, company is located, head office is located in Chennai. Branch office is located in Delhi. Okay. Preparation of books of accounts in branch office and sending to head office on daily basis becomes extremely difficult. Therefore, they gave exception completely to branches. What they said, in case of a branch office, whether in India or outside India, it shall be deemed to have complied with the provisions if books of accounts are kept at such place, means at the branch. So, full books of accounts will be prepared at the branch office and kept there. But to the registered office, proper summarized returns are sent to the RO periodically. Okay, sir, periodically means what? 1 month or 2 months or quarterly or half yearly or what is it? If it is Indian branch, periodically will be decided by board of directors. Means board of directors will tell whether to send 10 days or 1 day or 15 days or fortnightly or 1 month wise. They will tell. If it is a branch office located outside India, in such case, these all provisions do not apply. See that directly only one concept will apply. Every quarterly you have to send. So periodically decided by board of directors in case of Indian branch. In case of a foreign branch, quarterly returns must be sent, which will be termed as periodical. Okay, next. So in case of a branch located whether in India or outside India, it is enough if you maintain the books in the branch office, but to the registered office you send the proper summarized returns. Over. Next. Now starts the next one. Inspection. Who can inspect? See here, one by one. If the company is within India, then books of accounts are kept in registered office. Who can inspect? Directors can inspect, or their agents also can inspect at the RO during the business hours. Next, company in India, na? Answer is company in India. Yes. Branch office. I wanted to do branch office inspection. Branch inspection you need not do. If the branch is located within India, summarized returns sent at periodical intervals can be inspected by director at RO in business hours. If the branch is located outside India, you need not go there and inspect. Summarized returns are sent at quarterly intervals. Is inspected by director at RO during the business hours. No, sir. My company is located in India, but I don't have a branch, but I have a subsidiary. Whether subsidiary is in India or subsidiary is outside India, commonly one point is there. Inspection can be made only by person authorized by the board of directors. They did not tell director should inspect. It can even be CEO, CFO, stat auditor also. But only that person who is authorized by board only can go for inspection of my subsidiary company. Okay. No, sir. I wanted to do inspection. Inspection not of my company. Okay. Inspection not of my company. There is some other company outside India with whom we are making some dealings, purchase and sale of goods. I want their financial data. They are not my subsidiaries. For example, my company purchases a machinery from an exporter outside India. Okay, exporter outside India. Credit level we purchased the machinery. Auditor wanted to do external confirmation as per the standards on auditing. Standards on auditing, one of the standard is external confirmation. Whenever creditors are there on the balance sheet, blindly auditor should not put a tick mark. He should confirm with the creditor also whether you dealt with him really or not, whether this much amount is really paid and due or not. Like that, he has to do external confirmation. So our auditor wanted to discuss with, or our auditor wanted to get the financial information from a company incorporated outside the country. So at that time, auditor cannot directly ask the company outside India. Na? Therefore, if at all auditor want any external confirmation from a company outside our country, first auditor will ask director. If director want financial information maintained outside the country, director shall request that company outside India. It is not our subsidiary, it is not our branch. It is a Mr. Nobody. We don't know who they are, just we dealt with them. And the company shall send the financial information within 15 days of request. Request will be kept by whom? Director, not by the agents. But inspection can be done even by agents if it is within India. So within India, inspection can be done either by director or by agent. But request made by the director in India to a company outside the country, request can be made only by director and not by the agent. These are all given in the rule number 4. Rule number 4.1, rule number 4.2, rule number 4.3, rule number 4.4. Without putting the rule numbers, I have kept all the content here. Okay. It is a summary of this entire concept. Everybody, please tell me, are you all clear up to here? Regulation 89 of Table F. So what is this Regulation 89 of Table F? Let me explain. Okay, see here. Generally, we all have a notion, sir, books of accounts are prepared for the company, means members. Members have no right to inspect. Question will come or not, directors have inspection right. Members don't have inspection right. Listen, actually members don't have. Okay, actually members don't have. Inspection by members, not being a director. Board of directors shall decide such right, and they shall also decide the time, place, manner, scope and extent of inspection. Means what? Board of directors will decide the time, place, how to do, when to do, everything board of directors only will decide. That a member not being a director can do. For example, if I am both a member and a director, I will directly inspect in capacity as a director. But if I am not a director, only a member, then board of directors have to decide the place, time, scope, extent, what you can inspect, everything they will only decide. Okay. Okay. Now listen carefully. That means member don't have a power to do normal inspection of books of accounts. No, they cannot. Power to the members will come only from, okay, power to the members to inspect the books will come from three different sources. Number one, either in law they should give the power for members to inspect the books. For example, if there is any section in Companies Act which gives them power to make inspection, then you can inspect. Or board of directors should allow, just now we read. Or general meeting, they should pass a resolution allowing the members to inspect. If all these conditions, like any one condition is satisfied, means either law should give you, or board should allow you, or resolution should be passed in a general meeting. Then members can make an inspection. This is given in Regulation 89 of Articles, Model Articles, Table F. Hey, do you remember our Model Articles? Incorporation chapter we discussed already. Everyone? Okay? Yeah. Next. Maintenance of books of accounts in electronic form is a rule. I will discuss if time permit. Small concept, I'll never tested also. Okay, next. Directly, let us go into the next one. Preparation of financial statements. Preparation of financial statement. Is our next concept. Okay, see here. First one, features of financial statement. Financial statement should show true and fair view. Comply with AS and Ind AS. It should be in Schedule 3. So, three conditions, three features. Number one, it should give true and fair view. Next one, it should be as per Schedule 3. Third one, it should comply with the AS or Ind AS. Next one, exceptions. Okay, exceptions. What companies are covered? So, what is the point here? If you comply with the accounting standards, if you comply with the Schedule 3, then automatically true and fair view will be given. I repeat again. If you comply with accounting standard, if you comply with the Schedule 3 presentation of P&L balance sheet, Schedule 3 is the P&L and balance sheet format. So if you comply with Schedule 3 and if you comply with AS or Ind AS, automatically it is deemed that true and fair view is existed. Okay, true and fair view is existed. That automatically will happen. Understood the point? Okay, now listen carefully. So if you want to tell that there is a true and fair view, if you wanted to tell that there is a true and fair view, what are the conditions? First one, true and fair view is required, will be there if you follow AS or Ind AS, and if you present your P&L balance sheet as per Schedule 3. If both the conditions are satisfied, true and fair view is automatic. Now question will come. Banking companies will not follow Schedule 3. Insurance companies will not follow Schedule 3. Electricity companies will not follow Schedule 3. So many other companies in India which are incorporated under some other law. Okay, they do not prepare books of, they do not prepare their P&L balance sheet as per Schedule 3. And banking companies cannot apply all accounting standards. Insurance, electricity also same. Now tell me, banking company prepared its P&L balance sheet not according with Schedule 3. Banking company, insurance, electricity company cannot follow certain accounting standards. That means they are giving they are not giving a true and fair view. No. Therefore, the exception said that banking company, insurance company, electricity company. Okay, electricity company. In that case, it is deemed that financial statements are showing true and fair view even when they do not comply with AS or Ind AS, but they comply with their special governing law. Means what? I asked bank, did you follow accounting standard? No. Did you follow Schedule 3? No. Did you follow your own law? Yes, that's all. True and fair view is deemed. Means even though you do not comply with AS Ind AS or Schedule 3, I deem that there is a true and fair view if you comply with your own law. Everybody understood the point clearly? Everyone? Next one. Exception by CG. Exception by CG. See here. CG can grant exception to some companies from following accounting standard. In India, as of now, they did not give exception to anyone. Just namesake, this provision came. But one company, they have given exception. First, government company in defense. They need not comply with A17, segment reporting. Okay. So, CG may grant exception from any part of 129. Means CG may tell that, okay, you need not follow accounting standard. You need not prepare as per Schedule 3. Like that, it can give exception. Okay. That exception may be granted either directly by CG or company can apply also. Okay. It should be given in public interest, not in your company's interest. Really, government should feel, okay, in the interest of the public, this is required. Sir, give me one example. Why interest of public? Listen. There is a government company. That government company is purchasing Rafale jets, ammunition from France, Russia, etc. Okay. Segment reporting, do you know what will happen? Company should report where all its branches are located with a geographical location. They have to tell wherever they are doing their business. Government company defense production segment reporting, if they follow, they have to tell where their ammunition, everything is kept. That directly enemy will come and put a bomb on our head directly. Therefore, defense production companies ki safety point of view, government of India exempted segment reporting A17. As of now, no other company they have given exception. Accounting standards must to be followed. So CG may grant exception, okay, from any part of section 129, either on its own or on application, must be in public interest, and it may be with or without conditions. Okay. Example, I have written government company defense production need not comply with the provisions of AS17. Everybody in the class answer, did you all understand or not? Done. Next one. Duty of board of directors in case of non-compliance with accounting standards. If you do not comply with the accounting standards, what will happen? First thing is, board of directors have to disclose in financial statements. What they have to disclose? Fact of deviation. First tell that you deviated an accounting standard. Tell the reason why you deviated. Next, tell the financial impact. Okay. Next duty of board of directors. Okay. Duty of board of directors. Lay at AGM financial statements of that financial year. So of that financial year, financial statements are there na, balance sheet, P&L account, cash flow statement, and statement showing changes in equity, notes to accounts. All these things, please place it before the AGM. Okay. Next. Periodic financial statement, section 129A. CG may require certain classes of unlisted public company. Okay. See, listed public companies ki anyway there is a concept called as a interim financial reporting. Interim financial reporting is 25. That will tell interim financial reporting or interim financial statements. They have to prepare financial statements on 3 months basis. Quarterly basis they have to prepare. Whom? Listed company. But there are so many unlisted companies in India who are doing business almost like a listed company, but they are unlisted. And they are having good number of members also. Thousands of members are there, but never they went for listing. Taking them into consideration, government formed a new section 2 years back. Section number is 129A. CG may require certain classes of unlisted public company to prepare financial statements on periodic basis, 3 months. Okay. And whenever financial statements are prepared, generally what we will do? Main financials, AGM time. Board will first approve. Next to go to auditor. Next to go to shareholders. Same procedure again. Even periodic also, first apply and approval of board. Next to go for audit. Next to go for filing with the ROC. Shareholders approval will not be required. When shareholders will approve at the time of AGM, full financial statements of the financial year they will approve. These are all periodic. Na? One thing is missing. Shareholders approval is not required. So, prepare financial statements. get it first get the approval of board, next get it audited. For the 3 months only you will apply you will get the audit report na. That's why we call it limited review audit report. Next, file it with ROC within 30 days of completion of relevant period. Okay, next one. So the next one is special notes with respect to subsidiaries, associates and joint ventures. See here. See here. Yeah. From here, complicated concepts will come. 1, 2, 3, 4, 5. Below 1, 2, 3. Below 1, 2, 3. There are around 14 points. 14 or 12. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 points are there totally. 11 points, 11 golden points. Everything can come in exam. So 5 minutes we will complete this. So please follow the screen properly. Where a company is having subsidiaries, associates, joint ventures, then in addition to financial statement also prepare CFS of its subsidiary, associates and joint venture. Means what? If your company is having subsidiary, associates or joint venture, along with preparing your financial statement, also prepare a CFS with your subsidiaries. Number 1. Okay, sir, CFS I will prepare, sir. Which form it should be? Same form. M is missing. Same form and shall comply with AS. Okay, next one. Sir, which AS, sir? If it is consolidated financial statements of a subsidiary, AS 21. Of a associate, AS 23. Joint venture, AS 27. Like this, they have given 3 accounting standard: 21, 23, 27. Next one. Consolidated financial statement shall also be laid down in AGM. You will anyway lay your financial statements along with that also put the consolidated financial statements of your subsidiary at the AGM. Next one. Every company, see, there are so many companies in India where there are n number of subsidiaries for them. One financial statement bundle will be somewhere around 100-200 pages. I have 10 subsidiaries. Then it will become a 400-500 pages bundle. How difficult it will be for anyone to place it in the AGM and who will read? That's why they brought this concept. Every company shall, along with the financial statement, shall file a statement containing salient features of subsidiary, associate and joint venture in form AOC1. AOC1 you have to remember. AOC1 is a form which contains salient, means the most important, not silent, salient. Salient means the most important features of that particular subsidiary, associate, joint venture. What is important? Only those only we will put in 10-20 pages, such that bundle will become very small. So every company shall, along with the financial statement, shall file a statement containing salient features of subsidiary, associates and joint ventures in form AOC 1. Okay, next. Manner of consolidation as per rules. Before going into that, first read these 4 points here. Pause the screen and everyone read all the 4 points first. Next. See here. Non-applicability of consolidated statements. Okay, non-applicability of consolidation. Condition 1. Company is a subsidiary company of another company and company has obtained no objection from the members for not preparing CFS. First let us read. Condition 2. Company is not listed or not applied for listing. Condition 3. The ultimate or immediate holding company prepare and file consolidated statements as per AS. Very important. Yeah, exam they already tested 3-4 times this point. Non-applicability of consolidated statement. Read it first. Take time, read it first. Listen. What is the meaning? I will explain. See here. What they say is, there is a company X, there is a company Y, there is a company Z, there is a company A. 4 companies are there. Y is a subsidiary to X, Z is a subsidiary to Y, A is a subsidiary to Z. This is a chain. of various subsidiaries in the company. Okay, now listen carefully. What they said is, let us consider Y. Okay, Y. First point, X Limited will prepare consolidated financial statements. In that consolidated financial statements of X Limited, Y Limited, Z Limited, A Limited records are already consolidated. Their financials are already consolidated. Now question, Y Limited is a holding company to both Z and A. Deemed holding company, deemed subsidiary, we already read now. So, Y when it prepares its consolidated statements, it has to consolidate the records of Z and A, which are already consolidated with my ultimate holding company. Are you understanding? Which are already consolidated with ultimate holding company. Come to Z now. Z has to prepare CFS. It has to prepare consolidated statements of A. Okay. A's consolidated statements are already consolidated with the X Limited consolidation. Okay. Again, if I require, again it will become a duplication again, even in this case. Okay, because my holding company, see here, my holding company Y Limited and ultimate holding company Z Limited, any of these two people already prepared and sent financial statement. Then what is the point of Z again attaching the A's consolidation? It will become a duplication. Therefore, look at the scenario now. Again, one last time I will repeat because of complication involved. See, X Limited prepared consolidated financial statements of YZA. Y should prepare consolidated statements of Z and A. Z should prepare consolidated statements of A. Okay. Now listen carefully to the point. ZA already prepared and kept here. A kept here or kept also here. Therefore, lawmaker, what they thought? Why to duplicate like this unnecessarily? A anyway not required to prepare CFS because it is not holding company to anyone. It is only a subsidiary. So out of picture, consolidation for A. But XYZ the problem came. X prepared anyway consolidated statements of Y, Z and A. Y has to again prepare ZA. Z has to again prepare A. All these will be again prepared by X. Why all these nonsense? Anyway, if you take Y Limited, ultimate holding company prepared. If you take Z Limited, not being ultimate, the holding company prepared. Anyway, they are preparing now. Why you need to prepare one more time? Exception was given provided conditions are satisfied. Condition number 1, Y Limited or Z Limited should obtain their approval. No objection certificate from members. Means to the members you should first convince, or else members will question you. Why you are not giving? You tell duplication will happen. Okay, anyway, X Limited prepared it. So you can see there directly. Again and again, we need not prepare consolidated statements. So, company is a subsidiary company of another company and company has obtained no objection from the members. Company is not a listed or not applying for listing, means it's not a listed entity. Ultimate holding or intermediate holding means ZKH is a intermediate holding, X is a ultimate holding. So YK directly ultimate holding X prepare and file its consolidated statements as per AS. In that case, for your company, consolidated statements are not applicable. Everybody answer now, understood? Everyone? Okay, that's it. Okay, I am putting the full screen now. Pause it and see the entire answer. So let us continue. Next one. There are two other sections, 130 and 131. Okay, 130 and 131. There are two other sections. First one, reopening of books of accounts, section number 130. Okay, reopening of books of accounts. So, fastly I will go into this. Please listen carefully once. Okay, first one. First one, see here. Concept dealt. Reopening of books of accounts and re-preparation of financial statements. Recasting means re-preparing the financial statement. Reopening of books means what? Books are already closed, next year open. Now you are changing the old one. How much danger it is? Everything will change now. So when possible, it possible only in two cases. If the earlier accounts are prepared in fraudulent manner, fraud is involved, or books are not prepared in fraud, but earlier years your company is involved in mismanagement. When board of directors involved in mismanagement, now first doubt I will get on what? Preparation of books. Therefore, we are reopening. Either government is confident that you have done the fraud, or you may have done, you may not have done. I don't know. But mismanagement is there in the management. Therefore, there is every chance, since books of accounts and financial statements are prepared by management. Now I have a doubt on financial statement. As it is, you have to write these 2 points in exam if section comes on 130. So if the earlier accounts are prepared on a fraudulent manner, or the affairs of the company were mismanaged in earlier years, casting a doubt on its reliability of financial statements. Next one. Reopening at whose instance? Means what? Directly court will reopen. Directly company will reopen. No. Company cannot voluntarily reopen. Reopening at whose complaint? Request may be made by any of the person. CG and MCA. SEBI in case of listed companies. IT, Income Tax Department, or any other regulatory body like IRDI, RBI. For specified companies, they can also apply. So tell me, who will request to reopen? CG, SEBI, IT, any other regulatory authority. Application to whom? To any competent court or a tribunal. To any competent court or tribunal. Tribunal means what? NCLT. They will make an application. Duty of NCLT. Once court, once a CG or SEBI or IT or any other regulatory authority requesting the NCLT, please ask that company to reopen or give us a power to reopen, means directly they will not. NCLT will now send application to the remaining people. For example, if application request to reopen comes from CG to NCLT, NCLT will send that copy of request to remaining three people, SEBI, IT and other regulatory body. If received from SEBI, CG, IT, other regulatory body. If received from IT, CG, SEBI and regulatory body. If received from regulatory body, CG, SEBI and IT. Tribunal shall give a notice to CG or SEBI or IT or any other regulatory body and consider their representations. Means their objections and suggestions also consider. Nature of order. Order of tribunal shall be final. Means no other appeal can be filed against it. Next one. Okay. Just a minute. Yeah, all the points are completed. Now please answer 130 section. 130 section. First, who can, 130 section. Concept dealt. Reopening of books, recasting of financials. Okay. When possible, if the earlier accounts are prepared in fraudulent manner or affairs of the company were mismanaged and now casting a doubt on the reliability of its financial statements. Number 2. Reopening at whose instance? Request can be made by CG, SEBI, IT or any other regulatory body to competent court or tribunal. Tribunal will give notice to the remaining people and then it will order to reopen. But how many years I can go back? Scope of reopening. Books of accounts relating to 8 financial years immediately preceding the current financial year is only permitted unless a longer period is ordered by CG. If books of accounts generally should be preserved for how many years? 8 years. If CG say maintain for 10 years, means you should maintain for 10. Same. If CG asks you to maintain for 10 years, reopening also can be for 10 years. If CG said 8 years, nothing is said na, 8 years you can go for back and reopen the books. Okay, next. So now we completed reopening of books of accounts. Next one, revision of financial statements. Sir, what is the revision of financial statement? Revision of financial statements means we are not reopening. Only certain places we failed to follow accounting standard by mistake. For example, depreciation has to be provided at the rate of 10%. I provided by mistake at 15%. I wanted to do only that revision. Then reopening will not occur, revision will happen. But sometimes revision can lead to reopening as well. That's why how beautifully provisions are drafted. Let us see. Who can apply? Board of Directors can apply. To whom? NCLT. For what? Voluntary revision of financial statements or board report. When to apply? If company do not comply with 129 accounting standards or 134 preparation of board's report, duty of tribunal, it shall give a notice of application to CGR IT. Means what? When you are asking, for example, I will tell you, depreciation should be claimed at 10%. They claimed at 20%. Okay, income tax rate 15%. Okay, income tax rate 15%. The problem here that comes is, sir, income tax anyway we will disallow this and we will allow that, na, sir. But the problem is, if it is the mistake as per Companies Act, na, the profit what you take for income tax is as per the books only. That also will become wrong. Therefore, whenever financial statements any mistake is identified by company voluntarily, no fraud, voluntarily company has said by mistake we have presented like this, but tribunal will not do directly. Tribunal will send the notice of application by company for voluntary revision to income tax department and the central government as well, MCA, such that income tax department, if there is any tax impact on this revision, they will take care. Reporting impact on that, MCA will take care. So therefore, see here, it shall give a notice of application to CGR IT for their representation. Okay, scope of revision. There, scope of revision, how many years? 8 years I can go back. But here there will be different concept. Listen carefully. Time limits the scope. Revision can be made with respect to financial statements or board report of 3 preceding financial years. Means what? You are in 25-26 year. You can revise 24-25, 23-24, 22-23. But any 1 year only you can do now. Okay. So it can be done only 1 financial year. So you can go back and ask a revision for 3 financial years, but revision can be done only once in this year. Next one. Contents of revision. If financial statements are sent to members or filed with ROC or approved by AGM, means what? Already ROC also approved that financials and we filed. Members approved in AGM. Now you cannot do revision of financial statements unlimited. You can only revise. The revision shall be confined, means limited to correction in relation to financial statements of previous financial year and any consequential alteration. What does it mean? For example, we failed to put depreciation on a particular asset. Now put the depreciation, recast the financial statements. When you prepare the books of accounts by putting depreciation, consequentially what also will be changed? Fixed assets in the balance sheet, gross block value also will change. Net block value will change. Because depreciation not provided, now you will provide. Value in the assets side will reduce. Correct or not? P&L account depreciation also will increase. These are all called as a consequential alterations. On one of the asset, I forgot to put depreciation this year. Now I will put, because of these 3 changes. Number 1, depreciation amount will change. P&L profit will change. Balance sheet assets will change. That's it. Only these 3. So no sir, we wanted to apply another accounting standard. We wanted to make a better presentation. Let me change entire financials. Not possible, because you have already sent your financials to members, or you filed with ROC, or it is approved by AGM. Your revision should be confined only to the extent of mistakes committed, correct them. Any consequential corrections are required, make them. Unlimited I will not give. Okay, this is a point. For your understanding sake, for exams, 130, 131 I have written differences. See, concept, reopening of books and recasting financials. Here, revision of financials or board report also. Whose instance? Complaint can be made by CG, SEBI, IT, any regulator authority or any other body. But here, board of directors. When fraudulent accounts and mismanagement, here non-compliance with 129 and 134, period. 8 financial years here, 3. Fraud, mandatory here, maybe there, may not be there. Authority giving order, competent court here, NCLT only. Everybody answer? Understood the points clearly? Read this. Pause it, read. Next one is board's report. A board's report, there are two parts of discussion. This is part A. Part B I have given here. Part B, why I am giving here is, I will tell you, this is covered in audit actually. Okay, I am not going to cover that. Okay, that you have to prepare on your own. If you want, I will put a chart to take a photo, later you read. But this is mainly covered in audit. That's why I am not covering this. What is mainly relevant for law, preparation of board's report is there, that I will be covering here now. Okay, board report. First concept is signing. Okay, signing. What is this signing concept? Let us see. Preparation of financial statements is the responsibility of board of directors. Signing. In case of one-person company, one director will sign. In case of any other company, procedure is as under. Step 1. First, prepare financial statement and consolidated financial statement. Okay. Second, some problem is there. Preparation of financial statements and consolidated financial statements. Approval by the board of directors at a board meeting. Okay. So, financial statement should be first prepared along with CFS. Next, board of directors will approve at a board meeting. Next one is the signing. Okay. In case of any other company, one person company, one director. But who will sign in case of any other company? Situation 1. Chairperson is appointed and is authorized to sign. Then chairperson will sign. Sir, chairperson is not appointed or appointed but not authorized. In such case, step 1. Company has an MD, then one director and MD. Company has no MD, at least 2 directors will sign. Okay, if company appointed CEO, CFO, CS, those people also will appoint. Sir, only CEO, sir, but I don't have CFO and CS, then that question will not come. Companies which are required to appoint CEO are mandatorily required also to appoint CFO and CS. That's why they kept it as a sentence. So CEO, CFO and CS, if company is mandatorily required to appoint. So how to understand the signing of financials? If chairperson is appointed and authorized, if chairperson is appointed and authorized, okay, then chairperson will sign. If chairperson is not appointed or appointed but not authorized, in such case, step 1, MD will sign. If company has an MD. If company do not have an MD, 2 directors will sign. Also by CEO, CFO and CS, if appointed. Okay, completed. Next. Sir, next one is a board's report. Next one is what report here? Board report. Sir, how to understand the board report? Who will sign the board report? Question will arise now. See here. Same concept here. Board report to financial statement signing is almost same. But concept we should know application of common sense. Board's report means board persons only will sign. CEO, CFO, CS are not board persons. They are one level below the board of directors. Therefore, they will not come. Remaining everything is same. That's how you have to remember the provisions. One-person company can prepare abridged board report. Next, board report shall contain explanation by the board of directors on auditor's qualification, reservation, and adverse remark or disclaimer comments. Auditor's report can be a 4. Okay, in that 4, 3 things are very important. Qualified opinion, adverse opinion, disclaimer. Whenever auditor makes a qualification or remark or adverse thing or a disclaimer, okay, adverse thing or disclaimer, something like that if you do, adverse remark or something like that if they give adverse remark or if they give disclaimer opinion or if they give qualified opinion, in such cases, if they give qualified opinion or a disclaimer opinion, something like that, okay, Board of directors have a responsibility. Board of directors have a responsibility. Responsibility to do what? Responsibility to comment on the comments made by the auditor. Okay, comments made by the auditor. I repeat again. Board of directors have responsibility to give explanation on the comments made by the auditor. Okay. Done. Next one. Signing. Who will sign? One director. It's all one person company case. No, sir, mine is not a one person company, mine is a normal private public company. If chairperson appointed and authorized, he will. Other cases, two directors in that one shall be MD. If MD not there, two directors will sign. Okay. Every copy of financial statement shall be circulated along with explanatory notes, audit report, and board report. Okay. CEO, CFO, CS will not sign on board report because they are not board members. Everybody understood this concept clearly? See here. Circulation of financial statements. When you see the chart itself, it's very, very big. Section is also like that. Extremely complicated section in this chapter. Okay, listen. There are two sections now. 130 is actually 136. By mistake, they printed 36. 136. Okay, 136 read with the rule. Circulation of financial statements. Okay. So after that, NFRA, I will leave it for you to read. Just it's a basic general provision only. CSR again important for exam. Next, internal audit. Director is already I said now audit you have to read the circulation of financials. That's it. With this, the chapter will get completed. Or I will do one thing. First, I will cover small aspects and close. Okay. First, internal audit. Let us see. Internal audit. See. Which companies are required to appoint internal auditor? Listed company, unlisted public company, and private company. Unlisted public company and private company, when I will give you easy way to remember this. Okay. See. D, P, B, T. D, P, B, T are four keywords. Okay. In life, one thing which I never follow is putting mnemonics. Okay. And these are not mnemonics. These are points to remember. What is D represents a deposit. P represents paid up capital. B is representing borrowings. T is representing turnover. For you to understand. Okay. Deposits 25. Paid up 25 into 2, 50. Borrowings 50 into 200. Turnover 100 into 2, 200. If you remember DPBT and 25, that's it, over. So, when companies are required to have internal auditor, unlisted public company, number one, deposits 25 crore, paid up capital 50 crore, outstanding loans exceeding 100. These are all 50 or more, this is exceeding 100, and turnover 200 or more. That's it, 25, 50, 100, 200. Okay, if it is a private company, private company cannot accept deposits from public, so score out. Private company do not have big paid up capital, so score out. Turnover 200, outstanding loans 100 exceeding is applicable for private company. Answer over. Everybody, do you understand or not? Okay. Next, other provisions. Internal auditor may be either an individual or internal auditor may be either a partnership, body, corporate, anyone. Audit committee or board of directors in consultation with the internal auditor shall formulate scope and function. Means how internal control systems or what is the scope of your internal audit, financial, non-financial, sales, whatever the internal audit is, they will decide. Audit committee or board. Most important one is internal auditor shall be either a CA, CMA or such other professional. Any finance related professional can be there, whether engaged in practice or not, as decided by board of directors. Also, internal auditor may or may not be an employee. May be an employee, may not be an employee. Stat auditor should not be an employee of the company. Internal auditor can be an employee of a company. Okay. So, this is the points relating to internal audit. Just 2 minutes will be completed. Everybody, please answer. Understood internal audit concept clearly? Okay. Next. Now we are left out with three very important concepts in this chapter. Circulation 136, and circulation 136, filing 137, CSR 135. Okay, CSR 135. Okay. Where is this section? 136. Okay. 136. Circulation of financial statements, and 136 read with rules. Listen carefully. Okay. From the beginning, I am putting it on full screen such that you can see and scale it, understand the concept. See here. Everyone first reply before we start. 136, a full chart. Is it visible on the screen to you? Okay. Now let us see. 136 section is one of the most important sections of this chapter. 136, 137, 135, the heart of accounts of company chapter. Okay. Let us first see what is this. Circulation of financial statements. Basic obligation. Every company should circulate financial statements, not just financial statements. Nature of obligation. Circulate financial statement, consolidated financial statement, auditor's report, and all other documents which are required to be annexed or attached. How many days? Along with the notice we will send, therefore not less than 21 days before the general meeting. Okay, start. What is the basic obligation of this section? Every company shall circulate financial statement, consolidated financial statement, auditor's report, board report, all other documents. Okay. How many days before? 21 days before the general meeting, it should circulate. Now question, circulate to whom? Every member, okay, every debenture trustee, and any person entitled. Person entitled, who will come? Auditors, directors, all these will come under person entitled. It will circulate financial. Sir, I can give shorter notice to a general meeting. Like that, can I give a shorter circulation? Yes. You should comply with a special provision. Shorter circulation. If company having share capital, 3 conditions should be satisfied. Majority members. What do you mean majority members? 1000 members are there. Majority means 501. So head count 501. Don't write 501 members in exam. Example I am telling. So majority members, okay, who are entitled to vote. What do you mean by entitled to vote? There is a section in General Meeting chapter called as section number 106, restriction on voting right. If a member is not paying a calls properly, if a member is not paying calls properly, or if the shares of the person member are in lien and articles provide for restriction, then they can stop their voting rights. So you should not be such person. So majority members entitled to vote and obtain the approval of members holding not less than 95% of the paid up share capital. In case of such approval, yes, you can go for shorter circulation also. Means less than 21, 17 days before, 18 days before also you can circulate financials. So normal provision is what? Circulate within 21 days. Circulate within 21 days. But sometimes a shorter circulation may be asked. In that case, there are 3 conditions. Majority members should apply, okay, should approve, and those majority members should hold 95% of capital, and they should be entitled to vote. They shall agree. If they agree, you can go for a shorter circulation. Next one, not having share capital, not less than 95% of voting power. Next, circulation mode. Private company. Private company will circulate financial statements and other documents only in physical form. E-form allowed only for authorized by articles. Means what? Email, etc. Private company hardly members say 200 maximum. 99% of the cases they won't even cross 10 to 12. Then circulate it physically directly. However, if your company is a public limited company and if it is a listed public company, there is a special provision. Circulate. See, listed public company financial statements, if you see, it will come to around 1000-2000 pages because they will have subsidiaries. Consolidated statements also you have to circulate. It will become a big document. Therefore, don't circulate full financials. Circulate salient features statement in AOC 3 or 3A. Sir, already salient features there. Adi preparation of financial statements ki AOC 1. It is circulation format. AOC 3 or 3A. Okay, 3 for your company, 3A for consolidation. And make the copies available for inspection for 21 days before the GM. 21 days before the GM. So summarize. Mine is first one. I am going to circulate financial statements. I am a public company. I am a listed public company. I am a listed public company. Or I am a unlisted public company having a net worth more than 1 crore and turnover more than 10 crore. Net worth more than 1 crore and turnover more than 10 crore. I am a listed company or unlisted company having a net worth of more than 10 crore and turnover more than, net worth more than 1 crore and turnover more than 10 crore. In such a case, special provision will apply also to me. Okay, special provisions will apply also to me. What is the special provision? Circulate the salient features document. See, net worth 1 crore, more than 1 crore and turnover more than 10 crores. Special provision is only for listed company. Listed company need not prepare full financials. Salient features document it can circulate. Okay, so salient features means you will not send the full financials. No. So then where I can find full financials? That's why we will make the full financials copies available for inspection for 21 days before the GM. Okay, next. Provision applicable for both listed and specified unlisted. Okay, now this and this it will be applicable. Documents under this section can be circulated as under. Mine is which company? Listed or specified unlisted. Let us say mine is a listed company. Listed company means my details are already with the depository. Okay, therefore shares are in demat form and email is registered with depository. Circulate the financials in electronic form. First thing, listed company anyway will not send full financials. It will send only salient. A salient also you can send it in e-form if you are a listed company. Okay, your shares are dematted and email is registered. No, sir, mine is an unlisted company, but I dematted my stocks and emails are taken. Then for you also same condition. No, sir, mine is an unlisted company and non-dematted, but shareholders voluntarily saying that they gave emails and they asked me send to email. In that case also you can send. So shareholder consented. In all other cases, circulate in physical form. From this, what you understand? Listed companies never circulate in physical form. And listed companies never circulate full financials also. Unlisted companies have to furnish full financial salient features document does not apply to unlisted. It is applicable only to whom? Listed. Okay. It is circulation mode. Other points. Member and debenture trustee can inspect all documents mentioned in this section during business hours at registered office. Need not be 21 days before. Anytime they can go for inspection. Members can request copies of separate audited financial statements of subsidiaries. See, subsidiary key you will prepare CFS. But that subsidiary will prepare their own financials now, audited. That also I wanted to see. You can inspect. Next one. Special provisions applicable for listed company with respect to placing of financial statements on website. Okay. Now listen. Special provisions applicable for listed company itself, subsidiaries. Okay. See here, subsidiaries. Circulation only in physical form. Next. Financial statement, consolidated financial statements, auditor's report, and all other documents must be placed on company website. What is this report? Audited report. Means what is this statement? Audited financial statement. Okay. Audited financial statement. See, my company is preparing its financial statement. Along with audited. Along with that, I will prepare consolidated financial statements audited of my subsidiaries. Both of them place it on my website. This is the first rule. Next. CFS la you will find full details of subsidiaries are only consolidated part are consolidated. No. I want you have X Limited. X Limited has A Limited, B Limited, C Limited as subsidiary. Okay. You will consolidate and put it with X Limited. That's called a CFS. I don't just want that. I want separate audited financial statements of A, B, C. That also you should put on your website. Sometimes this B is a subsidiary located in, say example, Mauritius. As per the rule of Mauritius code, Companies Act is called as a Companies Mauritius Code. As per Mauritius code of Companies Act in that country, audit is not mandatory. Therefore, B Limited did not get its audit report, did not get their finance statements audited. But our Companies Act says that separate audited statement should be attached. Okay, but B Limited need not get it audited. Now what to do? You can put on website financial statements of B Limited which are unaudited. Other exception. So, with respect to subsidiaries also, place separate audited statements of each subsidiary on website. Exception. No requirement of separate financial statement of subsidiary if it is a foreign subsidiary and prepare CFS for its subsidiaries as per the law, and it must follow its own law. And no requirement of audit. Indian holding company can place audited financial statements of its foreign subsidiary if the audit is not required as per its own law. Okay, this is all about section number 136. Everybody, did you all understand the concept clearly? Read the concept here. It will come in exam. Because of its complex nature, they will ask in exam. Max 5 minutes we will spend on this section. Very easy. Listen. Stages you observe. First, financial statements are prepared, 129. Next, those are signed, 134. Next, those are circulated to members for their approval, 136. Now we are filing with ROC, 137. Did you understand the sequence clearly? Everyone. Okay. So, first we will prepare the financial statements under 129 section. Next we will put it for signing under 134 section. Next we will circulate to members for their approval in AGM, 136 section. Next we are filing the same with the ROC, 137. Everyone understood the sequence clearly? Yeah? Okay. So now listen. What they say is, listen first, after that you can read 1 minute concept here correctly if you speak. See, whenever AGM has to be conducted, AGM has a time limits under section 96. When we come to general meetings, I will tell. Okay. So what is said in section number 96? There are 3 dates. Okay. Those 3 dates, whichever is earlier, will be the last date for conducting AGM. Generally, the date will come to 30th September. Okay. That date is called as last date on which AGM should have been held. Okay. 30th September, 99 out of 100 companies ki 30th September will become the last date for holding the AGM. Okay. If you hold, very good. If you do not hold, that will be the last date on which AGM should have been held. Okay. Let's understand this. See here. Lawmaker said like this. Whenever you wanted to file your financial statements, first conduct AGM and get it approved. Unapproved financial statements, unaudited financial statements, you should not file it with ROC. Unapproved also you can file, but only in one exceptional case I will discuss today now, in this case, in this section. So listen properly first. Point number 1. Company has to file its financial statement, consolidated financial statement, auditor's report, board report, all other documents which are required to be annexed or attached with the ROC within 30 days. Within how many days? Within 30 days. Okay, within 30 days of AGM date. If AGM date is conducted today, from today 30 days, you have to file your financial statements with ROC. Number 1. Okay, so if I conduct AGM and get my financial statements approved by the members, then you will file within 30 days of AGM. Perfect. Clarity. Second case. My company is there. Conducted AGM. Sorry, first audited. Audited after it went for general meeting for approval of members. Members did not approve because auditors have given a disclaimer opinion. Okay, auditor has given a disclaimer opinion. Member said that in disclaimer opinion we won't accept anything. They did not approve. Now answer my question. Lack of information, because of that reason auditor gave a disclaimer. Since company did not provide any information to the auditors, On that mind basis, shareholders did not approve the financials in the AGM. Now AGM conducted but not approved. So AGM will be stopped and it will be adjourned. Correct? So from the date of original meeting, whenever you conducted, where the accounts are not approved, from there within 30 days, again you have to file your financial statements with ROC within 30 days, but file them as provisional financial statement, not as approved. Provisional. Now you will conduct audit. Now you will again resend to auditor, send it, give proper records and data to him, and get a opinion, either unqualified or qualified or adverse, not disclaimer again. So these opinions will come. Now again put it in the AGM. Again put it in the AGM. AGM la adjourned AGM will be conducted. There you put it. Adjourned AGM la if they approve na, from adjourned AGM again 30 days you have to file approved financial statements again with the ROC, because previously we filed provisional only. Okay. Next, Sarasli, AGM not held, sir. Then if AGM is not held, all the documents, okay, financial statements along with all the documents should be filed with ROC. Mention the reason for not holding the AGM. Okay. In all these three cases, commonly one point is there. The document which you need to file, financial statements prepared according with Schedule 3, will be filed in Form AOC 4.